Konuche. Lady Anna Konuche, can you hear me?
Yes, I can hear you.
Thank you. Our candidates who are online, please note physically present with us at the venue. We have Christine Kepsang.
Good afternoon.
Good afternoon, all. We have
Good afternoon.
Madam Jacqueline Ngutia.
Present. Am I audible?
I stand corrected on the titles. Also present with us, Lady Julie Soweto, or I can use Madame Soweto. I stand guided.
Oui, je suis madame. I am present.
Thank you. We will use this session very briefly to just take the contestants through a brief ground rules of what to expect in the debate. And I hope the candidates who are online can hear me. If you can't hear me, kindly communicate. The debate will include questions from the moderators. They will be joined by the audience that is present. And we'll also take questions from online audience, which will be relayed through the moderators. Time limits on statements, answers, rebuttals, responses will be enforced by the moderators during the debate. And the moderators will indicate the time that will be allocated for the particular questions at the time the question will be posed to the candidates. Candidates will remain in their positions. No participant may touch any other participant during the debate.
I can't have them.
During the debate, just listen to the rules. During the debate, after you can hug, you can kiss. You wait to be recognized by the moderator before speaking. You will not interrupt or talk over someone else who is speaking. You will listen for content. In the statements, and if something is not clear, you will seek clarification. You may not make demeaning or inappropriate comments, facial expressions, no eye rolling when another candidate is speaking. You will be given an opportunity to make opening statements and introduce yourself. Thereafter, the moderators will proceed to address all questions to the candidate. Can I get a confirmation that that is clear for all the candidates? Or any clarification or comments, please? Yes, Christine?
Thank you, moderator. I have two questions. The first one, it relates to the questions by the moderators. How many are they? And the second point is on the debate itself for this JSC segment. How long is it? Thank you.
The questions, like I've said, they are questions by the moderators. They are questions by the gallery that is present, and we'll also be receiving online questions from the members who have joined online. The questions from the moderators will be 8. The members who will be present when the debate is being conducted will be able to take at least 6 questions from the members of the audience that will be present with us. From the online platform, depending on the questions that will be coming in, we will. I may not comment now, as I may not predict how many questions will come in. Our time for this debate will be 2 hours strictly. And the 2 hours, like I've stated, will be divided: introduction, moderators, gallery. Then we'll have an opportunity to have closing remarks from each candidate. Any other question? Members who are candidates who are online, any other question that you may have? Candidates who are online, do you have any question, concern, clarification? No. Thank you, Jen. Madam Anna?
Yes, I have a question.
Please proceed.
I'd like to know whether there is a crossfire section.
Yes, there is.
Okay, thank you.
Lady Aoko Otieno? Any question, concern, clarification?
No, I don't have any at the moment.
Thank you. Yes, Christine?
Thank you, moderator. I have one more question. You have said the debate is going to take 2 hours. Are we going to stand for 2 hours? And maybe our colleagues are seated wherever they are online. Thank you.
Thank you. The setup, we have, you may want to get as comfortable as possible. The setup, the way it has been done, we have media that is covering, and we needed to be able to project the candidates. But we can perhaps get chairs. Any other clarification, concern?
Yes.
Thank you, moderator. I have one more. Are we using our phones or they should be away from us?
Mine is off, it's here, but it's off. What does it matter? What does it matter?
We can agree that we may not use any type of technology during the debate, and you can have, I think we've requested the hotel to provide a writing pad and a pen.
I'd like to retain mine. I have my notes, I have my papers, okay. Is it okay if I retake them? Also,
Remember, you have a session particularly for introduction, for what you want to do. So that part of preparation, you are allowed to have that. The candidates who are appearing virtually, your video should be on at all times. The candidates who are appearing virtually, please enable your video to be on. Thank you, Lady Aoko Otieno. Thank you, Madam Jen Nyaboke. Mwalimu Anna Konuche, kindly enable your video. I can see all the candidates. Thank you so much. We will begin right away. We were to begin this exercise at 2:30. It is 3 p.m. I will proceed and invite the chair of the West Kenya branch to do a small introduction so that we can begin our debate right away. Thank you so much.
Madam Chair, if you'd allow me to share a podium of Kim-san, we are not a canvassing. Good afternoon, everyone. I wish to take this opportunity to welcome all of us to the Law Society of Kenya West Kenya branch presidential debate. We call it presidential, but we are having contestants for two positions. That is for the Judicial Service Commission and for the post of the president. So this particular time, we will start with the members or contestants for the seat of the Judicial Service Commission. We have 3 present, and as you've seen, we have others who are present virtually. And we also have members appearing virtually and physically. But before we take off, I would like us to run through some preliminaries. I would request one of us to pray for us kindly. Lead us in prayer so that we have the mercies of God. Thank you.
Good afternoon, honorable members.
Good afternoon.
My name is Elvira. I would like us to order in prayer. Our Heavenly Father, we come to you with thanksgiving in our hearts for enabling us up to this day. We want to commit this debate into your able hands. We pray for your anointing upon the best leader in our midst, Lord Jehovah. Give us wisdom, knowledge, and understanding. We thank you and we love you. In Jesus' name we pray. Amen. Thank you.
Thank you very much, Council Elvira Welunda. I would request all of us to be upstanding for the national anthem. BJ, please. We'll start with the Kenya national anthem, followed by the East African anthem. Africa. Thank you. They're requesting me that we proceed. We sing the East Africa spiritually. So you can take your seat and allow us to proceed. So I want to quickly take this opportunity to welcome all of us who are here present and virtually again, and also to our candidates who heeded to our call to come and be presented before the members for scrutiny. It is not an easy task to avail yourself and to be criticized by members, the very members that you're seeking for their votes. So we are very grateful, the JSC candidates and the presidential candidates who are present and are around. I think we have all the presidential candidates present. We'll be calling them forward much later. They came in not so long ago, and they're very tired and hungry and sleepy. We've allowed them a moment to go get water and come back. I also take this opportunity to thank our moderators for accepting our call to come and moderate this session. It is not an easy task, and we were so much impressed by Senior David Otieno when he quickly accepted the call and even quickly accepted to lead the other moderators. He's a very senior advocate, experience. He's a partner, senior partner at Otieno Ragot, and he's an ardent footballer. He plays for a team that it's always difficult for me to mention the name. Please, I'm not going to explain the meaning of that, but I'm also informed he's the captain, he's the goalkeeper, the forward, and the defender. So he takes up all the roles and executes them very well. Thank you very much, Bwana David. Karibu sana. We have Dorothea Kinyi. We know her as Dory. Is it Doro or Dory? Dory. Dory is a senior advocate of 13 years experience. She's also based in Kisumu, just like Dave Otieno. She's a senior partner at Stausi, Asuma and Lodge Advocates. She'll also be taking us through the session. Smile, don't be fooled by that smile. Be very prepared for the questions that are going to come from her. And with us on the fine is Ms. Odek. Ms. Odek is the chairperson, Kakamega chapter. The branch is divided into chapters, or rather devolved into chapters. And one of the chapters is Kakamega chapter. So we have one of the chairs as our moderator. Odek is equally a very experienced advocate of 12 years experience, with a lot of experience in debates, and most of presidential debates. Small-bodied, yes, but be ready for what is going to come from her. She's a senior partner at Samba Odek Mulama Advocates. Apart from the moderators, we also have other people that are going to help us run the process. We have the screen monitors for the members who will be appearing virtually. We also have some monitors in charge of the ground, we're calling them ground managers, and we also have a timekeeper. You remember we mentioned timekeeping in the rules. We have a very firm timekeeper. If he doesn't allow you to go beyond a second, kindly oblige. So thank you very much, our moderators and the other people who are going to help us run the session. This is the main presidential debate. Of course, again, as I mentioned, we have also the JSC. And we would have loved to have all the other members, the other contestants on board. I see many of them are present, but kindly allow us, we may not be able to do so because of time constraints. But a time will come, we are going to recognize you. So don't feel left out. Asanteni sana, I can see most of them smiling. I also want to say that this is the most competitive election in the history of the Law Society of Kenya. I think all of us can associate and resonate with that. We have very many candidates for various positions and posts. All of them are very able and capable. And it's even difficult for the voters to choose as to who to vote for and who not to vote for. Because they come talk to you and you're like, this is the best. You wait for the next, and then you get carried away. So we've given our members the opportunity and the platform to engage the candidates and be able to see and get the best out of the best. And at this opportunity and juncture, without taking much time, allow me to open this debate and hand over the program to the moderators. Thank you very much.
I do not know whether we can just proceed while seated or we need to stand, but I think whichever way I believe.
The assistants get the chairs for the candidates.
If that comes, I think we can just proceed. I think this is strong enough to remain.
She has a problem with the AC, so I'm saying to
Okay, thank you.
change
That is how to treat a guest here.
Yes.
Thanks. First of all, without having to restate what the chair of West Kenya said, I want to welcome you all to this debate. We are not going to ask you things that are out of the ordinary. These are things that I think you know about, you will have heard of them. And by the time you made the decision to run for this high office of women rep in the JSC, I'm sure you thought through these things. You went through what you were. You went through what is expected of you as a representative in JSC, and I'm sure you know your role. Now, I think my question will go to all the panelists or all the candidates present. We will start with those who are in the room. Yes, thank you very much. I'm reminded that before we go to the questions proper, and I think I had thought that the chair of the branch would probably have done this. Now that I'm the one with the mic, we want to give each of the candidates an opportunity to tell us about themselves, introduce themselves to us and to the members who are online, about who you are, why you have decided to run for this office, and generally what your vision is as the LSK rep in the JSC. I will start with you, Jacqueline.
Thank you, Senior. Colleagues, good afternoon. My name is Jacqueline Ngutia. I work with the Kenya National Commission on Human Rights as a regional coordinator. At the Commission, I'm engaged in litigation, majorly public interest litigation, and I've done policy and legislative advisory to both county and national government. At the same time, undertake monitoring of states' compliance with its international human rights obligations. I have served LSK in different capacities. I have offered trainings in a number of CPDs. I have served as a vice chair of the branch, at the same time being a pupil master to a number of lawyers. I have given guest lectures in universities, and I believe I'm the best person to represent you to the Judicial Service Commission because my interaction with the judiciary is threefold. One, I litigate before different courts, so I have real experience as those of litigating counsels. I also consider myself a hybrid lawyer because I am an in-house counsel. I undertake litigation at the same time, do advisory within the institution. I have sat in a number of court users committee. I'm able to understand the challenges within which other justice actors are faced with when it comes to administration of justice, which the JSC ought to address. My agenda is as a result of my personal experience. My agenda is as a result of my interaction with members, and it's threefold. One, I want members of the Law Society to engage the Judicial Service Commission beyond looking for jobs, beyond raising complaints, because the JSC has a lot to offer. We have the strategic plan, we have regulations that have been adopted, but very minimal interaction with the interaction of members with the Judicial Service Commission. Number two is on independence and accountability of the judiciary. We have seen increased cases. We have seen increased cases of disobedience of court orders. We have seen an overlap judiciary and JSC, yet the JSC Judicial Service Commission distinct institutions, but we have overlapping mandates. Unless we have clarity of functions, we will continue to find ourselves in the challenges that we are faced with. Thirdly is on the issue of service delivery. If courts were closed, lawyers would not have an opportunity to get our bread and butter. The best the JSC can do is to improve service delivery, have more courts across the country. Tendering process must be available to all lawyers, not just select few. We have seen a number of cases at mostly in Nairobi, and only select few. So I believe I'm the best candidate to represent you, and thank you so much for having me here, because my service to you will be responsive. Thank you.
Thank you, Jackie. I had assumed that you had been advised about the time.
Oh.
But yeah, it was supposed to be 2 minutes. You have taken about 3 stages. We will give each of the candidates 3 minutes.
Can we get to know the alert? I had something and I was not so sure whether that was.
Okay.
Yes.
That was
the
it.
bell. Okay.
That was actually
Thank
it.
you.
Yes. Thank you very much.
Okay.
So we'll give each of you 3 minutes. Thank you. Then we'll ask Ms. Julie Soweto to go.
Good afternoon, members. Good afternoon, distinguished members of the panel, learned colleagues. My name is Julie Soweto. I have been a practicing advocate for the last 18 years, seasoned, tried and tested, and with a record that speaks for itself. Why do I want to be the representative of the Law Society before the JSC? Number one, I have practiced before the JSC, and I have seen how unjust the JSC can be. We cannot allow that, and I want to do something about it. As a practicing advocate for the last 18 years, I understand what advocates go through in their work in courts. The JSC's mandate is only judicial processes and the administration of justice before the judiciary, which is something that I do on a day-to-day basis. And therefore, I understand what members go through, what members are suffering, and the challenges that need to be addressed. My platform as a representative of the LSK rests on 3 fundamentals. One is to be the clear voice of the bar. I say this because the bar has lost its voice. We have become a political tool for politicians and political interests, and members' interests are no longer being represented, even before the JSC. Secondly, is to safeguard the courts, which is what the JSC is about, as a workplace of the advocate, so that advocates can thrive and they can deliver on justice to their clients. And thirdly, is to safeguard the independence of the judiciary. When we have a clean judiciary, we are all able to work and deliver on our mandate, which is justice to all our clients. Thank you very much.
Thank you, Julie, for that opening statement. I'll then go to Christine. I'm told that the title of the issues here, but please bear with me. Thank you, Christine. You can proceed.
Senior advocates present, middle bar, young lawyers, moderators, members of the press, ICT team, my co-debaters, good afternoon. Good afternoon again.
Good afternoon.
How are you today? Good. I've been given 3 segments to introduce myself and why I need to go for this seat. The person in front of you was born in the mid-70s to a chicken vendor and a mason husband in Makueni, Kilili. You have seen my name is Christine Wikali Kipsang. My father used to tell me, Usiawane dosawa kwena musi. The feather of a rare bird is not collected near your homestead. And so I went to Alliance, having shocked the entire village. And when I went there, I was perplexed by flushing toilets. Were you in Form 1? Years later, in 1992, my father's cows died, all of them. Actually, the few that remained were too thin to be bought by anyone. So I was wondering whether I'd go to school. And when my community came together, 50 bob here, 500 here, and they took me to school, I was able to go to the assembly that morning, then the following term. Years later, I went to University of Nairobi, Parklands campus. Soon after, I was battling morning sickness and deadlines for assignments. Soon thereafter, I joined pupillage. You know how hard it is to get pupillage in this city, in this country. And I joined the bar. My journey for quests to fulfill the needs of justice of the disadvantaged started. I'm going to JSC to look at the issue of access to justice for all. Not only the advocates who are sending me there, the 20,000, the common Mwananchi, the Wanjiku, will know that there is a village girl who can speak for them. The second issue is judicial independence. We have failed to complain or get the issues of complaints resolved. As a mediator, arbitrator, I'm going to do it. Lastly, LSK members' welfare. Members' practice centers are shrinking, they are freezing, they are being condensed by the day. Please vote Christine Kipsang, and I'll be the voice. I'm an advocate for 21 years. Thank you.
Thank you very much, Christine, for that very elaborate introduction. Thank you again. I will go to Mrs. Jane Nyaboke Njagi. Council, I believe you can get me. Please proceed. It's your turn.
Good afternoon, members present. My name is Jane Nyaboke. I'm an advocate of the High Court. I've practiced all my life. So if you talk of who knows where it is, I am right here. The purpose of asking for this vote is because I want to ensure that the JSC is transparent, independent, and effective. I have served a lot of places where I have been privileged by the president. I've been a chairperson of Water Regulatory Board. I have been lead counsel in many commissions investigating corruption in this country. But what is important, members, right now is that I am seeking your vote because I want to ensure that the interests of the advocates are ahead of mine. I will be able to point out any ills that are in JSC. I'll make sure that there is gender equality and that there is access to justice. In other words, I'll be running after ensuring that there's rule of law. I've been a member of FIDA as well, making sure that I work hand in hand with FIDA, finding out all these abuses on our children and women of this country. I am ready to serve you. In my legal practice, I've also set a lot of precedents in cases of family law and insurance law. So I stand here this afternoon to ask for your vote. I shall stand tall for you without fear or favor. And I will repeat, where there is evil, I shall point it out without any fear. I ask for your vote. I've been in practice this long. Thank you.
Thank you very much, Senior. You made your presentation well within time. The next in the line will be Ms. Anna Konuche. Thank you. Right. Sorry, we can't hear you, Ms. Konuche. Something.
Sorry. Yes, can you hear me now?
Yes, we can hear you. Proceed.
All right. Thank you so much, Senior, for this opportunity to interact with colleagues from all over Kenya and to discuss my agenda in my candidature. By way of introduction, I work at the Kenya School of Law as the Assistant Director in charge of the Advocates Training Program, which is the largest core department at the school. I'm in charge of policy development, oversight, budget formulation, procurement, basically running the department. Previously, I have been in academia where I was teaching at the Moi University School of Law as well as the Kenyatta University School of Law. I also had a brief stint, 1.5 years as a corporation secretary at Sports Kenya and prosecution counsel for 1 year. I have a law firm. And we started it in 2018. So I come as a full package with a rich profile, both in management issues, leadership qualities, practice of law, academia, and corporate governance, which I essential in the membership of the Judicial Service Commission. Now, the way I understand the Judicial Service Commission, the mandate is, to my opinion, threefold. The first mandate, which we all know, is that one of human resource. It's actually a human resource powerhouse in that it hires, fires, disciplines, trains judicial officers. The other function, which I'm more interested in, of Judicial Service Commission, creating strategy on behalf of the judiciary, developing policies or approving policies, and as well as oversight function for the judiciary. Thirdly, it's just a forum for all stakeholders to participate in the affairs of the judiciary. Now, in terms of my vision for judicial service, based on my own experience, based on the experiences of others who I have worked with and talked to all over the country in the last 1 year, I would say that the most important and the most key area of priority is that of
recording in progress.
Is that of strengthening of the oversight function, because my argument on the strengthening of the oversight, I realize that most colleagues in practice and most colleagues all over the issues that face each station, each small community where there is practice of law, they have their own small issues. And these issues may or may not be raised to the Judicial Service Commission, and sometimes they're addressed and sometimes they are not addressed. And to this agenda, my proposal is that we have a quarterly system where the judiciary responds specifically to issues raised by the Law Society of Kenya, by the bar, so that if the Kisumu chapter or the Mombasa Law Society has an issue, maybe with a judicial officer, maybe with
did you hear the bell?
Court structure, they raise that issue either through me or directly to the judiciary, and within 3 months we have a report from the judiciary indicating that these are the issues we raised, itemized, and this is what we have done. It's a committee that has been formed.
It's that.
Sorry, I was muted.
Ms. Konuche,
so my proposal, yes?
Can you hear me? We had allocated each of you 3 minutes because as you will understand, we have another debate coming up, so we are not we don't have the luxury of so much time in our hands. So you are at 3 minutes. So basically, yes, and there's a bell here. I hope you can hear the bell.
I didn't hear the bell.
Okay, it's rung again just now. Just that must be a fourth reminder. But, yes.
All right. Okay, then
you'll have the opportunity to say a lot more about that. You'll also have a chance to make closing remarks, so you can spare the rest of what you have in mind for that occasion. Last but not least, Ms. Aoko Otieno, it is your turn to close this segment of the debate. Thank you. Ms. Otieno, can you hear me?
Yes, I can hear you.
Thank you. Proceed. You have 3 minutes.
Thank you. Good afternoon, colleagues. My name is Aoko Otieno, but most of you know me as Chol the Chol. I am an advocate of 20 years standing and in right standing with the society. I've never had any complaints that was registered against me. I'm a very active and passionate member of the LSK. I have done the full circle, having worked both in the public sector and the private sector. I started into a human rights lawyer, and next I joined the corporate world, and finally I settled into private practice. Why am I running for this position? I am running for this position because as practitioners, we need a strong, firm, and independent voice at the JSC so that the much needed change that we need can take place, and I am that voice. I have 2 agendas, which are actually the core mandate. Pardon?
Just proceed.
Pardon?
Proceed. That was a small mishap.
Okay, I have 2 agendas, which are actually the core mandate of the JSC as stated in the Constitution, Article 172, which is 1, to promote efficient and effective administration of justice, and 2, to promote independence and accountability of the judiciary. I stand out among the rest because, as I said, I'm a passionate and active member of LSK. If I'm elected, I will not run away for 5 years. You'll keep meeting me at the AGMs at the Justice Cup. Hope we'll have them this year. As I said, so I am independent, firm and strong. I do not come with any strings of political parties, close association with political parties, or members of political parties. I am self-driven, and I said I will bring my experience of 20 years and my passion at doing the work that I do. Thank you.
Thank you very much, Ms. Aoko Otieno. Just a small, there's just one little ground that we did highlight when my colleague set out the rules. In order that we do not catch you off guard when you're in the middle of responding to a question or making a presentation, we will be notifying you 10 seconds before your time will be up. So the bell will actually go 10 minutes, 10 seconds. Get into a situation where you feel you have left something important out. You can use the 10 seconds to wind up. Thank you very much. I think we are done with the with those candidates. Now, the first question that I would have for the candidates is that when you made the decision to run for this office, you understood, I believe, your role or responsibilities under Article 172 of the Constitution that creates the Commission. And one of the things that that requires you to do, one of the functions of the Commission, is to review and recommend conditions of service of judges and other than remuneration. That is important. Other than remuneration. So there is a whole lot of things out there that we know about.
Let somebody mute everybody there. There's a lot of interference. We can't hear.
Mr. Nsongo, I think that is you, if I'm not wrong. Okay, I think we'll continue. Now, so if we elect you into office, what would you recommend? Okay, apart from questions of remuneration, which is not within your mandate, as part of the conditions of service of judges and other judicial officers, to improve service delivery to consumers of justice, who include us as members of the Law Society and the public out there. What is it that you thought about that you think needs to be done, other than questions of remuneration, something which is not being done today? Something which you think is not being done currently to change the way judges and judicial officers offer their services to the Kenyan public. I will start with the candidates who are following us virtually or who are participating virtually. And I will start with Ms. Jane Nyaboke Jagi.
Thank you so much for that question. What I would recommend first and foremost is that we invest in technological infrastructure, training and guidelines, and ensure that every officer has at least a laptop so that the communication becomes easier, because I believe communication is the power into any solution to any problem.
Thank you. Thank you very much. I will then go to Ms. Anna Konuche. I believe you got the question. Yeah.
Having interacted, listen to some of their issues. I'll propose that first of all, we review the transfer policy so that it is fair to all, so that there are not people who are being transferred far away from their homes or from their families, and that it is done in a consistent and transparent manner. Secondly, we need a training calendar for judicial officers so that it is predictable when and when the courts are not sitting. Thirdly, there is need to redistribute judicial officers or the workforce across stations depending on the amount of work that the station has. That are workload, and the other stations are necessarily be. Thirdly, the conditions and the environment of work. Yesterday I was in Kericho. As you're aware, the Kericho North was condemned. So what has happened is that they've been put up in a temporary place, which was initially a residential homes, and how they are working, even their places of work, the kind of furniture they have, they are not very good. So I will recommend that we improve the infrastructure so that they have better and good condition of environment for working. And finally, in terms of performance contracting, I got feedback from the members of LSK that they would like to participate in performance contracting, evaluating the work of the judicial officers, because currently they evaluate themselves, and members feel that sometimes maybe that is not objective. And so we would like participation by other stakeholders who are not necessarily members of the judiciary in the evaluation of the work of the judicial officer. Thank you very much.
Thank you very much, Council. Ms. Aokotieno, you can get us?
Yes, I can, but I would just like you, my senior, to repeat the question.
Okay. My question was that under Article 172 of the Constitution, one of the functions of the JSC is to recommend conditions of service of judges and other judicial officers other than questions to do with remuneration. And my question was, what do you intend to do if we elect you to recommend the working conditions by judges to improve the delivery of those services to members of the society, that is the LSK, as well as members of the public? What is it you would want to propose if you get a seat in that commission, other than questions of remuneration, which by law you are not allowed to deal with?
Thank you, Senior, for repeating the question. Well, I would make recommendation that will improve the physical capacity, that's infrastructure, with the human capacity and the systems capacity. So for the human capacity, I would make recommendations that we have a manageable caseload for all judicial officers. I do not see why Court of Appeal has like about 6 matches in a day, but a magistrate in minimally commercial court has about 40 to 42 cases in a day. So I would recommend that we give all judicial officers a manageable caseload for each day. Secondly, I would recommend that the number of magistrates be increased and their support staff too. This is because if you're giving one magistrate per day 50 cases or 48, that means that they are few in number. And if we overload the magistrates, then we cannot expect any efficient and effective service from them. Actually, if you give them that 50 cases in a day, more often than not, maybe only 4 will be had and the rest will be given other things. So if the numbers are increased, then we can give them a uniform and manageable caseload per day. I would also, still on the magistrates, I dwell on the magistrates because 81% of the caseload of judiciary lies in the magistrates' courts. Therefore, if we get it right there, this is something that was said also by the Chief Justice a few weeks ago, if we get it right at the magistrates' court, then we shall have enhanced access to justice. So I would also recommend that, not the remuneration, but something to do with their allowances. You find that for the last 10 years, we've been pushing work down from the high courts to the magistrates' courts, from succession matters to divorce matters, to employment and to land. So you find what the judge was handling 10 years ago, right now a chief magistrate is handling. The judge takes home other perks apart from his salary. Why shouldn't we give the same perks to the chief magistrate who was earning, who is now handling matters that were previously being handled by a judge? For instance, a judge has a researcher
Mr. Sino, did you? I hope you've heard the bell. We just want to confirm that you can get the bell from where.
I can keep that there. And then thirdly, review the procedures that we use in our daily court matters. For example, how long should it take before your summons is signed, before an order is signed? So we can review those procedures and actually put timelines for them in order to make our justice system efficient and effective. Thank you.
Thank you very much. Thank you very much. And just going forward, I think we are learning as we go along. We will be notifying you in advance of who will take the next question, so that we all pay attention and I listen to what is coming up. Now, thank you very much to the candidates who are online. We are back here. I will start with Christine Kipsang. I hope I didn't catch you while you're not ready, but you have to be ready at all times in this one. So we will. The time is just 2 minutes. The bell goes 10 seconds before time, so that you prepare to.
Thank you. The points I raised here are supposed to enhance accountability, transparency, independence, and integrity of all the people who work in the judiciary. And the first one is I would like to have more courts, more tribunals, and even the small claims. I suggest over 1,000. I'm told there are about 100 that are coming, but I pray for 1,000 so that we can be able to have them countrywide. I suggest stenographers, costly statisticians, translators, legal researchers, transcription of proceedings, security of all judiciary's personnel, bench committees that are strong, not those ones who just go there and take mandazi and improved communication, coordination, mediation, court users committee to be very strengthened. Complaints resolution, many judicial officers have this weighing on them. We want them to be resolved within 30 to 60 days. Better housing, schools that for the children, so that we can be able to have no worries. The county government to have coordination to give land where we can be able to build these courts and the facilities, especially toilets. I was told once that in Makueni, the judicial officer had to adjourn the matter and go home and have a break. Can you imagine? I have break. It was happening, but now they have a very good courthouse. This is actually a justice tower. And so we want to have the experience that you would enjoy in the Supreme Court, in the Court of Appeal, in the High Court, in the ELC, to be the same as the same in the subordinate courts, the small claims, the tribunals, and even the Cadiz courts. Thank you. One more, there's 700 magistrates we have in Kenya. In JSC, in the Supreme Court, we have 7 judges, 30 judges in the Court of Appeal, 150 judges, and 41 court houses in terms of High Court. And we have 127 court stations. I would like to see these stations increase so that what I said.
I have 3 recommendations that I think would enhance information service for judicial officers. Now, 1, High Court judges publish their decisions, which then motivates them to shine. Magistrates don't do that. I would like to make recommendations that magistrates, subordinate staff, be published as well, so that they can have an opportunity to shine, which is aggression. But it also gives an opportunity to check the work of judicial officers, because in the High Court, when you read those decisions, you know what which judge is saying. So that's number 1. Number 2 is we have to review the workload of judicial officers, particularly those in the subordinate courts. The workload affects the quality of the work. Right now, it seems we are favoring quantity over quality. When a judicial officer, particularly a magistrate, has 56 matters in one day, you can be guaranteed that you will not get a fair hearing before that court because they are only seeking to go through their causes. So we now need to balance and give them a manageable workload. Thirdly, I think we need to have support programs that enhance the independence of judicial officers so that we do not have judicial officers complaining or feeling threatened by a commissioner appearing before them. That is a question of a judicial officer not understanding their oath of office, which is to do their work without fear, favor, ill affection, ill will. If they are not protected and if they feel they do not have mechanisms that support them in their independence, then they will not be independent. And then lastly, I would like to see the mental well-being of judicial officers being prioritized. It does not seem to be. Thank you.
Thank you very much, Ms. Soweto. Last but not least, Madam Jacqueline Ngutia.
Thank you, Senior. I have four proposals. One is around training. JSC also has a mandate to advise on training for judges and judicial officers. What needs to be done is that the training must be informed by the demand from the magistrates, not the Judicial Service Commission deciding on what the magistrates ought or ought not to be trained on. We can also have exchange programs, but when you're having the training and the exchange program, we should ensure that that does not affect service delivery. The second issue is around staff wellness. 3 months ago, I was in Mombasa and I met a number of judges. Within the beach, they are having their files. They had come for a colloquium, but they're carrying their files, walking in heels in the beach. I was there with my shorts and walking around enjoying the breeze, but they were telling me we need to still think about our decisions. We are here, but we need to write judgment. So we need to think about their staff wellness. We have seen a number of judicial officers, judges, and staff engage in alcoholism because of the workload that they have to meet. The case management system must be reviewed so that it is then efficient. Number 3 is reducing the workload, and this can only be achieved by increasing the number of judicial officers, judges, and staff. If you look at the state of the judiciary report, for 3 consecutive years, the Magistracy Court and the High Court is considered one with the highest backlog. So we need to then increase the number of judges, magistrates, and let it also be demand-driven. There are places in this country that don't have judges, there are places in this country that don't have judicial officers, yet they demand the service. When you reduce the workload of judges and magistrates, then they are able to work efficiently. Lastly is about fair administrative processes within the Judicial Service Commission. We have a number of cases that have been before the High Court, the Supreme Court, on the process of disciplinary process within the JSC. That must be reviewed. Thank you.
Thank you. I hope we didn't cut you short, but we are really running short of time.
No.
My colleagues for your very able answers. I'm sure the members participating in this debate have understood and are able to summarize what the candidates have said broadly, and we'll be ready with their questions when we return to them. Now, the second question that I intend to raise with you as candidates, and I will again go to our colleagues on the virtual platform, or who are following us virtually. This time around, I will start with Ms. Aoko Otieno. Ms. Aoko, you can hear me? I will start with the question. Yes, the question will come to you. Then I'll go to Ms. Jen Jagi. Then I will go to Ms. Anna Konuche. And in this other end, from Ms. Jacqueline to Christian. Now, when we promulgated the new constitution in 2010, we created the specialized courts, the Employment and Labor Relations Courts, the Environment and Land Courts, and went ahead and interviewed judges to serve in those very specific divisions or courts, to have the High Court as we have always understood it. The question is, and this is something which I know you may not be able to do immediately when you join the commission, but it is something that you need to think about when you are sitting there with your colleagues. Do you believe or agree that the creation of the specialized courts may not be a good thing for the professional development of judges? Is it time, in your view, that we considered a rotational arrangement to ensure that the judges serving in our High Court, especially, develop as professionals by interacting with various areas of the law in the same way in which there are divisions within the High Court, the human rights divisions or family divisions or commercial divisions. Members are particularly concerned about this because of some situations where we have seen certain judges having challenges when they get promoted or when they move up to the Court of Appeal, and they must now do things that they have not done for several years while serving in those. Do you think that it is something that you want to think about to ensure officers are able to grow all round professionally and therefore be better, service providers? I will start with you, Ms. Aoko. We can't hear you.
That we ought to have just retained High Court divisions. We shouldn't have created specialized courts. There should have been divisions of the High Court, all the specialized courts that were created. But since they're already there, and we've already done 12 years, I'm of the view that we can actually make also the Court of Appeal to be a specialized court. And I think that is where the whole world is going. Everybody is specializing in different areas of law. Therefore, we have a specialized court, a Court of Appeal for land matters, for environment matters. But still, I can put it, if I'm elected, I can put it to the floor with 11 commissioners, and we would go by the majority. But I would be of the opinion that we revise the Constitution and just make those courts part of the High Court and make them as divisions of the High Court. Thank you.
Thank you. Thank you. Thank you very much, Mr. Otieno. Next is Ms. Jane Jagi.
I appreciate that question. I would certainly think that it was smoother before, when the judges were able to sit within the High Court and deal with all matters law, other than what we have now, very specialized. For example, if you are judge in the environmental court, you remain with that environmental court, and that's all we deal with. I just wonder whether it isn't a little boring for the judge who has specialized in all disciplines of law, sitting in just one court, dealing with just the issue of environment or the issue of land. But I would say that we are already there, like my learned colleague has said, that the future is about specialization. But I would want to say that if the particular person applying to be a judge, and they have specialized also in colleges and universities in the matter, say, of land, then we'll be able, during the interviews, to be able to say, A is good in law, that is what they specialize in, and that's perhaps what they did in their masters. So that as the JSC is interviewing the members and deciding who is going to be a judge, then in that respect, we'll be able to have particular judges in particular courts, specialized courts. That is what I would say, and that is where we are headed. So as things are, then we will be able then to advise that there is specialization even in matters of interview. Thank you very much.
Thank you very much, Ms. Njagi. Before I go to Ms. Anna Konuche, Ms. Njagi, our screen monitors have just informed us that you may be having company in your office against the rules. I don't know if that is correct. If so, please just deal with that. And you must remain on video throughout, because you're not here with us. We want to be as fair as possible to every participant. Thank you. I hope you will. Yes.
I don't have anybody in the office except someone operating my system.
Ah, okay. Thank you.
Yes.
Okay, thank you. Yes, Madam Konuche, or Ms. Konuche.
Thank you very much, Senior. On the issue of specialized courts, I would start by stating that the nature of our training as lawyers is that we train as jack of all trades and master of law, master of none. So that when you're released into the market as a lawyer, you're somebody who can fit anywhere because you know where to get the law and how to apply it. And having said that, you realize that as people grow and as people develop in their careers, they tend to specialize. And that's why in academia you find people specializing in constitutional law, human rights, or any other field. And it is a good thing because then you are able to master a certain area and become a guru in that specific area, which is good and commendable. So my answer to this question is both yes and no. That first, specialization is good to the extent that it creates gurus in the specific fields where there is that specialization. But no, in the sense that, again, it doesn't allow for, it limits the room within which a judicial officer operates, especially because of the creation of the specialized court, which does not deal with the High Court. It's not the same way as the divisions in the High Court. So I would urge that we do away with specialized courts and remain with the divisions of the High Court as our state, and so that judges are able to move as they feel and as they specialize in an area in which they are comfortable in. And I encountered this issue when I was talking to some of the judicial officers in the lower magistracy level, and they were also arguing for specialization, but I did not agree with them because at that level, the kind of and volume of matters they handle are not necessarily specialized. So I think we should do away with specialized courts, not, of course, not immediately, and retain the old structure of the divisions of the High Court. Thank you so much.
Thank you, Madam Konuche. Ms. Ikutia. Please, for those who are following the debate online, please manage your gadgets because we're interrupting the debate. Please. Okay, we can proceed. Yeah, thank you.
Thank you very much, Senior. On the issue of specialized court, it's a good idea. I don't want to go to the issue of basic structure and eternal clause because specialized courts are a provision of the Constitution. So as JSC, I don't think it is important for us to discuss issues around amendment of the Constitution. It's a good idea that we then have the magistrates also recruited based on the specialization. It pains me that in the morning you find a magistrate handling a criminal matter, in the afternoon children matter, the following day handling a land matter. So we can have a system where we also have at the magistracy level specialized magistrates. The other issue is for us to just embrace the specialized court. The judiciary, the judges in the specialized courts are considered lesser. So the more we keep segmenting them, the more they feel unwanted. It's a constitutional requirement. We have to remember where we came from as a country, why we needed specialized court from the time of land dispute tribunal. So for me, it is just an issue of strengthening them and ensuring at the Court of Appeal, judges in this specialized court are also recruited, or even advocates who have specialized to also get positions in the Court of Appeal and the Supreme Court. When also engaging researchers, we need to bring on board advocates who have specialized in this particular area. So I am of the opinion specialized courts must remain, because in other jurisdictions it has worked perfectly. We just need to strengthen them. Thank you.
Thank you very much, Chaplain. We'll then go to Julie.
I'd like to answer that question in this way. There's a proverb that says plans fail for lack of counsel, but with many advisors they succeed. Now, how did we arrive at our constitution? It was negotiated, there was thought around it, and therefore the fact that it's in the constitution, we probably need to go back and check why is it that we came up with this court structure, and then review it. If we have to then go back to Kenyans or to many of us, especially we advocates who are involved in it, to see how do we deal with it, what are the pros and the cons of having these specialized courts, especially now that we are in the teen years of our constitution. We check and see what has worked and what has failed. Specialization is a good thing. The only problem right now we have is that we have specialization in the middle, but not at the top and not at the bottom. So it creates, whilst it enhances the knowledge of certain judicial officers, the other disadvantage is that it can create rigidity amongst the judicial officer because they are stuck in a particular way. It also creates a bottleneck in access to justice, which must be reviewed. So my simple answer is we need to go back and engage the people, the lawyers, in terms of why we would want to have a change at this, because this is now an academic question, seeing as it's in the Constitution.
Thank you very much, again, Julie. Finally, we go to Christine.
Thank you, Senior. I'd like to answer it in 5 points. I want to say that this is the best innovative idea we have ever had as a country, because if you look at the labor cases, we have the majority of cases that used to be blocking, the way of challenging us in the access to justice. So by having a labor court that is specialized, we have had many judgments delivered by that particular court. The same applies with the Land and Environment Court. Tell me, advocates present here, have you ever had a case where your litigant dies as you wait for hearing? Or your witness gets tired and you keep on sending summons? This is not happening now again in the Land and Environment Court. And land is very emotive, is a means of production. So the matters are being churned out very quickly. And if you have seen the judgments that have come out of these specialized courts, they're amazing. Because they're not like the way we see in the lower court, where an application is said, I allow the application in its entirety. Have you seen like that? Here, every point is analyzed, and issues that are set for determination are analyzed one by one. We need specialization right from the lowest court level, that's the small claims court, the magistrate court, the high court, the court of appeal, and even the Supreme Court. We should have people who are specialized. Even I'm urging each advocate, the 20,000 of us, to be specialized. I would like to be specialized as a family lawyer and be an expert in that, in adoption, in surrogacy, and what have you, so that when you come to Christine Kipsang, you will be able to see that this is an expert in it. let's specialize, because now even those judges you are saying they are rigid on what have you, they can read online, they can read these other judgments, so that when they come to Judicial Service Commission, they will be able to compete with the others, and when they go up, they learn. Learning and leadership are inseparable. Yes, and necessity is a mother of all innovation. So we should always find a way where we keep on learning. I imagine these judges not to just sit and enjoy and become a happy worker there in the particular divisions, but to work very hard and become specialized. Or because even if they resign or they retire from this particular jurisdiction, they can be employed in any Commonwealth country. Thank you very much.
Thank you very much, Christine, for closing the answer segment to the first two questions. The next two questions will then be presented by my colleague, Ms. Dorothy. Sorry.
Thank you, David.
Sorry.
I will randomly select from our debaters as to who to shoot the questions. The question will be the same for all of you. Now, what exactly is the place of researchers appointed under Section 7 of the Judicature Act? We have concerns, and our question is, do you think that they have enhanced the quality of decisions that we see in our courts in which they serve? There's a concern that from some of these decisions that the work of the researchers is being presented as rulings and judgments. Is there a possibility that judicial officers have delegated their duty to make decisions to these researchers? And if you are our candidate, what is your take on this? I will start with Madam Jagi. The floor is yours.
Can you please repeat the question? I did not hear it clearly.
What exactly is the role of researchers under Section 7 of the Judicature Act in the administration of justice? We are concerned that some of the judicial officers have delegated the responsibility to write rulings and judgments have the researchers improved the quality of the rulings and judgments or decisions of our courts? And lastly, what is your take on this?
My answer to the question is I would say yes and no. That on the issue of delegating the work, I would say that yes, it does help, especially this when we have very few judges and magistrates. Sometimes work is too much for the judicial officer. So if you are a good researcher, then they will be able to bring the research to the table and it expedites the work. So the judge or the magistrate is able to read the research with a determination. But I would also say that it does reduce the decision making. It does remove the decision making. Because during research, then the judge, if he's the one researching himself or the magistrate, they are able to come up with a clear points of law and be able to make a decision consciously. So, to me, I think it is a yes and no answer. But at the very end of the day, we have to trust the judge or the magistrate to use their own conscience in reaching a decision. So we leave it to the judge to make a decision. If he has too much work, he needs a researcher, or after that research has been done, if he can employ his own conscience and reach a just determination. Thank you.
Thank you so much for giving time. The floor is now yours, Madam Soweto.
Yes, I can answer this question out of experience. I have been a researcher to a judge in the Constitutional Court of South Africa. Each judge had 2 researchers. And the work of the researcher is not to make the decisions for the judge, but it is to facilitate the work of the judge. Research so that the judge has all the facts, all the material, all the case law before him or her from everywhere in the world, which enriches the decisions that the judge has made. That way you cannot have a conflicting decision, for instance. Again, we know that many heads are better than one. So when you're able to debate and look to see what about certain points is the decision. So my answer to the question of whether it is, yes, it does. The researchers have greatly helped to decisions by our judges. These days we see well-reasoned, well-researched decisions that include authorities that are cited. Judges don't even come up with new ones. That is good for our profession. Do the researchers take over the work of the judge? No, the researcher is the researcher, the judge remains the judge. It is ultimately the judge's work to come up with the decision and to decide what it is. But researchers don't just do the research, they help to ensure that we have a good judgment that is proofread, that does not have mistakes. Because if you have read a judgment in which there are corrections, and there are errors, it reduces the integrity of the decision. And then finally, the researchers definitely help the judges work faster, work better. So I do not think that this position needs to be reviewed. It's a good thing. We need to strengthen the capacity of all the courts with researchers.
Thank you very much, Madam Soweto. The floor is yours, Ms. Alpe.
Firstly, I'd like you just to confirm, is it really under Section 7 of the Judicature Act?
They are appointed under
yes, the
Section
appointment
7. Yes.
Of researchers.
Yes.
It is?
Yes.
Okay. I would say this, just like my friend Julie, the place of a researcher is to facilitate the work of the judge and not to write decisions. Therefore, if there have been some fears that there are some situations whereby researchers are writing judgments and rulings, then that is just an abuse of the resource that's available. And as we all know that every system is prone to abuse. But if there are such fears, then I think the members of the bar should actually petition the judiciary so that such fears are allayed. Because their work is to facilitate the work of a judge by bringing in precedents and authorities from all over the world that will help the judge in arriving at a fair and just decision. So, to the first question, have they improved the quality of the judgment? Yes. I have seen a number of judgments on the Court of Appeal and the High Court since researchers were employed, and I can say I'm very happy with the level of research that goes. Just the work that you present, they go beyond what precedents, they bring their own precedents. And so my point would be that yes, the researchers are good, they are there to facilitate the work of the judges, and so we should retain them in our system. Thank you.
Thank you very much. The floor is now yours,
Thank you, Dorcas, for the question. Yes, the researchers do have a big role to play in terms of assisting judges search for the, and that is the ideal situation. Researchers, and I have received information, anonymous information, that at times they are bullied to come up with decisions. And the issue is when they raise the issues with me anonymously, I'm not able to then escalate the issue with the JSC. And the reason again why they're not able to speak about this issue is because of the terms and conditions of service. Researchers, if you look at the Judicial Service Act, they are neither judicial officers or judicial staff. Their terms of service is 2 years. They are easily manipulated, they are easily discriminated upon. So we need to, yes, encourage the judiciary, the JSC to come up with, to hire more researchers, but we need to improve their terms of service and in addition to that, ensure that they have their roles cut out just before they engage. When you have researchers make decisions, then that affects independence of the judiciary. It is a clear way within which people can influence decisions. You have researchers reaching out to parties, telling them that I'm the one making the decision, I need some money. So once we improve the terms and conditions of service for judicial researchers, then it will be easier for them to know their place, because we cannot allow them make the decisions. And I have seen very good judgments from the Supreme Court, and you could tell that there were people behind those decisions. The place for judicial researchers is there, but we need to be careful that they do not take over the role of the judges and magistrates, because you cannot delegate decision-making process of the judges and judicial officers. Thank you.
The floor is now yours, Madam Gibson.
Thank you, moderator. I would like to say that judges and judicial officers, that's magistrates, they listen to facts that are coming from the witnesses after reading the pleadings. They understand the story, they do the analysis of the law and the facts, and they're the ones to decide. And in Kenya, we all know that we have legal researchers in the higher courts. We do not have legal researchers at the tribunals, in the Kadhi's court, and even the magistrates' court. And for me, I would recommend that we have legal researchers in all the courts, in the entire. Research is actually starting from, what you know as the facts that have been given, and then now you go out and find out more about it. And we all know our judicial officers and the judges have cost lists. We have just said here, the cost lists are huge, the workload is a lot. And so daily they have a cost list. Sometimes I always wonder, that day in day they have cases, they have a cost list, they have to listen to those witnesses, at the same time they need to research. So I would recommend that the researchers do their work in research. Of course, I've gone around the country, and let me call a spade a spade. Researchers are writing judgments and rulings. Members of LSK, do you agree? Do you agree? They are writing judgments and rulings. Read those judgments, sometimes you get to wonder. They are writing them, and that question is very timely, because if I get to JSC, the researchers will do their work, and the magistrates and judges will do their work. We need to have separation of functions, besides having the issue of terms and conditions improved for legal researchers. Of course, I want them to be permanent and pensionable so that they can be able to develop in that particular area. Because we cannot not all be it as practitioners. Some people want research. Thank you very much.
Last but not least, Madam Konocha.
Okay. The question of whether the place of researchers, whether they have enhanced the quality of decisions of our courts, I agree, yes, the quality of decisions of our courts have been enhanced since there was appointment of more in-depth research as compared to when the judicial officers did not have them. And also, as we have noted, the so the workload is higher. and therefore they may not get the time to do the research that they're required to do in order to get a judgment. So researchers, yes, have improved the quality of decisions. And the concern of whether judicial officers have delegated the duty to researchers, my issue would not be so much as delegated as it is accountability. I think at the end of the day, the judicial officer is still accountable in terms of the decision that they have signed. So it may have been written by a researcher, but at the end of the day, the judicial officer is the one who is accountable for that decision because it is their signature that is appended to it. And to that end, then they should and must go through decisions that are written by researchers to ensure that it tallies with their thoughts and their philosophy, their legal philosophy. The issue I want to raise is the evaluation of researchers. You find that they are not accountable to the registrar per se. They cannot be evaluated by the registrar because they do not receive instructions from the registrar. They receive instructions directly from the judges. But you find that the judges are not the ones who evaluate them. So it is not easy to evaluate researchers because the chain of command is not clear. Who are they accountable to? Administratively to the registrar, but functionally to the judges. So I think that is an area that needs to be cleared out. And also just to reiterate that they have no career path. These are people who have belonged 2 years, sometimes rarely retained, so they have no career path to grow either into magistracy or to the administrative positions in the judiciary. So with that unclear career path, then again it puts them at a compromised position in terms of accountability, in terms of independence of thought, because they are thinking about their job, what happens after their contract.
Sorry to cut you short, but your time is over.
Thank you. Thank you.
I wish to clarify that the discussion we've had was under Section 7 of the Judicial Service Act and of the Judicature Act. Now on to our follow-up question, still touching on the bench. The number of judges in the Court of Appeal was raised from 10 to 30 by dint of Section 7 of the Judicature Act. But nonetheless, we are still having serious delays in the writing of judgments and rulings, and even in the hearing of matters under certificate of urgency. So much so that if you were to file a certificate today, you will be given a date under certificate on priority, sometimes in November 2022. And we'll all agree with me, practitioners here present, that by that time, the reason for the urgency might have been defeated. So, debaters, this is despite the fact that now the judges have assistance in terms of researchers and very good research facilities because of adoption of IT within the judiciary. Where do you think the problem is? And what is your prescription once we get you into JSC? I will start with Jackie Noti.
Thank you for the question. I was thinking somebody else would be asked that. Okay, yes, the problem with over legislation, why would they settle on party? To the best of my ability, the best practice, HR practice and HR practitioners who are here, staff establishment should be a management issue. The JSC ought to, as opposed to having the figure legislated on. We need to have the act amended to increase or even just remove and have a minimum number. What informed the 30? Population of, we are how many? 50 million, and others could be about from that number, 30 people who are accessing justice. The number is also high. Why 30? And I also have concerns with the Court of Appeal on the manner within which they are locating dates and hearing matters. There are certain law firms that get priority. There are certain state agencies that get priority. And I would blame this on the Judicial Service Commission. They need to set standards, minimum standards for all courts. Yes, the courts must control their diary. The courts must control the court itself. but minimum standards must be set by the JSC, and this can only be through either policy or systems. There is absolutely no way a court of appeal can hear 6 matters and you have the magistracy hearing 40 cases. So Judicial Service Commission needs to up its game, and I believe I'm the right person because I know you cannot have a definite figure in statute. You need to then have the definite figure either in policy or standard operating procedure. 30 is not enough for the population in Kenya because we are having from the 30 we have 25. We are yet to have the president appoint the two or three Court of Appeal judges. But even if we get to 30, I do not think we will resolve the impasse that we have. Amend the Act and have staff establishment based on figures on the number of people who want the services of the Court of Appeal. Thank you.
Thank you, Madam Inguchi. The floor is yours, Madam Judge.
Kindly please, my phone was echoing. If you can repeat the question.
The number of judges in the Court of Appeal was raised to a maximum of 30 from 10. Pursuant to 2015 amendment of Section 7 of the Judicial Act. Now, there are still some serious delays in settling down matters for ruling and delivery of judgments. And we all agree with me that if you're to go to the Court of Appeal under certificate of urgency today, the earliest date should be given is somewhere around November. And by that time, the reason for the urgency might have been defeated. This is also despite the fact that there are researchers available to the Court of Appeal and very good research facilities from the adoption of IT. My question is, as somebody who wants to be our JSC representative, why do you think the problem is, and what is your prescription to this problem?
Yeah, that is a good question. What I would say is that the problem lies on the heaviness or the amount of work that is facing the judges. So what I would do is I would encourage dispute resolution mechanisms through infrastructure, like I mentioned before. And this has been done in other countries, including England, where there's been a lot of investment in infrastructure. I would recommend recruitment of more judges, and I would promote seriously alternative dispute resolution. Make mediation part of that process. So in looking at it from that end, then we have sorted out quite a number of problems, and it will be reducing the workload. Thank you.
Thank you very much. The floor is yours, Madam Salt.
Yes. First of all, having been a researcher, I know that decision making is not easy, especially where you know that you are the final court. You have, and that affects the lives of people, and there's no other avenue for people to go to. And having been a researcher in a court that is considered to be one of the best, I saw decisions take even a year, not because the judges were not working, but because they were going back and forth, trying to see how best to make a decision for those who it affects. Now, the Court of Appeal right now has 21 judges out of the 30, which means we still have a shortfall. The reason why we thought about 30 was to cater for even our population. So with the current shortfall, we are creating backlog. It means we do not have enough judges to hear the cases. And Kenyans have become way more litigious than they used to be before. People are fighting for their rights, which means there are more cases making it up to the Court of Appeal or even to the Supreme Court. As to where the problem is, I do not know where that problem is, but this is a question of transparency. We need more transparency and accountability from the Court of Appeal, We need to know. They need to give us feedback and tell us what is the problem right now. Why is it that they are not able to manage the workload? Is it a question of resources? Is it a question of courts? Is it a question of the manpower? So we need to have some communication back from the Court of Appeal to tell us where the problem lies, so that then we understand, as we are right now, all we're doing is hazarding guesses, trying to figure out what it is, and we're then thinking that the judges are not working. I think we have rather hard-working judges in our courts. I'll stop there.
Thank you. The floor is now yours, Ms. Alpha.
Firstly, I'll begin by saying that we have this history of always capping judges, whether of the High Court or Court of Appeals. Our legislation is always capping, and this is something that has got to do with how government works. So maybe in future, the JSC needs to sit with the committee in Parliament that's in charge of legal affairs, so that they can see how best they can manage this capping. But capping has been a history even before independence. I'd also like to point out that we have never, since 2015, when they were increased to 30, there's no one day we had 30 judges of the Court of Appeal. And as Julie has said, that there are 21, I thought there were 20. So that means that we have a shortfall of judges handling this matter. Where I would say the problem is, firstly, we created specialized courts, which were like at par with the High Court. So that means there is more work coming to the Court of Appeal. And this is because many more people were now accessing justice before the Land Court, before the Employment Court, and other courts, other specialized courts. So you find that the Court of Appeal is having more work on the High Courts than the specialized court. And we have not increased the number of judges. In fact, for almost 3 years, prior to April 2021, we had only 11 judges serving in the Court of Appeal. So you can imagine, 11 judges are supposed to hear appeals from all over Kenya. Honestly, there has to be a backlog. So a lot of backlog was created. As much as there was backlog before, a lot of backlog was created when we had 11 judges. My prescription would be that what I have noticed that when a judge dies or retires, it takes forever for the JSC to replace such a judge. I think that I would prescribe that should happen immediately. When a judge dies or a judge has retired, there should be an immediate replacement so that we do not have the gap that we have had in the last 3 years. Secondly, I would advocate that we reach the limits that has currently been provided.
Sorry to cut you short, Ms. Alpha, but your time is over.
That is
all. The floor is now yours, Ms. Gibson.
Thank you, moderator. I would want to say 3 things. Firstly, on the issue of delayed certificate of urgency hearing and rulings, that this is a case of lack of uniformity. Because in other courts, when you go to the certificate of urgency, you're given directions in one way or the other within maybe 1 or 2 days. And so I would advocate for uniformity of all courts so that there's clarity, there's transparency and accountability and certainty. So in this case, the Court of Appeal needs to be able to have what we call active case management. Immediately a matter gets into the system, and the way you have said that this monitoring of use of technology, their assistants, their clerks, they should be able to monitor the matter the way, like you send a person by DHL, and you can track it. We should be able to track these matters actively throughout the life of this particular appeal. Remember, this matter maybe has come from the Small Claims Court, it has gone to the High Court, is now at the Court of Appeal. So the justice, we always say litigation must come to an end, and there's nothing new under the sun. These systems need to be put in place, and they should be improved in one way or the other. The other point is the issue of decision making. I sit in a tribunal, and I can tell you writing a judgment or a ruling is not easy. And so if there's some delay, it's because somebody has to think. Because you can have a judgment and then not have a country or even a house or a couple. You can find that couple has cut each other, isn't it? And they are dead, both of them, and the children are left as orphans. So you have to really think, you have to really analyze. And as a judicial officer, you have no one else to ask but yourself. You have to really keep on looking at the law and the facts and how this impact will be on the particular society or consumer of justice. So it is not easy. I need to want to tell you that there is a roadmap that we use in making decisions. Then the other point is the issue of establishing backbench committees. The issue of saying there is delayed hearings, rulings, and what have you. If we have a strong backbench committee, we'll be able to task the particular committee and ask them, can we have a meeting so that we can understand where the bottleneck, where the inefficiencies in the particular court. So the last one is on attitude. I think this attitude of laziness, attitude of lethargy, there's an attitude of wanting to wait upon, to do something. But also, if you look at the Court of Appeals, the judges are very competent and hardworking. Thank you.
Thank you so much. Ms. Anna, the floor is yours.
Thank you so much. I'll begin by saying, looking at the number vis-a-vis the number of judges of appeal vis-a-vis the number of judges of the High Court, ideally it's one judge 5 of the High Court. Basically, what I'm trying to say is that the workload partly is to blame for the serious delays and both in writing judgments, taking late certificates and all that. So I think the workload is a bit high for the Court of Appeal, and for that reason then it calls for increase in the number of not just the judges, but also Court of Appeal stations across the country. Secondly, there's just reported apathy in the judiciary, and I think apathy, Christmas, public lethargy. For this, I would suggest that we commission, I would propose for a commission of an organizational survey. The root cause analysis of whatever ails the judiciary. Can we just have an independent survey that is done on performance, on culture, on attitude generally, and then identify where the problems are and then find solutions for those problems. Thirdly, participation of the stakeholders in the evaluation of the judges. Currently, as I indicated earlier, the evaluation is internal. It's done by the judiciary itself, and it may not be objective at the end of the day. So they will give us a report that they have cleared so many matters or the workload has been reduced by this number of cases. But in reality, maybe things are just, cases maybe are being dismissed not on merits but on other grounds, technicalities. So we need to have the feedback of stakeholders taken into account when it comes to evaluation of not just the judges of appeal, but judicial officers in the overall. That way, we incorporate that in the performance system, and we have 360 sort of evaluation of the work of the judicial officers that covers both their internal factors and the performance according to the other stakeholders, the external stakeholders. Thank you very much.
Thank you very much. I now hand over the microphone to my colleague, Ms. Odette, for the next part of the deliberation.
Because of time, I would request members please listen to the question. I can see we are already out of time. I'll begin with Lady Alpha Otieno. Section 25 of the Judicial Service Section 25 of the Judicial Service Act sets the retirement age for a judicial officer at the same age as that set for public officer, which is 60. the Judicature Act sets the age at 70 for judges. Believing that you understand what informs the need to keep judicial officers in service longer than other public servants, do you agree with this dichotomy? Lady Aoko Otieno.
Firstly, I would say there is a reason why our legislation has set those two different categories for judges and other judicial officers. There must be a very good reason why that is done. And I have not had anybody saying they want to petition those sections of the law to be amended so that the judges can serve less than a year in office. But I would like to say that so far, I have not seen, in my 20 years of practice, I have not seen any judge being errant or being less sharp because he or she has exceeded the age of 60. Actually, at the age between 60 and 70, they give very good judgment. If you compare with Britain, US, in US judges serve at the Superior Court, they serve until they die. There is no limit. Therefore, I think even in Kenya, we should not limit judges of Supreme Court to 70. At 70, most of them are still very active and they still have very sharp legal minds. But however, I would say that we need to have a uniform system because this is one judiciary. I would advocate if elected that magistrates also retire at 70. However, they can voluntarily decide to retire at 60 if they feel tired. So I support the judiciary having a different age with the other civil service, but at the same time, I advocate that we make it uniform such that magistrates and judges can serve until 70. That is it.
Thank you. Mwalimu Anna Konuche.
Okay, thank you very much. Listen to your question. And judicial officer 60, judges 70. I would also like to add that academic staff retire at 65, others at 70, 65. I think the reason for this, the underlying reason for this, the kind of work that these officers are engaged with during their lifetime. You'll find that for magistrates, the kind of work they do is kind of backbreaking, all day kind of long course distance and all manner of work, as I said, jack of all trades. But judges, as they move on higher, they tend to have lesser workload, and therefore able to contribute better and not as backbreaking as that of the magistrate. So I think that is probably part of the reason. And I think with the law, people age like fine wine. The older you are in the profession, the better you get. So I think the older the judge, the better the ought to be. And therefore, I do not see any problem with these provisions of the law. Thank you.
Thank you. Madam Jadi.
Thank you for that question. When you look at the chapter, it gives the officer liberty to retire at any time. So having been given that test, I think that it is the wisdom of the legislature to have seen down what we did. But what I would say is that at 7 years, you will find that some of the judicial officers are quite active and having invested so much in the role of reaching that 7 years while in the judiciary, I think it will be proper that they be allowed to continue retire at that later age, especially with their liberty when they feel a bit tired, they are free to retire. However, there is that discrepancy with the other officers that I would not want to engage in. Thank you.
Thank you. Ms. Soweto.
The protection of judges' age is set in the Constitution, unlike other public officers. I would actually like to be able to know what was the reasoning behind it and this dichotomy. When I do not have an answer to a question, I am not afraid to admit that I would like to do some research in order to be able to understand why is it that there is this dichotomy. I was not aware that there was even this dichotomy, because it would then create a question of discrimination. Somebody probably has not brought it up just yet. However, as a practitioner, I know for a fact that the older you get, the better you get. It's not debatable anymore. The things that I used to do in my youth are not what I do right now. I am more seasoned, and I've seen judges get much better as they get to 70 than what they were before in their years. Then finally, on that question alone, I think the nature of the work that's done by judges as compared to just, when we talk about judicial officers, perhaps I didn't understand this question. Are we talking about magistrate? The distinction between the judges and the magistrates, I am now not clear on, because now that I think for me raises a question that I would need to interrogate a little bit better. Right now, I'm not sure. They seem to do rather the same work, although the magistrates seem to do more back-breaking work. So I would want to interrogate that more.
Thank you. Christine?
Thank you, Moderator. I think in this question I would want to answer it in two parts. The first part is the two different numbers have been given, 70 and 60. I see no problem with this, because this career progression, I would not want to expect a magistrate to stay in one station until they are 60. They need to apply to be judges, isn't it? Judges of the High Court, judges of the Court of Appeal, I mean, they need to go up. So the retirement age, I think it's the wisdom of the Parliament, and as JSC, I would want to engage the committee, because as JSC, should not just engage them when I'm looking for funding to establish more courts or more facilities, but I would want to understand how they came about with this and how it can be harmonized and bring uniformity. The second bit is the fact that we all know that judges and the judicial officers in this country are serving at different terms and conditions of service. Judges have security, judicial officers do not have, and many other amenities that they would wish to have, but the judges are the ones enjoying only. So if I were to engage the Parliament and also to get the, like the way I said, a Bambage committee, I will be able to understand how they are being affected in terms of service that are different from judges, and yet they hold the Kenya Magistrates and Judges Association together and they raise those issues. So if I see the discrepancies, then I would say it's discrimination, and then we need harmonization of those terms and conditions so that they feel motivated. I've got this country, there are judges and magistrates who are demotivated. I need to motivate them. I need to encourage them. I need to make sure that all advocates have food on the table. Have you ever seen the way a magistrate is happy with you when you are submitting? It is the same thing I would want to have, that the terms and conditions are improved. As your JSC advocate, vote for me.
Thank you, Maureen, for the question. As a human rights practitioner, I understand not all different treatment amounts to discrimination. The issue of age is set by the Constitution, and I cannot say the Constitution is unconstitutional. So it's a custom that we borrowed from the common law, and the other issue is that judicial officers and judges have different terms of service. The recruitment process of a judge is different from that of a magistrate. The removal of a judge from office is different from the removal of a magistrate in office. So I agree with the sentiments that the older you grow, the wiser you become, and I'm happy with the retirement age of 70, and I'm happy that one of the judges who was recently appointed was a magistrate who was on retire and was recalled to take over the position of a judge because of this provision of the Constitution. So unless we take the question back to Kenyans to deliberate and agree on whether we also need to push the retirement age of magistrate to 70 years, but as of now, we have to live with what the Constitution provides for.
Thank you. I will begin with Mwalimu Anna Konoche. The Judicial Service Code of Conduct and Ethics Regulations 2020 has a set of rules for judges in Part 2 and a separate one for what it calls judicial officers in Part 3. Do you believe this separation sends the right message if you consider that judicial officers at all levels do more or less the same job? Could there have been a mischief for this distinction? Anna?
Thank you very much. Now, the Judicial Service Code of Conduct, Part 2 and Part 3. Let me begin by the last question. I do not think there was a mischief in these provisions that provide for judges and for the other judicial officers or judicial officers. And the reason being, there is a difference in the recruitment criteria for both judges and for the other judicial officers. That's number one. Number two, there are different terms of service for each category. The magistrates created under the Constitution but governed by a statute. So, of course, there is the universal qualities that govern all these judicial officers under the Bangalore principles. Those are universal to all. But I think we can differentiate between one cadre and the other. And this is evident even in other sectors of the public sector. For instance, we have the Public Officers Ethics Act that governs all of us, but each institution has its own code of conduct. The DPP will have its own prosecutorial code of conduct, and other public institutions have their own, depending on what they do, depending on their terms of service and everything. So I think there is no mischief, and I do not think that it is discriminatory in any way. I think the provisions are okay. Thank you.
Madam Njagi.
Thank you. I do also, I do not think that there was any mischief, and the issues of different codes of conduct in this case. That's what I can say.
Thank you. Lady Aoko Otieno.
Thank you. What we have to appreciate is our history. How did we start the judiciary? It was started by our colonial masters in 1897, past court. So what they did, the judges were not natives, so to speak. The judges were foreigners. So what they did was just to create for themselves better terms than the terms that they were giving the Africans. So I think it is a high time that we actually harmonize and synchronize. Because if you're a judicial officer, for example, a magistrate, I don't see why we should have a separate procedure for you and for a judge, and yet you all discharge the same function of administering justice to the cases that are brought before you. So I would say there's really no mischief. You're having that different classification, even of ages, just because of the colonial hang-ups that we had. So it is about time that we actually synchronize these provisions that seem discriminatory. Yeah, they didn't intend, the legislation didn't intend to be discriminatory, but it's just a history that we adopted as that independence. So it is a high time is now ripe for us to ensure that there is harmonization such that judicial officers, magistrates are treated the same way judges are treated. Thank you.
Thank you. Christine?
Thank you, moderator. Briefly, I would say that these two parts serve the same function. And I would say that because judicial officers and judges serve the same judiciary, we should have the harmonization of their functions very well, because the issue the service of judiciary. And so this is a call for reform, so that we can have reforms that can bring working environment both for the judges and the judicial members, and also so that they can feel like I said before, so that they can feel motivated to work hard and even to aspire to go to the next level. And as you all know, even the people who are seated here, I think most of them also want to be judges and magistrates. So if these reforms come into being, it will mean that anybody applying for a magistrate's job to be employed in the judiciary will be motivated, because the terms and the conditions code of conduct is clear, and it brings the independence of the judiciary. Of course, if there is those reforms to be done, it needs also to engage Parliament. And so the three arms of government need to work hand in hand so that it can be of us to access government services. Thank you.
Thank you. Madam Nkuche?
Thank you for the question, and I'm happy that at least for the first time I'm hearing something about the code of conduct. I've been walking around the country, I've asked colleagues whether they have had an opportunity to review that document, and I'm saddened that we have not had an opportunity to interrogate. So I would ask colleagues kindly get a copy of the code of conduct that was launched sometimes in 2020, very comprehensive on the offenses. On the question that you have asked, the Constitution separates the judges and the judicial officers. The Judicial Service Act also separates them. You have the definition of judge to include High Court judge, Court of Appeal, and Supreme Court. You have the definition of the judicial officer to include magistrates and caddies. And then you also have the definition of judicial staff to include clerks and executive officers. All of them have different roles. In addition to that, the Judicial Service Act delegates the power to the Chief Justice to discipline judicial officers and judicial staff. So it is important to have separate code of conduct for these three, the three staff of the judiciary. The other issue would be around the removal of judges from office. It's a very comprehensive process, and when you lump them up into one code, then it may be problematic when it comes to implementation of the code of conduct. So it brings clarity to know what a judge, what a judicial officer, and what a judicial staff ought to and ought not to do. Thank you.
Thank you. Finally, Ms.
Yes, the answer to that question we must look at it from the pathology of the Constitution. The Constitution is where it provides for judges. And the Constitution also creates a very clear path for disciplining or removing or dealing with disciplinary issues of judges under Article 168. the Constitution. It's not the same for other judicial officers. Therefore, naturally, any subordinate legislation must first look at what the Supreme Law has provided and then provide for it. That is why there is that dichotomy between judges and judicial officers, because even the Constitution does not treat them equally, and they are not equal. We must recognize what the Constitution has provided and how they should be treated fairly. Now, that for me is a very big question, because we know that for a long time, the Judicial Service Commission has not had regulations on how it should treat judicial officers or how it should deal with them. It's a good thing that now we have a judicial code of conduct that clearly spells out those things, those rules, as long as it does not violate what the Constitution has already provided. Judges have security of tenure, judges are protected under the Constitution. Judicial officers do not enjoy the same kind of protection.
Thank you. Requested that I will allow 2 questions from the members of the gallery, and the question will be directed to a specific candidate. Only 2 because of time. I'll have 1 from her. The next person? If you have 1, thank you. Please come to the front.
Thank you very much. My name is Elizabeth Duya. I work for Transparency International Kenya, the regional office based in Kisumu. My question goes to Jackie, and I'd like to hear your strategies in terms of fighting corruption in the judiciary once you get elected as a female representative in the JSC.
Okay, I believe that question will be dealt with. I think that question should be answered by all of you. I believe so. I think we want candidates what the attack is on that very important subject that you've raised. And
if I could ask if it could be repeated, because I think the mic was too close to the mouth that it was not audible. The question was not audible.
Ms. Anna Kunuche, corruption, as always. What do you intend to do when you get there? Time that you all answer that question together with another question that I will raise, which is unconnected with it. Okay? Because we still have the presidential debate, the other bit of the debate to deal with. Now, so have that in mind. Now, the next issue that I want the participants to address is something that I have personally experienced with the JSC, and which is based on an interaction I had with an official of the JSC. The Judicial Code of Conduct, which Jacqueline has talked about, as she says, I think very few of us have read about it, but I was forced to interact with it recently because to the JSC, a judicial officer in Nairobi, and the reason why I want you guys to deal with this question is because under the Code of Conduct, a judicial officer is required to act with professionalism. And the definition of professionalism has many things. It includes discharging his duties as a judicial officer competently and while maintaining the right standards of performance. So you have a scenario where you are not talking about corruption or anything, but someone is just incompetent. And I think you may have come across that before. The reason why I have raised this is because it is turning out that whenever you file a complaint against a judicial officer on the ground of incompetence, look, this judgment or ruling is so bad, you cannot support it or explain it in any way, except on account of the fact that the person who delivered the verdict is incompetent. But when those complaints get to the JSC, there appears from history that you will be told that if there is provision for an appeal against the decision, you go and file an appeal. Okay? So I want you to tell us what your take is on dealing with scenarios or situations where judicial officers are plainly incompetent, and whether you will also tell us just to go and file an appeal if the law allows it, so that we can go and cry in the appellate court and say, this is a bad decision. Yet in the code of conduct, there appears to be provision for raising a complaint based on that issue. The last bit, and again, this we're doing in the interest of time, I think because now combined with the question raised by our colleague, we'll give you 3 minutes. The final question from the moderators is, we have had challenges whenever we have elections, either of our representatives to the JSC or to council, of candidates receiving support or funding from politicians. And the rumor is already all out here. I don't know who is involved, but we just hear, this country is full of rumors. So we want to know, and you need to honor and tell us and admit whether or not you are receiving support from the political class, because we all know that will definitely impact on your representation of the LSK in the JSC. That will be the last question from the moderator. The online group, I believe you got me. I will start. I don't know if Ms. Jen Njagi is ready. Madam Anne Konute looks extremely ready. I think you can go fast on this. There are 3 questions. There's a question of corruption, the questions of complaints with the JSC that I've raised, and the question of the possible mingling of candidates with politicians.
All right, thank you. Let me just get clarity. I have 3 minutes to answer these 3 questions.
3 questions. The first one came from the gallery on what you will do to stem corruption in the judiciary if you're elected. Number 2 was the question brought to you as committee against a judicial officer on account of incompetence or failure to maintain the right standards in the delivery based on incompetence. Whether you think that is a matter which should actually be the subject of an appeal and not a complaint to the commission. And finally, there are indications from our members that some of the candidates running for this office are being supported by politicians or are receiving funding from politicians. And we just want, on this one, we just want you to say yes or no. We may not want too much information, but we want you to be as open as possible about that last bit. Thank you.
All right, thank you very much. Actually, what I was seeking to know is how much time I have for the 3 questions.
Sorry. 3 minutes. I'm sorry about that.
All right.
3 minutes.
Thank you very much. On corruption, let me go on corruption. Yesterday I was in Kisi, and I think there was an advocate who was arrested in Ogemo because of raising issues of corruption publicly, and I think the lawyers there rushed to his aid. What I propose in fighting corruption, number 1, we have an anonymous reporting system. The reason I say this is because when I walked around the country, I was told that when you raise issues against judicial officers, chances are there's backlash or victimization. So we need to have an anonymous reporting system, strengthen the oversight system, and work with EACC to stem out corruption. Number two, we as members of the bar need to stop participating in corruption. There's no corruption in the judiciary without participation by members of the bar. So it starts with us. We need to introspect on that. So on the second issue on incompetence at the bench, my first proposal is, first of all, we need to review perhaps the recruitment process so that we only take the very best, it's all-rounded. Yesterday when I engaged members with Kericho, some of the complaints I got was that when we recruit people from certain sectors, they come in very narrow-minded and some are not willing to learn. So it goes back again to performance management and evaluation. These people, these judicial officers need to be evaluated not just by the internal system, but also feedback from the external system. The external stakeholders must be taken into account. And secondly, we need to have a parallel system process where the appeal can proceed alongside investigation. Under Chapter 15 of the Constitution on independent offices, independent offices have the mandate, have the power to investigate, to initiate investigations. So if there are any complaints, JSC can initiate investigations into any allegations of incompetence, and this must be pursued to the logical conclusion, and a finding is made, and then the law takes its course, whether it is a dismissal from service or if it's a performance improvement system that can help that judicial officer come up to par. On the issue of funding for politicians, my answer is an emphatic no. My sources of funding can be verified, my request statements can be availed to confirm that it's only friends who have come to my aid. Thank you very much.
Thank you. Thank you, Madam Konuche. Ms. Jane Jangi, I believe you are ready. Please proceed.
Yes, I will start with the last question.
Yes.
The funding from politicians. I would say no, and even said that it is very, very wrong. It is a very bad hit in the mouth. If we, as members of the legal profession, can accept funding on an exercise where we want to choose someone who is going to deliver, one of us, whoever it is, who can be able to stand up and even fight that corruption. When you accept this money, it means that you are accountable to that politician. And that is the independence. That is where we are fighting for independence of JSC. We need a clean JSC so that we can be able to deliver our mandate. So that we as the law society can also stand up and be counted. But if we start by accepting to be funded by the politicians, then that is the beginning of our fall. So I would say no, and I would not want even to accept the fact that this will be happening, because that is the beginning of our end. Then I want to go to the issue of corruption. It is not just about getting reports that are anonymous. It is a question of making emphasis and dealing with the matter of corruption with the seriousness it deserves. It is about being each other's keeper and coming out and saying we are one country, let's be each other's keeper, and let's deal with corruption the way it is. There is nothing to hide about corruption. We have Chapter 6. We must be able to deal with this openly, handle it with the seriousness it deserves, so that at the end of the day, if we are together, people will say, the country will say, yes, now we have a JSC that is transparent. People will believe in it, and people will believe in us lawyers, and together we shall go into the future. When it comes to the complaints, the conduct of raising, you say the scenarios where judicial officers are incompetent, that also should be dealt with the seriousness it deserves. When these reports go to the JSC, they should be handled with precision, so that they are not cases that lie there and allow, for example, judicial officers continue being in office when they're actually incompetent. It's very clear to know that a judicial officer is incompetent. You go to that court, like I said, I've practiced for that long. You go to that court, and your case is adjourned every other day. You are told come for a ruling, you go for a ruling, it is not there. So you start asking yourself what is happening. So let us be able to be vocal. Let us not fear that we shall be victimized. Let us make a law society that is clean and a judicial service commission that is accountable to the people. Thank you.
Thank you very much, Jen. Christine?
Thank you, moderator. For the question of corruption, I would say that I would promote better terms and conditions of the serving judges and the magistrates and even the staff, because we know that it starts right from the registry where 50 bob or even members of public, and so those clerks starting having parallel work apart from the work they do in the registry. And then when it comes to the magistrates and the rulings, favorable decisions depending on whether bribes have been exchanged or not. So it just behoves upon each one of us as members of the bar. We are 20,000. As I said, magistrates are 700, judges are less than 300, less than even 2,000. So can you imagine, we are 20,000 and a small segment is holding this country at ransom, causing a lot of injustice. So as advocates, I call upon you to stop the corruption from our end. Don't give that 50 bob, don't give out that 100 shillings. Even in the land registries, it's the same cry all over. So if we were, as advocates, we would stand and say we stop this 50 bob issue, we will be able to resolve this issue. And then in terms of personnel, I would say that more judges and magistrates deal with the issue of corruption cases. Right now in the country, I think there are very few magistrates who are dealing with corruption cases, or even the judges. So we look as if we are doing it part-time, piecemeal, or something like that. So if we were to really have a department dealing with corruption cases, then we'll have even orders freezing accounts, seizing corrupt enabled properties and what have you, and the country will be streamlined and will have better economic empowerment as a country and will develop better. So we need more personnel, and then also we need training. The judges and magistrates dealing with these corrupt cases need a lot of training and support and security so that we can be able to stamp out corruption in our courts. We are only 127 court stations in this country, and you can imagine if it's 127 centers, we can still remove corruption once and for all. So I also advocate for LSK unity, cohesion, so that we can be able to speak with one voice and support me as your JSC representative. On incompetence, yes, I know those complaints have been there. Even me, I also reported 1 or 2 judicial officers. And I can tell you my file took a long time to be resolved. And I was told, can you go up in the appeal, continue appealing? So I think incompetence is not, the prescription is not appealing or going up the ladder, because this person, apart from the case you have reported, he or she is still also causing a lot of injustice by delivering incompetent decisions every day. He's not applying his the legal reasoning that is required in the matter. So we need the issue resolved by JSC, as I said, within 60 days, so that there can be a clarity, a certainty, and end to litigation. The last point is about politicians. No, I have not gotten anything. I've gotten support from advocates, senior advocates, young advocates, even others have volunteered to do my work of sharing the posters and in the social media. And I'm very happy because I'm feeling like part of you. Just make it again. Let's continue that way. Thank you.
Thank you. I think yours is bottom up. Julie. Thank you.
I think, just to understand the question correctly, it was about dealing with corruption within the judiciary. My strategy for dealing with corruption within the judiciary is to, first of all, see how it is being dealt with currently. And one of the problems we have is the JSC itself. We need to strengthen the capacity of the JSC to deal with corruption cases fast, expeditiously, and very fairly. The problem we have right now is they do not have rules or regulations, and therefore there is no systematic way of dealing with corruption cases. A fair system says first in, first out. Without rules, it's a puzzle how they deal with their complaints. Secondly, I would propose a lifestyle audit amongst our judicial officers so that we're able to gauge and see, you came in, this is what you have. You're going out on at this particular point in time, you have so much. Where did you get it? You should be able to explain it. Thirdly, again, is to emphasize that the JSC needs to deal with corruption cases with speed. Because one question a question of integrity against one judge is a blot on the entire house, but it needs to be dealt with fairly. Now, the second question on David's question of the issue of incompetence, I am struggling a little bit with that, only because I am firm on the rule of law, on a fair hearing, and one getting a fair trial. The thing with incompetence is that there's a thin line, there's a fine line between is the person just incompetent or are they corruptly incompetent? So that when you go to the JSC and you want to make a complaint that this person, the corrupt incompetence is what motivated, it's the proof that becomes very hard. But I think if there is proof and you can actually sustain it the same way we do with fraud cases where the requirement is a bit harder, you ask for what are the particulars of fraud, you find that it's not that easy to find those particulars. But where you have the proof, then the JSC should be able to process it and show that this is not a question of you being ruled against on the basis of the law. This is now a question of this judge just not knowing how to handle their job. And then on the last question of getting support from politicians, I don't have any support from any politician. And I think it's a good conversation for us to have right now. The LSK should figure out or create a mechanism for how to support aspirants so that we keep the campaigns clean. Right now, I ask myself how people are affording to move around the country. It's like a presidential election. Where are you getting this money from? Going around the country and plying people with goods and alcohol. I think it then weakens. It's weakening our society, and which is why we have become a political handbag, a tool that is being used to peddle influence. I don't have support. It's very expensive. I wish you guys can reimburse me for showing up today. If I had known that it was open to debate online, I might have taken that option. But thank you.
Thank you so much, Julie. Ms. Aoko Tieno, can you hear us?
Yes, I can hear you.
Okay, thanks. I believe you have a grasp of all the questions that we have laid out. So this is your time.
Yes.
Thank you.
Okay, thank you. On corruption, I wish to point out that we have the small corruption that happens in the registries and the big corruption with now the Superior Court's judgment. So there have to be different strategies for them. One, I would say we review procedures at to do with how fast should an interim order be signed, extracted and signed. How fast should we have proceedings and proofreading done? So once we review these procedures and put in timelines, we will definitely fill the gaps or the gaps for corruption, because a lot goes in these three procedures, immediate procedures that we do at the courts. Secondly, I would say now for the judges and magistrates, the JSC should actually just grow some teeth and fight. But that doesn't mean that the judicial officers or judges who have complaints before the JSC should not be heard. They should be heard. It should be a just and fair process. But however, I am representing a few officers at the JSC, and most of the time, these complaints are just complaints without proof. And so you might be out here saying, oh, JSC just lets it go scot-free, but you need to prove. Yeah. I would also say we should review our recruitment procedures. I mean, over-reliance on healthcare clearance certificates or the debt thing do not give us the best persons. I know in the USA, if you qualify to be a judge and you had some debt you haven't cleared, they will assist you to clear that debt. So that will not hang over and make you lose 70% of your marks, and actually you are competent. Then, also, we have known that in this country, the area can just refuse to give you clearance. And those are the first things the JC is asking for. So we end up putting in people who are, leaving people who are highly competent for these positions and putting in others just because they have those clearances. So we should review and not place over-reliance on those kinds of certificates. We also need to recruit more judges and magistrates. Why am I saying this? This will avoid litigants or advocates trying to pay registry staff so that they can get their matters mentioned or they can be given dates. Right now, the Court of Appeal we've had where the dates are, even at the magistrates courts, almost all courts, you know, they have further dates. I think maybe just a few courts can give you a date next month or in May. So if we recruit more judges and magistrates, we will be able to at least sort out some of the corruption. Then we also need to fully embrace and invest more on technology. Once we invest on technology, like for example, why shouldn't our summons be signed with a digital signature for a deputy registrar? Because we are already filing the e-filing, so why should we rely on hand signature? What's there in the summons to be verified? I mean, it's a document that has been prepared by the advocate. All that needs is signature for the DR. So we should fully embrace and invest on technology. That will eradicate like almost 3/4 of the corruption that is going on. And I would also actually say that members of the bar should make use of the bar bench to resolve some of these things. I remember in one session I have worked in, there was some few corruption cases here and there, but we just started the bar bench
Sorry, have you had the bell? The bell has gone. The bell has gone.
I have 10 seconds.
That is the third time they're ringing the bell. I understand because you are appearing virtually, so sometimes you may miss the notification from the timekeeper. But the bell.
Can I continue? 2 seconds.
I have given you 5 seconds, please. 2 are gone already.
Okay, thank you. On the issue of incompetency, JSC should again just grow teeth and bite and send such judicial officers home. I agree with you, there are some judgments that actually below par. My friend Julie was talking about innocent, incompetence, and induced incompetence. Incompetence is then the code of conduct. We should actually uphold the code of conduct, and JSC has been failing on this. On the issue of if I'm receiving political funding, I'm not receiving any funding. Funding is strictly from myself, and that is why I'm operating a very lean campaign. And I could not even travel to Mombasa to Kisumu. I was the first one to ask for a link, and I detest and I would advocate that in future candidates should be barred by the elections board of the LSK from receiving funding from politicians. As Julie has pointed out, our friends here, it's just me and Julie who have not colored the whole country with campaigns. We could not afford to travel all over because we don't have that funding. So thank you very much for inviting me and giving me this chance.
Yeah, it's important to clarify that's okay, but it doesn't mean that the others are receiving support from elsewhere. It could be that they're just well enrolled or unbudgeted. That's a possibility. But of course, we appreciate your position. Last but not least, Jacqueline.
Thank you.
Please proceed.
Yes, thank you, Senior. Let me just begin with the last question on whether I'm receiving any money from politicians. My son, 15 of us, we have a communication specialist who is handling all my communications. The branding, it's my sister. So that is an asset from 15 children. A meeting, and my father directed all of them to remove a particular amount of money. So money from family. That then enables me to move around the country. The Kisumu chapter has really supported me. The launch that was here in Kisumu was a courtesy of friends and colleagues from Kisumu. I'm also not very poor. I have some money. I drive a Prado, to walk around the country. And I also have friends who have vehicles, big vehicles, and they give me drivers and I move around. So, and I like what Elisha Amboya said. If we don't do that, then we find ourselves electing people who are not deserving those positions. It's a history that has been there. I'm not proud of myself moving around. It's tedious. I have to be away from office. But if I don't go out and look for the votes, then no one will know Jacqueline Nguti apart from Kisumu colleagues. I had to travel so that at least Jacqueline Nguti is known. No politician has given me money. By virtue of my office, I am apolitical. Some of us are paid by politicians. The work that they do, in as much as they are using their personal money, but it is money paid by politicians. So we also need to interrogate that particular issue. On corruption, allow me to respond to the issue of corruption and incompetence. The code of conduct is very, very comprehensive. It prohibits judges, judicial officers, and staff from engaging in any form of corruption. And as senior, you had rightly put, the issue of professionalism is also a provision under the code of conduct. The problem with the code of conduct that it requires regulation to implement it. If you look at the decisions that have gone before the High Court, review or constitutional petition against JSC decisions, the issue the courts have held time and again is procedural flaws. The JSC does not have procedures of investigating or disciplining judges, magistrates, or judicial officers, and the judicial staff. And this has been ongoing. Every other time a matter goes before the High Court, it's the same thing the judges keep saying. And I'm happy with the decision of the Supreme Court, Gladys Sholay. It directed the Judicial Service Commission to come up with procedures of investigating or undertaking disciplinary process, and that is agenda number 2. In my agenda number 2, I have clearly indicated that we need procedures. If we do not have procedures, we will forever be running around complaining that we are not able to fight corruption. So procedures must be put in place to know how to approach JSC, to know the nature of complaints JSC can handle, and thirdly, to guide the JSC on the timeline within which they need to hear and determine complaints, including complaints on incompetence and complaints around corruption. Maybe you could allow me to just say the issue of incompetence. We need to balance incompetence and decisional independence. And I agree with you, some of these decisions, as my senior Ahmed Nasir said, some of those decisions are crime scene on their own. So we also need to interrogate the same. And that's why I believe I'm the best candidate, because I already know the problems within JSC that must be handled when it comes to complaints, including corruption and incompetence. Thank you.
Thank you. Thank you, Jacqueline. We are coming to the last segment of this debate. And we are going to give the candidates an opportunity, 1 minute each, to ask questions to any other candidate, something you think is material. I am aware that sometimes this can get a little untidy, but I know we are all going to be civil. I don't know what that means. I'm told that some people know how to do it, just to emphasize a point to send a message. So in case any of the candidates has a message, has a question for another candidate, this is your opportunity, and we are really, really short of time, so we will give you a minute. And please do not try to embarrass anybody. Let's stick to what is material to the competition. I'll start with Pauline. Do you, Christine, do you have any question for any of your colleagues?
Yes, can I ask 2 candidates or 1? Or because of time? Okay, my question goes to Jackie. When we were on Twitter Space, she said that she has a problem with the fact that I suggested that Judicial Service Commission should advocate or promote traditional justice system. I did not understand why she has a problem with the issue of dispute resolution mechanism that is provided under the law, and even these policies that have and the framework of AGS. Thank you.
Good question. Decent question, Jackie.
Thank you, Christine, for the question. My question that I asked that day was not in relation to me being against traditional justice system, because it's a constitutional provision. My question was, you are representing lawyers, they are your constituents. We have a representative from the member of public who is picked by the president. Let that member of public agitate for the need of including traditional justice system. For me, I have to ensure lawyers have work, and I cannot say I'm supporting traditional justice system, because when you do that, you're removing bread and butter from lawyers. We need to have proper courts, we need to have courts across the country, we need to have efficient judiciary. If you have efficient judiciary, we have more work as advocates. But if you agitate for AJS across the country, we will all close shop and go home. And that is what I was saying, as a representative of the Judicial Service Commission, representing lawyers, that cannot be an agenda you want to advance. And if you're going to advance that agenda, then members, she's not the right candidate to represent us.
So can I answer now that she has clarified? On Twitter, we had like a minute or 2. I was not able to answer the way she has clarified here. Yes.
I think in all fairness, let's give you an opportunity to respond to.
Yes.
Yeah, to what Acacia said. You have understood her point.
Yes.
That because she's going in as a representative of lawyers, she wants to stick to the agenda of protecting the interests of lawyers, and she does not think that what you're suggesting is something that is good for the lawyers or that will help the lawyers.
Okay, so this is the clarification I want to give Jackie, because she seems not to understand it, even at this point. Traditional justice system is provided for under the law, yes? And when I go to the JSC as a representative of the 20,000 lawyers we have in this country, I'm going to sit in the 11-member, board and make decision as Judicial Service Commissioner. I'm not going to be like a segmented person, but the decisions will be coming out as JSC. It's a collective responsibility. So the issue of promoting, traditional justice system as its place, the small courts system as its place, the chief magistrate as their place, the court of appeal, all the justice system as its place. So you cannot say the person who has come from representing the members of public or appointed by the president or appointed by the other organization or the courts is the one to advocate for a particular issue. We will have no coordination. We will not have complementary support of one another because we are seeking justice as the Judicial Service Commission. I am the right candidate. I analyze issues and come up with a solution. Thank you.
I get your answer. I think it is for the members now to judge. Yeah, the responses, okay? Any other candidate who has a question for a competitor? And let's keep it the same way. I think Christine and Jackie have set the tone for this. I was a bit worried that it might get out of hand.
Now we are civil. The ladies are very civil.
The men are watching. Any question, please? Anybody who has a question for a competitor? Well, I will assume that that is that. And oh, sorry, Miss Jen, I would have blocked you out, but because you're senior to me, I will allow you to put your issue across. Yeah. Yes, quickly, one minute. We are late.
I really don't have a question. I just want to wish all these.
That is great. You should start also by wishing yourself luck, and then everybody, as they say, help yourself first before you help others. Thank you. I think
that as they go home, they may just want to vote for me.
Thank you. The message is home. The message is home. We are done, and the last, the very last bit of the debate before we call it off. Start with Christine. 15 seconds strictly. Timekeeper, I'm very serious about this.
Well, okay, thank you, moderator. Dear members, and I take this opportunity to say thank you for have you listen to us. It was good to have the questions that were raised by the moderators. I believe they came from the members. And my parting shot is the issue of what I will do. I've said it's a 3 for the one we use in our houses. That one I will not run away from. Secondly is a complaints resolution mechanism. I will not run from it. And the last one is the establishment of strong bar bench committee that will be able to resolve your issues as LSK members' welfare. You have seen for 1 year, we did not have a representative. What has happened? Silence. We need to break that silence by giving you feedback and giving you good reports every now and then. Thank you very much.
Thank you.
Vote for Christine Kipsang.
Thank you very much. Julie?
Members of the bar, the JSC has 11 commissioners. 2 slots are provided for the advocates to protect the interests of the advocates, not to advocate for the entire country. Those interests are already protected by other members. We need a voice for the bar. We need a clear and independent voice for the bar. We are the minority in the JSC, yet we are the largest stakeholders. It requires independence, and it requires an ability to know what your responsibility is in that JSC. I have the qualifications. I have what it takes to represent and advocate for the advocates within the JSC clearly and independently. We do not need other people who are speaking for other interests or for the state. I ask you to vote for me.
Thank you. Thank you, Julia. I think everyone is keeping time.
Thank you.
Yes, Jackie.
Thank you, colleagues, and thank you, West Kenya chapter, for the opportunity. Colleagues, this is my 16th year of practice, and I have been consistent for the past 16 years on issues around access to justice. I have been consistent in litigation. I do understand issues that affect you in litigation. As a hybrid lawyer, I do understand when the corporation secretary is sweating in the boardroom, trying to explain to the board as to why they cannot lift up court order because of backlog of cases. I have served members in different capacities. I have represented you well, and there is absolutely no way I'm going to do the wrong thing at the Judicial Service Commission. I do understand the different roles of the three institutions within judiciary. That's the judiciary itself, MCAJ, and also the Judicial Service Commission. I am going to represent you to the Judicial Service Commission, but I will also work with other members who represent LSK in MCAJ, that is the President and Babbage Committee. We cannot take this to chance by giving someone who is going to continue litigating and intimidating judges. We cannot give this to someone who has not litigated. And I'm the best suitable candidate to represent you. Thank you.
Thank you, Jacqueline. Aoko Otieno, miss. 15 seconds, please, strictly.
I'm the best suited candidate for this position. This is because we need a firm, strong, and independent voice at the JSC. Currently, we have none. I have a track record of being very passionate and an active member of LSK. The past has shown us that if we just elect people who come last minute and say they don't want the JSC position, they disappear after that. And I'm the only one who has undertaken to serve the society diligently, to be accountable, accessible, to avoid conflict of interest, and serve only one term. We find some of my colleagues today, they are conflicted because either they are public servants or they are serving in a tribunal which is under the judiciary already. So I do ask for your votes on the 10th. You vote for me because I am the best suited candidate for this position. Thank you.
Thank you. Thank you. Thank you very much. Thank you very much. Ms. Anna Konuche, it's your turn. 15 seconds strictly or less. You are parting short.
Thank you so much, moderator, and thank you for the members who have attended this session. I would like to urge the members of the Law Society to vote for me for responsive representation with diverse skills. I am an all-rounded person with rich profile. I have been very active in the Law Society. I retired from the Advocate Disciplinary Committee just last year, having served for 3 years diligently. So I attended all my hearings and wrote all my judgments. I have previously served in committees in the Law Society, including the Editorial Committee. I have participated in public interest litigation that involved the society, and I am qualified for this position. This is a position that is part-time, and therefore you are allowed to hold another position as per the Constitution, because this is a part-time position. You don't have to be a full-time member at the Commission for you not to hold another position.
Thank you.
Finally,
finally, Anna. Thank you. Okay. Last but not least, Mrs. Jane Jagi, though you had said goodbye, but I'll give you a chance to say something again. Just 15 seconds, please.
Then I want to thank you all for this participation, but I'm persuading all my colleagues to vote for me. I am the most experienced. I am the most, I've been practicing for a very, very long time. I am independent. I am fearless. I will put the advocate's interest at heart, and I use the word I shall stand with you and ensure that the Judicial Service Commission is transparent, independent, and effective. Thank you very much.
Thank you very, very much. And I think, ladies and gentlemen, to took part in this debate today and our candidates. We wish to thank you for creating time to attend. We have been enriched by your responses to the various questions put to you, and we wish each and every one of you all the best. May the best candidate win. And thank you. Thank you. I think it is in order that we give them one round of applause. You are free to leave, but you will remain there because a bigger one is coming. Yes. Bigger and hotter.
Members appearing virtually, we are quickly transitioning to the presidential debate. We should be starting in 5 minutes. All the presidential candidates kindly prepare yourself and move forward.
While we are on a 5-minute break, I wish to invite the other representatives vying for the various positions here present. Their names.
The moderator is calling upon all other contestants for the other positions as we await the presidents to come in. Position. Other than that of the president and JSC, you can have them and tell the members what you're contesting. Please don't tell us your manifestos and all that. I think most of us have read in time. Thank you. Okay. You don't want to go fast.
Good afternoon. Thank you for indulging me for 1 minute to listen to me. My name is Matthew Zohor. I'm an advocate of the High Court of Kenya. I'm currently doing my 12th year in practice. I have been mentored by some seniors who went ahead of me and who can vouch for me. I've worked under Mohamed Mugai and I've also worked under Professor Tomo Jenda before I set up my practice. Currently I'm based in Nairobi and I also have a branch in Mavoko, Machakos. I kindly seek your mandate to serve you as a general member representative. I have what it takes to serve. Other than just my experience in litigation, I hold a master's degree in corporate finance from University College London. So I believe I'm best placed to address the corporate governance issues that we currently grapple with as a society, among other things. Thank you very much for your time, and please vote for Matthew Zokot as a gentleman.
Thank you very much. Through the chief moderator, all protocols are observed. My name is Jacqueline Wahenya. I'm an advocate practicing in Mombasa, and I am seeking your vote for the cost to availability into the profession that is standing on all the pillars in Section 4 of the Law Society of Kenya Act. I have a lot of competencies. I am a fellow certified secretary and also a fellow of the Charter Institute of Arbitrators. I am conflict competent and I have the qualities to be part of any team that will be running the Law Society. Thank you very much for this opportunity.
Odia James, welcome.
Good evening, members of the public, my colleagues, and our protocols observed. My name is Jane Odia. I am an advocate. My name is Jane Odia. I'm an advocate. I'm vying for Nairobi Rep, LSK Council. I seek to join the council or to join the LSK governance to bring in my expertise. I have 15 years in the civil service. I've practiced for 11 years, and I would like to ask the members to vote me in. My agenda topmost is regarding the protection, promotion of the advocate sphere of practice. A lot has been lost, and I'm praying that we can go back to the drawing board as advocates and be able to protect our practice, or rather to protect our bread and butter. Kindly vote for me. I'm not a very young girl, so I would also like to bring my age and bridge between the young and the old. Thank you very much.
Is there any other candidate I have left out? Yes, please. Very good.
Good afternoon. My name is Philip Omoiti. I'm an aspirant, Philip Omoiti Wasindu. I'm an aspirant for the position of Nairobi representative. It's a pleasure to be here in Kisumu. I will not go into much. Mine is, my agenda is simple. Deals with practical issues, issues to do with our daily bread and butter, issues that we face in our daily practice at court, at the land registry. So issues at court registries, issues at our land registries, and finally issues to do with the general welfare of advocates. I have had an opportunity to interact with most of you. I have had an opportunity to explain what my agenda is all about, and I'm humbly praying that come 10th of March, you vote for me as the Nairobi representative. Thank you.
I wish to call to order. We want to proceed to the next segment of our debate. And this segment is for those contesting for the president of the Law Society.
outside to comments, but we proceed. I welcome. In the interest of time, let us hasten.
Set the ground rules before we begin. so that we are on the same page. First, the debate will include questions from the moderators. We will be joined by the audience who are present, and we will have questions from the online audience that will be put to the candidates. Candidates may not use any type of technology during the debate. We have requested that a notebook and a pen is provided to the candidates, but if you have some notes in preparation for the debate that talks about what if you have some notes, you may be allowed to refer to them, manifestos and that kind of material. Time limits on statements, answers, rebuttal, and responses will be enforced by the moderators during the debate. The candidates and the moderators will remain at their designated positions, and no participant may touch any other candidate during the debate. You will wait to be recognized by the moderator or talk over someone else who is speaking. Do not embarrass yourself or disrespect others by making demeaning or inappropriate comments, facial expressions. No eye rolling. I think introduction. The questions that will be posed for all candidates, you will have 2 minutes to respond to the questions. We will have a session where you will be able to ask one another questions. Thereafter, you will also have an opportunity to give closing remarks. The time for our debate will be 2. Moderators have divided that time. That's why when I say you have 2 minutes or 3 minutes, that division. Who has any question, clarification, or a concern? We share the mics.
Madam Chair, one of the moderators, I don't know whether this is critical, is my classmate and the head of our class in first year. I don't know if that would be favorable to me. I need to disclose this so that Mr. Omanza would not complain that I was favored by my classmate.
Thank you for raising that. Perhaps that is a question that would be directed to the Mr. Heuli. The questions are standard, I think, to all of us. So I don't think there's any issues there. Ms. Tanya Bena.
we were a judge, I could still do a case before him, so really no problem.
Most welcome.
Thank you for that. Any other concern, question, clarification? Thank you. I would invite Madam Rauto.
She's stepped out, but I can get.
And you've agreed to share the mic. Yes, ma'am.
Colleagues, we had allocated 3 minutes to introduce yourselves and tell us about your vision. In the interest of time, do you think that is time or is, let me not ask if it's late. But I was wondering whether we could do it 2 minutes. Or is that beyond commitment? Please. Okay, thank you. I was trying to get 2 out of you, but it's fine.
A big thanks to our presidential contestants who are present today. You had to come from very far and abandon your duties and other engagements and also campaigning to hit our call and come all the way to the left side. We appreciate your presence and coming today. I had already said so much in my opening remarks, so I'll quickly proceed to declare the presidential debate for 2022 LSK presidential candidates, West Kenya Law Society branch, open. Thank you. Back to you, the moderators. Mr. Tieno. I'm being reminded to quickly introduce the moderators. I would repeat because I've already done it, but it's for the benefit of the presidential candidates who are not in. On this end, we have Ms. Maureen Odek. Ms. Maureen Odek is the chapter chair, Kakamega. That falls under the West Kenya branch. The only gentleman among the 2 ladies, that is Dave Otieno. Dave Otieno is a senior colleague of ours based in Kisumu, 25 years of experience, a senior partner Oichi Otieno Ragot. Then the far end, the smiling, beautiful lady, that is Dorcas Sakinyi. She's a very experienced advocate. She also practices in Kisumu. She's a senior partner at Asuna, Styles Asuna and Oluoche Company. Those are our today's moderators. We're going to deal with you perfectly. Thank you.
Okay. Ladies or gentlemen and a lady, our immediate former VP, good afternoon. Welcome to Kisumu. Thank you for creating time to come to listen to what the membership of West Kenya branch have to say about or some of the concerns they want to clarify as we head into these elections. We have had a difficult past 2 years or so, and I think all members of the Law Society of Kenya are looking forward to the day when we will be able to clean ourselves again and start on a new slate. So we welcome you. You, under the act that creates the Law Society, one of the things that you are required to deal with as our council by statute is to deal with issues regarding practice and welfare of members. And for this, the statute has created branches, including the branch in which it is hosting you this afternoon. Now, we know that now we have devolution. You have the obligation as our council members to advise government on matters of law, and but now we have devolution, and you are aware that in addition, or other than the laws being created in Nairobi in Parliament, the two houses of Parliament, now we have legislation being created at the county levels. Okay. We have legislation being created at the county level by the county assemblies, and I think it is the reason why I send this question is because I realize that this is an area that we have, or we appear to ignore. Yet, we are now required to look at what the county assembly. Sorry about that. First, my apologies. I think I've missed out on a very important segment of our debate. Before we go into the real issues, I overlooked the need for you to introduce yourselves and tell us why you are running, what it is that you want to do, what you want to bring into the society, or what you want to improve for the benefit of members of the Law Society. My apologies for not having given that opportunity. I think I will start with Mr. Debate.
Thank you very much, David. My name is Matthew Yabena. I've been an advocate of 21 years standing, admitted in 2001. I'm 46 years old, born and bred in a family, big family. I'm child number 9 out of 11. I'm part of the younger ones in the family. So that one has made me learn to speak less and listen more because I grew with my elder siblings. In my younger life, I was actually a herdsboy, taking care of my father's animals, and out of which I learned the art of unity. Because when you work with the herd with strong fists, they scatter. But when you learn the art of unity, you learn to speak with them, they come together. No wonder even in the Bible, herdsboy and shepherds were called upon. I believe in letting everybody be involved. I believe I have worked as for 4 years. I've worked in the branches caucus for 2 years. And I've exercised this. And even in this campaign, some people ask, why is Nyabena not being loud? I like listening more and allowing other people to set the agenda. To practice. I have done many things. But as chairman, when we heard about the small claims court barring advocates from appearing, I led a team in Mombasa Law Society. We filed a suit, and in the process of that suit, there was an amendment to allow advocates to appear. But I wish to report that that suit we allowed it to go to the very end because we were worried about the right of appeal, which was only to the High Court. Likewise, when the Work Injury Benefits Act came into force, I led a serious team in Mombasa. We filed a suit, which we won. But when we advised on how to deal with the case at national level, there was a challenge, and along the way, I had to go to the Supreme Court to try and solve this issue. I'm passionate about matters practice. You are not going to elect somebody who is saying he will do. I have done, and I will continue doing this to ensure that we get justice. In addition to being a leader, I'm an elder of the Seventh-day Adventist Church. Tomorrow I go back to church, retreat, and seek spiritual nourishment. So when I talk about unity, it's not what I possess. It's also biblical. It's in the Quran that people should exist together. I let others shine, and I lead by example. So I'm bringing to you an opportunity because we have done things the same way. We have elected the same leaders. It is time to change. And I believe I present the most drastic change for the Law Society of Kenya. My colleagues, 3 of my colleagues have served before in the Law Society of Kenya, national office. Just remember how they served. If you think they served rightly, please elect them. But if you feel you need a change, look at Matthew Nyabena, a new character. I have never run for national office. This is my first time. So as my slogan goes, united we stand, one team, one LSK. I present you this gentleman myself and humbly seek your vote. May you hear me and enter judgment as prayed on 10th of March.
Thank you. Leave their mic.
I think now we're fine. Thank you, Mr. Nyabena, for that introductory speech. I think next we go to Mr. Ngetich.
Thank you very much, Senior Mr. Uma. Ladies and gentlemen, members of the West Kenya branch, good evening. My name is Arap Ngetich Kipkoech Bernard, an advocate of the High Court of Kenya for the last 14 years. I am based in Nakuru since I was admitted in the year 2008. I've had the occasion to serve as a branch chair of the Rift Valley Law Society 2012-2014 after serving previously as the vice chair and council member. I have also served at the national level as an up-country representative from the year 2018 to 2022. I am running on a track record of several accomplishments. I would only wish to mention 5. One, in 2014, as the chair of the Rift Valley branch, I was able to arrest, after meticulous investigations, a quack advocate who was convicted, and I think he relocated to Malindi, but we got hold of him and smoked him out of Malindi. As the branch chair, I intervened when Charles Olesena, an advocate in Narok, had been arrested for doing a sale agreement where the land existed, the seller existed, the purchaser existed, simply because the magistrate and the prosecutor thought that somebody had to be punished. Luckily, the High Court, through Lady Justice Ellen Omondi, as she then was, watched those proceedings. As the up-country rep, I have also been able to arrest a quack magistrate last year in Nakuru. The gentleman, as we're talking today, is at Nakuru Chike Remand Prison, awaiting the wheels of justice to roll to ground slowly. It involves more than 20 million shillings. I've also been able to push vigorously for judicial calendar, and I filed the case of Elfish, Odirananda versus JSC and CJ, where the High Court, through Justice Macau, said, yes, judicial calendar on workshops, on colloquiums, should be circulated among as judicial officers and court users. However, they are not compellable. I am pursuing this in the Court of Appeal. Finally, on public interest litigation front, I have been involved in the case of Mumo Matemo in the Court of Appeal, which has set the threshold for Chapter 6 of the Constitution and the peculiarities of filing a petition. Ladies and gentlemen, if elected to be the president within the first 1 month, I want to reduce CPD fees from 1,500 to 1,000 by persuading council, waive certificate of good standing from 2,000 shillings to 0, because once you paid your PC, once you paid your CPD, you're already in good standing. And finally, I would want to do Truth, Justice and Reconciliation Commission, where the brave new bar, age limit must fall, or call LSK, and all of us would come together. We identify the root causes of the troubles bedeviling the Law Society of Kenya, we forgive each other, and we move forward. I am running on the clarion call of a sober bar, and I am asking all of us to come together. Let us rebuild the Law Society of Kenya and have a sober bar for the future. I am an elder of AIC Kenya. I'm also a Sunday school teacher, as well as a sponsor for the youth and the Sunday school. Thank you.
Oh, this is a big debate. We have men on the clock here, many of them. I believe Eric Girish will not let us down by saying he's not one. Thank you so much. The only lady among these very powerful men, Ms. Caroline Kamende. The floor is yours. 3 minutes, please. Thank you.
Thank you. My name is Daudi Kamende Caroline. I have been an advocate of the High Court of Kenya for the last over 16 years. I have practiced both in the country and also internationally, having been appointed by the United Nations as the legal assistant in the ICTR, International Criminal Tribunal for Rwanda, to undertake the special positions. I run a law firm in the name and style of Kamende DC and Company Advocates. I have served the Law Society as a Nairobi representative. I am still serving as the Vice President of the Law Society of Kenya. My scorecard speaks for itself. I am the champion of welfare in the history of this Law Society. There's no single advocate in this country, over 19,000 advocates who can say that they have reached out to me for any cause and have failed to take it up. As you can say, as you've said, I'm the only lady here. I am a woman of fasts. In the history of this Law Society, there was no single sexual harassment and anti-bullying policy. That is my baby. It was born in this hall. I am the person who established free toll lines so that advocates can reach us in all the 8 branches and in the national office. Those lines are on 24 hours. All the branch chairs who are here can confirm. Susie can confirm. Even West Kenya has one. I am the person who came up with the emergency and endowment fund. That fund has seed money of 500,000 shillings waiting for me when I ascend as the president to execute it to finality. The reason I came up with this is because my phone is always full of requests for assistance, financially or otherwise. So I came up with structures to ensure that advocates who do not have my number can reach out to the society through the free toll lines and also can benefit from the endowment funds. I am also the person who established good working relationships with the police. Along the way in my 16 years, both domestically and internationally, I have created a network. There's no single advocate in this country who has been in conflict with the law, who has been arrested or harassed by authorities that have not been able to assist. What do I bring on board? I come on board having had experience in service to the Law Society. I wish to continue protecting the practice of law in Kenya. I happen to have been in the council where we shone in the rule of law. I will endeavor to ensure that we continue with advancement of the rule of law. We are in an electioneering year, so it is the duty and mandate of the Law Society to provide checks and balances to the executive, legislature, and any other arms of government, as well as defend the Constitution and the judiciary. Lastly, I want to ensure that there is independence, accountability, and transparency in the Law Society. Most of those issues that arose in the last 2 years were as a result of lack of an independent, accountable, and transparent LSK. Thank you, ladies and gentlemen.
Thank you so much, Caroline. The only thing that you missed out, I think, was to say you are a praise and worship leader. You know, they have set the tone.
Yes, I am.
I'm sure Mr. Mwanza won't disappoint. The point is.
Yes, good evening, friends, colleagues. My name is Umwanza Umbati. I signed the role of advocate in 2004, and consequently, I have practiced law for the last 18 years. I've heard what my friends have spoken about, and I've listened to them for the last 3 weeks. I've also gone throughout the country to listen to members and what they want as a new leader of the law society. The first attribute that I have as a president is that I'm cool, I'm calm, I'm collected, but also have fire in the belly. If you need your president to stand up and breathe fire, I'll be that president. But most of the time, I propose to be a peacetime president. And the most consequential presidents in the last century are peacetime presidents. They're the ones who rebuild after war. And I take this example from President Roosevelt, who came with a New Deal, and then I have a deal with you as a society. Now, in running for president, I believe that what matters is competition of ideas. Now, in the competition of ideas and in providing solutions to the law society, I believe that I present the clearest vision, the most sellable, and the one that gives solutions in terms of what bedevils us as a law society. Now, I have identified briefly 4 issues that I think are the most consequential challenges that face us as lawyers. Number 1 is the unity of purpose that all of us are speaking about. Unity of purpose. Meaning that for the last 4 years, that is, in the last 2 councils, we've had a problem of unity. That is an issue that needs to be sorted out quickly. But I've again heard what my friends are saying, and I think that the solution is beyond what President Moi used to say in terms of peace, love, and unity. It goes beyond that, because the challenges of the law society are more. The second challenge is on a large bar, large young bar that is restless and that presents unique opportunities that need to be addressed. Between 1 and 5 years now constitute about 65% of the bar, of those who are in the bar, and we need to address that, and I have solutions for that. The third challenge is on technology. Technology and what has happened post-COVID, and there are studies which have demonstrated that in the next 5 years, 5 to 10 years, 20% of our work, of legal work, will be taken over by automation and robotics. That is an issue that I intend to address going forward. And the last issue is on our practice space, which has been stifled either through legislation, court decision, for instance, on WIBA, legislation, for instance, the Proceeds of Crime and Money Laundering Act, and other professions who are eating into our practice space. So those are the issues that I propose to address as the president. Now, going forward, what is my track record? I have my track record with the involvement of the Law Society actually began in Kisumu as a young man. I remember Justice Gisheru issued a direction that cases, constitutional and JR cases will only be filed in Nairobi. I was instructed by friends from Kisumu, Olel, Onyango, and Mamo to file a case. We filed, and out of that pressure, Justice Gisheru revised that. As we continue with this discussion, I'll be able to present a clearer vision, and you'll hear me, and I stand for a strong, united bar, but I also offer solutions that are beyond mere rhetoric. Thank you.
Thank you very much, Mr. Mwansa, for that, for those opening remarks. Last but not least, we give this opportunity to Mr. Eric Perry to tell us who he is and what he wants to do for us. Thank you. Karibu.
Thank you so much. Good evening, friends and colleagues. My name is Eric Theuri. Currently, I serve you as the chairman of LSK Nairobi. I have been in practice for the last 17 years. I am very closely associated with the Western region, having done my pupillage in Kakamega, grown up, gone to school in Kakamega, so have a lot of fondness for this area. I am also an alumni of Moi University and currently the vice chair of the Mosul students alumni, which we are currently setting up. So I ran for the office of president on 3 pillars. The first pillar is on expanding and protecting our practice environment, where I propose to ensure that we put in adequate structures to protect the work environment. And as we do that, we engage at the Secretariat in a manner that responds to the challenges that we face, and so that we can be able to create a Secretariat that is focused on the members, a Secretariat that is sober in its approach, and most importantly, to ensure that we champion the defense of the rule of law. I believe that the most important duty of the society is to act as a watchdog. And in an environment where the rule of law is observed, then lawyers will thrive. In an environment where advocates are free to represent clients and are not associated with their clients, then the advocates would feel safe in their practice. When we address the economic challenges that we are facing, then advocates would feel safe in their practice. When we address the practice bottlenecks and ease those bottlenecks, then advocates will have a thriving practice. And so my mantra is to create a law society that is inclusive, thriving, and where members feel that they are safe. I have served you before in council. I have been a member of the Young Lawyers Committee. I have been a member of the Welfare Committee of the Law Society of Kenya. I have been a member of the CPD committee, and through those engagements, I have interacted with the issues that affect most of us. Lastly, in the year 2018 to 2020, I was the co-convener of the advocates, the Police Advocates Relationship Committee of the Nairobi branch, where we developed regulations in terms of engagement between the police and advocates. But unfortunately, for one reason or the other, those regulations were not implemented. And so I come to you on the back of a track record of committed service to the society.
Thank you very much, Mr. Deuri, for giving the final word on that segment of the debate. I want to ask or raise an issue that is connected to something that Mr. Mwanza and Mr. Deuri have said, and which I think all of you will be eager to address us on. It is about protecting our practice space, which I think is one of the core mandates of the LSK, and to look into those areas that have eaten up our practice. Mr. Mwanza said they include technology, they include legislation, and precedents that has been set by the courts. For those of you, or those of us who work for parastatals, for example, and state corporations, you are aware of the directive by the AG, which has gone to court, and in respect to which the court has rendered an opinion. I think it was in 2019, but then the government, as usual, ignored it. And I think the unofficial position, or should I call it official position right now in government, is that parastatals, state corporations, and other government agencies can only use in-house lawyers. And the situation is so bad that they have, I think, a requirement in that circular, in that infamous circular, that they need to obtain permission from the AG to engage an external counsel. But for those of us who have tried, there is then the unwritten rule that such permission will not be granted. I understand that the response from the Solicitor General is normally a one-line letter, a standard letter, that permission denied, use in-house counsel. I want to know, because this is important, it is restricting the growth of practices. The big law firms that relied heavily on work from those entities cannot employ the young lawyers coming out of school of law and cannot pay them decent salaries if they do engage them. I would like to know from you, how do you intend to deal with this problem? And I want you to remember how difficult it was to get the government to accept to swear in those judges, despite numerous court orders. I don't know whether you want to propose to have tea with someone, like the CJ said when she was appointed, to get this thing out of the way, because it is really becoming a huge problem for many of our practices. So I think I will start, I will pick randomly, and I will start with the gentleman who actually raised the issue in the opening remarks. Mr. Omwanza, you go first. Then Mr. Theuri will follow, then we'll go this way.
That's a pertinent question. How do we deal with, especially the opinion by the directive by the AG that you can only get work from corporates, corporations, unless he concurs with that. I must acknowledge that Eric gave me those instructions when this circular came out. And we went to court and obtained an order by Justice Matiwo that stopped it. But that just ended that because there is on the 18th of this month, there's going to be a judgment about that issue. So there was a stay on those directives. However, I think that we burnt a lot of bridges, and besides intervention in court, we need to rebuild those bridges and probably use the political tools that we have in terms of reaching out. I remember this action was taken as a consequence of our motion to remove the Attorney General and the Solicitor General from the role. And as I said, you need to use different tools in handling a situation. I believe that one of the ways of doing it is to, in this instance, is to reach out to the AG, to the Solicitor General and the Attorney General, to try and resolve this matter politically. Because I got a counsel who told me that in the last 2 years, we've lost total legal fees of almost 3 billion throughout the country, and that is substantial work. So I think where we need to fight, we will fight, but in this instance, I believe that we need to reach out and rebuild certain bridges, and that is how I would intend to go about it.
Thank you very much, Mr. Omwanza. Mr. Theuri, what's your take on this subject? We have lost 3 billion shillings. I didn't even know the statistics. That is terrible.
Yes, indeed. When the Attorney General issued that circular, we of course immediately understood its implications, and as Mr. Mbati has said, we gave him instructions and we moved to court and got orders to stay. But there is a broader question which we hardly ever ask ourselves. I believe, one, that the best way to deal with it, of course, would be to also engage the Attorney General. But there are other avenues that the Law Society has hardly used, which is international lobbying. In the years when LSK was agitating for the return of constitutionalism and multi-party democracy, they used international lobbying to a very effective extent. And this is one of the things which I intend to do: reach out to the UN Rapporteur on Human Rights insofar as the threat that is caused to the country when the government is not obeying court orders. Because it is a bigger issue, it goes into the ease of doing business, and we can still use the World Bank because they have a ease of doing business secretariat that we have also as a branch interacted with when we were dealing with small claims court, and as a way of lobbying for resources and on other issues related to art disaster. The challenges we've been having with lands, we've used the ease of doing business secretariat to try and pile pressure on the CS lands to ease certain challenges that we faced. So that is all, a method that I intend to reactivate and ensure that the Law Society is able to use all these persuasive methods of intervening with government, because as we all know, the government has a high appetite for external loan, and they always want to maintain a good PR or a good image when it comes to international donors and partners.
Thank you. Pass the mic to Caroline. Caroline. Thank you.
Thank you. For me, if this issue was to arise, I would look at it in two limbs. First, is that directive legal? Secondly, if it's not legal, what should I do as the president of the society? Now, that directive was not the first one. I served in the 2018-2020 Council, and the Attorney General then also issued a similar circular. I remember then I was also affected because I was acting for one of the government institutions. What would I do if that circular, a similar circular is issued? For me, the issue of persuasion is just postponing a problem. If it is an illegal circular, is that directive anchored in law? There's no law that says that government institutions cannot outsource for advocates. So for me, the correct procedure would be to go to court, challenge that, because it was already challenged. Firstly, in the Allen Council, we also obtained court orders, and those court orders were obeyed then. And I think during the COVID season is when another directive arose. So for me, once an order is issued that declares that circular illegal, it is the role of the head of the legal profession, that is the president and the council, to ensure compliance, and if necessary, also pursue the officers who have failed to implement or comply with the court orders with personal liability. If it is a directive that is anchored in law, then that is where the issue of persuasion and also having meetings with the stakeholders comes in. But most importantly, we need to revamp the department, the directorate that monitors legislation. The practice areas of lawyers diminish because we fail, or we always late. We're always chasing wind when there is a directive or a policy or a law that has come to restrict our practice areas. So for me, if we can take, and I will ensure that we take use and make use of Section 28 of the Law Society of Kenya Act that says Council can determine and come up directorates that will strictly monitor legislation so that we don't chase after the wind. That is how I will deal with that issue. Thank you.
Thank you, Caroline. As we answer that question, it would be good to just clarify one or two things based on matters arising from the presentations. Caroline says that we enforce, we pursue the officers concerned. The upcoming presenters, you need to think about a scenario in which the AD says, well, circular withdrawn, but then they have a way of still ensuring work doesn't come to, they can't do that. So you need to think of that situation where the circular is withdrawn, but they negate the order of the court. They will withdraw the circular to avoid contempt proceedings and so on and so forth. But we need to think about a situation in which they do not implement they do not return us back to where we were in terms of getting work from these parastatutes. Thank you.
Thank you very much, moderator. I must say that, as Kara said, This is an issue which has troubled the Law Society of Kenya, I think, for the last 4 years when I've been in council. We succeeded in pushing the first one, another one came. The reason why we intended to remove the AG and the Solicitor General was because of the fact that 41 judicial officers were yet to be sworn in. So I think for purposes of the rule of law and constitutionalism, the direction the Law Society of Kenya to the council was taking was well-intentioned, and it was in furtherance of Section 6 of the Law Society of Kenya Act. Way forward, I think it's good to be extremely pragmatic, and if I was the president of the Law Society of Kenya, I don't think court action would yield much any further. The circular is quashed, as you've already indicated, but you cannot now compel a legal manager in a parastatal to give you instructions to represent the client. What we need to do at this juncture is to rethink our strategy, engage the Office of the Attorney General, engage the Office of the Solicitor General, and say the issue of 41 judges is now moved to a bigger extent because we already have several judgments taking these judges to be sworn in. The President has refused to swear in the 6th, but I think that is an issue now that is beyond litigation. I would be very pragmatic, look for the Attorney General, the Solicitor General. We have a discussion on how to move forward as far as matters of legal practice are concerned. And since government understands pressure, probably as the President, I would pick up the issue of pending bills on constitutional petitions, which run on to billions, and run to court to put pressure on government to pay these. And as a case of win and win, a case of going home with trinkets, the Attorney General then might be willing to reconsider instructing parastatals to give us work, even as they budget to repay. As they budget to repay the pending balances on constitutional petitions. Thank you.
Thank you very much. So your view, Mr. Nitich, is we have tea with the Attorney General.
Yes, put some pressure to do constitutional litigation on pending bills and maybe engage the Legal Affairs Committee of Parliament. Thank you.
Thank you. Elder Matthews Nyabena.
Thank you very much for the question. Actually, this should be a referendum on those of us who have occupied office, what we've done. I've talked about what I did in Wiper. I've talked about what I did in Small Claims Court. Coming to the issue of the AG, when there was a lot of pressure, let me now disclose, this is not known to members. The branch chairs caucus sat, and they say this tension is not good. I reached out to the Attorney General. I was sent, not myself, I was sent by the branch chairs to reach out to the Attorney General, to reach out to the Solicitor General. I reached them. I had a meeting in August 2020 with the Solicitor General, addressed the issues on the appointment of judges, addressed the issues on this practice space. Why did I do so? I believe in diplomacy and firmness. Before you become firm and start shouting from the mountains, you must engage in diplomacy. This is what I've done. Because I understand one thing, you must have goodwill of the officers. As you've correctly stated, they can withdraw the circular, but you don't get work. So a lawyer's tool in trade is a goodwill. If you elect me, I'll try as much as possible to have strategic engagement to return this goodwill. As I do so, I must also point out, my colleagues who have served in council before, I have been, as the branch chair, insisting in our annual conference, we should have a session on the state of practice. We want to discuss very good topics, but we forget our bread and butter. If you elect me, when we have our annual conference, we'll have a sitting to look at how our practice space is being dealt with. So this requires diplomacy and unity. When we go and deal with these issues and we're united, then we are able to achieve results. I'll use CBD. So far we have had very nice topics on CBD, but I want also basic and daily activities of practice to be dealt with. On the issue of swearing judges, we issued statements. I led the caucus to issue statements. So, ladies and gentlemen, what I'm saying today is for us to protect our practice space, we must learn to speak with one voice. When you send me as your president, having united you, we will be able to deliver results. Thank you.
Thank you very much. My next question will be, actually there should be two, but they are connected, so I will urge you to respond more or less like as if it was one question. Now, the training of a lawyer, starts right from the time he joins the university, wherever that may be. Then he then progresses to the School of Law, and then finally there is the admission to the bar. One of the functions of the LSK under Section 4 of the Act is to ensure that those who practice law in Kenya or provide legal services meet the required standards of learning and training. And that is important because you are required to continuously maintain those standards. And that is why the Law Society of Kenya, by statute, under the Kenya School of Law Act, has a seat in the board of the school. I believe you know that. One seat in the board of the school. Now, part of the problem we have with the training, I don't know if I'm right, I believe I'm right, starts from the School of Law. There is a problem of mass failures at the school. Students taking way too long. Because these are people, by the way, by the time they join the School of Law, they're already lawyers, they may not be advocates, but they're lawyers, preparing to become advocates. There is a problem of mass failures at the school. As a result, I know of many young men and women who actually drop out, for one reason or the other. And what happens then is that they start going to courts, small courts all over the country, to masquerade as lawyers. Therefore damaging the image of the society and risking their own liberties and so on and so forth. I want to ask you, and I ask this because we are part, by date of the Kenya School of Law Act, we are part of the running of that school, the operation of the school. What do you think is the problem at the School of Law that results in this problem which has been there for a very, very long time? And what do you propose if you are given the opportunity to serve as president? How will you work with your representation in this board of the school to try to deal with the problem of training at the school? Because something is not right. Something is not right. Our young lawyers, they have failed many subjects in their thousands and in the hundreds, and they end up running away and doing things that are very unethical and which dent the image of the profession as a whole. Thank you. I will start this time around with Elder Nyabena.
Thank you very much. The Law Society of Kenya has a duty to mentor from high school. As Mombasa Law Society, we went to high schools to mentor students. We have a duty to mentor in university, have talks with students at the university, have talks with students at Kenya School of Law and pupils. For example, I know and I can confess, during my pupillage and holding over, for once I thought I should not be a lawyer because it was very difficult. We need to reach out. I'm asking a pertinent question. If a young lawyer is admitted in November, what moral authority does the Law Society have to ask him to pay 21,000? Nyabena, who's been practicing from January to December, paid 20,000. A young lawyer who struggled and at times borrowed fees, we require him to pay 21,000. I think if you elect me, I look either weeping or prorating these fees. On the issue of mass failures, I know Kenya School of Law now teaches Council of Legal Education sets and marks the examination. We need to reevaluate. We need to look again at this dual role and know where the problem is. If there is a problem at the school, we'll be able to solve it. If it's a problem at Council of Legal Education, we need to solve it. We should not make it difficult for young people to join the profession. All in all, what I'm saying is that we need to reevaluate the journey of the advocate. Not only evaluate the journey of the advocate. If you elect me president as part of my mentorship, before these young lawyers get admitted and I go address them, we should be able to create a program when people are gazetted to reach out to them and make them feel part of the law society. We have an obligation not to forget the young lawyers. We have an obligation to reach out, to make them have a sense of belonging. As a young lawyer, I remember senior lawyers who held my hand, looked me in the eye, and they said, it will be well. As elected president, I deliver hope to our young students.
Mr. Mutich.
Thank you very much, moderator. I want to say that from my understanding and experience, Kenya School of Law has done fairly well in terms of instruction. The only problem I have with Kenya School of Law is that it is intense in terms of theory, and it is extremely thin on practice. The problem is worsened by the fact that examinations after Kenya School of Law is set and marked by CLE. CLE, from the way I've been made to understand, has absolutely no synergy with the Kenya School of Law. So you teach at the Kenya School of Law, instruct at the Kenya School of Law, the person who is setting the exams has no idea what has been instructed. I think there needs to be some synergy, there needs to be some collaboration between Kenya School of Law and CLE, and this is what our representative at the Kenya School of Law needs to consider very seriously. On the issue of our younger colleagues, moving around, marauding as advocates in small claims courts and across, I think this is a collective responsibility for all of us practitioners. Let us draw closer to our younger brothers and sisters, let us mentor them, and in the long run, we are going to have a better society. Thank you.
Thank you very much. Caroline, your take on this?
Yes, thank you. There has been many complaints and also highlights of the mass failure in the Kenya School of Law. In our council, we commissioned a committee to come up with a report to engage the Kenya School of Law and the CLE on this issue. A report was tabled to council, but it was not actioned. The problem seems to be, as my colleagues have said, and what the report says, the findings are that the problem is the synergy between KSL and the CLE. One institution teaches, the other one sets the exams. So my take on this is that there ought to be synergy between the two bodies, and as the law society, because these members are churned into our profession, we need to take seriously our objective under Section 4 that says that we need to monitor the standards. So for me, what we need to do is to ensure that this committee, if I'm elected as a president, this committee's report is first implemented. It is still a report that is out here at large. It has not been picked up by the council for implementation. The other issue that arose from that committee is that we do not, as the Law Society, that is, we nominate a person to represent us in the board under Section 25 of the Law Society of Kenya Act. We have power under that section to recall and to ask the representative to give us a report. That has not been happening. So for me, if elected as a president, I want to pick that issue and ensure that I get quarterly or even monthly reports from our representative, because we send somebody there. There's a reason why there's a representative from the Law Society of Kenya to that specific board. Otherwise, unless we implement the report, these mass failures will continue. It is time for us to implement the findings of that committee, and also engaging and holding to accountability and holding accountable our representative to the KSL board and the CLE. I would, as a president, also ensure that I attend those meetings and understand really where the problem is, because this has been a perennial problem that cannot be solved on paper. We have to go to the root cause of this problem. Thank you.
Thank you very much, Council. Mr. Martin.
Yes, my understanding is that under Section 4 of the Act, of the Law Society Act, part of our object is on practice and legal education and legal standards. I think that is where we first get a patch on what we should do with the students. We have a representation at CLE at the School of Law. I've had actually two students who have taken 5 years, and one of them actually has not been able to succeed. And because of that, I took time to try and understand what is the issue at the School of Law. Because, I mean, there is no school that should fail 80 to 90% of its students. It means that the teachers have failed or the system is completely broken down. The way I look at it is that beyond our representation at the school, beyond having a strong representative at both CLE and the School of Law, I think there is lack, because I don't understand the word synergy. I think the right word is probably standardization of exams, so that you do not have what is taught, then you have different exams. And I believe that when I spoke to the teachers and also tried to find out the problem, I think that is the issue. The students are taught one thing, the exam is different. So there is no standardization of the exams. There is nobody who moderates to know that the exams that are set for the students are actually exams that address not only the issues of practice, but issues that they've been taught. So how do I address this? Obviously, number one is to try and put pressure through our representative, but that has not worked. And I think now there is time to go to Parliament and tell them that these schools are messing the lives of our children and youngsters. And through that intervention, we should have regulations in terms of standardization, in terms of probably more representatives from our side, the law school, and in terms of finding actually what the real solution is. Thank you.
Very much, Mr. Baki. The solution there is the legislation according to what you say, Mr. Theori, yes? 2 minutes.
All right, thank you for that question, and it's a very pertinent question. And let me use the statistics of the membership to demonstrate just how serious a problem we have in our hands. Out of about 12,600 advocates who took out practicing certificate, about 5,800 of them are between the years of 0 to 5 years. Essentially, half of our membership cannot take an offer pupils. In the next 2 years, we expect this number to rise to 70% because of the rate of admission. We admit about 2,000 students, 2,000 advocates every year. So we have a crisis on our hands, and I believe that it is now time to take seriously the proposals that have been made in the Kipra report, the proposals that have been made in the task force on legal education, and ensure that we take measures to address this challenge and face it head on, because if we don't, we are going to get to a position where we will have a large number of our population being unable to take and offer privilege. So that's a very serious issue. There is a need to look at and harmonize the admission criteria, because when you look at the Kipra report, it seems to suggest that that is part of the problem. Schools that have more thorough admission criteria have a higher percentage than those that have a weaker admission criteria. And that, I think, is the role of the Law Society. The Law Society should intervene with the regulators, the CAD, the Council for Legal Education, and the Council for University Education, so that then we have strategic interventions that can be able to deal with these challenges, because the problems are well documented in the 2 reports that have been done before us. The issue is implementation, and I will champion their implementation. And to just demonstrate that I already have identified this challenge, the Law Society Nairobi branch has an ongoing memorandum of understanding on mentorship of students at the School of Law. So it is already an ongoing issue. In their next award ceremony, as a branch, we are going to recognize students who perform well, because it is part of our responsibility as a leadership to ensure that we offer mentorship and encourage academic excellence, but also address the challenges which are there. And we have already, as a branch, started addressing those challenges. And when I'm put in the national office, I will ensure that this partnership, we have a stronger partnership between the Law Society and the Kenya School of Law and the CLE, and ensure that the well-documented proposals in the two reports are implemented.
Thank you very much, Mr. Tuli. That's an interesting proposal. I will not, it's a question that I framed initially, but I think I will not go into it. But I just want the audience to think about it, especially with the statistics that you have given regarding the numbers of young lawyers who are now coming out of the School of Law and who are joining the profession. Whether we need to really start thinking of relaxing the criteria or the qualifications of members, of practicing members of the Law Society to engage pupils. Because the numbers of lawyers who have done 7 years and above continues to shrink, and we are getting new members of the profession or seeking to enter the profession in their thousands. And the truth is, for many of you will know that getting pupillage, a place for pupillage today is already becoming a problem. Yet in our time, the law firms in Nairobi used to come and fight for us in university. To join, they used to come and please join us. But this time around, a lot of things have changed. We move quickly. There is the... Oh. Hope that's not you, Mr. The other thing, I want to ask a very open question about CPD. And if I was to ask in this particular room, those who actually attend CPD for the purposes of attaining the objectives for which the regulations were passed, there will be very few. And the CPD rules that were set in 2014 had very good intentions. But I think we need to now ask ourselves whether this is just an avenue for raising revenue on the part of the LSK, or it is a genuine forum that we create for members to truly train and develop themselves professionally. Is there anything that we can do to improve on this objective, or the objectives of the initial rules as enacted? Is it, do you think it is in order that you should lump all the lawyers, the ones who have done 50 years and the ones who were admitted 6 months ago in the same room for purposes of training them in the name of professional development? Is CPD still the same thing that it was designed to be? Or are we just doing it for purposes of raising revenue? Because a lot of people will be, if you have asked them, they'll tell you, during the time when we used to attend physically, they will come and sign in and, you are meeting in the hall and they're having alcohol on the second floor. That is the truth. And for those who are attending virtually, I think the virtual sessions are even worse. The people log in, they mute, they volume 0, and he does his own things in the office. Then of course you give him his point and you have taken his money. Is there something that you want to tell the members about improving this thing? Would you want to revise the conditions for participation in CPD in line with what Mr. Nyabena said of reducing the fees, especially for the young lawyers who are just coming in, because a lot of them don't have that kind of money. Maybe 1,500 is very small for Mr. Native, but for some of our members it's not that easy. So what is your take on how this thing has grown and whether it has attained the objective for which it was designed? Ms. Kamende, I will start with you now.
Thank you. I believe that the CPD rules that were designed in 2014 had all the intentions, good intentions, so as to comply with our objectives under Section 4 of of the Law Society of Kenya that requires to also train our members on various areas. The truth of the matter is, from where I sit, is that we technically just appear because the CPDs are tied to the PCs. It is a requirement for one to attend certain number of CPD sessions to be able to be given a PC. For me, for us to have meaningful CPD attendance and to assist our members, it's high time we thought about divorcing the two. We can roll out the CPD programs and sessions to targeted persons or categories of people in practice, so that we can achieve the intention. The intention was to continuously sharpen our skills, as the word CPD actually just says, to develop our skills, but that has not been achieved. I will also tell you for free that I'm one of those people in the early days of my practice. I'll just attend because I need that point. So if we think of reviewing those rules to divorce them from the PCs, then we'll have achieved the intention in the first place. I think also we need to engage members on the topics, and also, like I said earlier, to target the people who are not interested in CPDs on tax law, who are not interested in CPDs in other areas. If we can engage members and tell members, now we want you to give us topics that you want us to discuss in those CPDs, then I think that would also assist in achieving that role. Mixing all people, I think it is important that we have everyone attend at will, because that is where the young people tap knowledge, the old people also pick other issues or of concern, or also pick, they can also tap knowledge from the young people, especially matters technology. So I think we should start a conversation of engaging the requirement of the PC from the CPDs, because if you ask me also, this CPDs, I will say it from here, is a cash cow for the Law Society of Kenya. I am now speaking as a signatory to the Law Society of Kenya accounts. CPD is a revenue raising avenue for the Law Society. We need to think about whether we, an advocate who was admitted yesterday, needs to raise the same amount as Kikoech, who was admitted 15 years ago. I think we need to review. It is time we have that discussion. Let us relax our rules of practice so that every member is free to also practice law without necessarily restraining. Many advocates, young advocates, reach out to me to assist them pay the CPDs, because some of them are not employed. It is time I will start that conversation as the president of the Law Society of Kenya, having inspected the accounts of the Law Society and noted that we have money to run the society. We don't need to strain our members further, especially the young members. Thank you.
Thank you. Sure, many are excited to hear that. Mr. Metich.
Thank you very much, Senior. I am one of the candidates running on the clarion call for reduction of CPDs from Kenya shillings 1,500 to 1,000. Because as an outgoing treasurer, I know that the society has sufficient money, and we've gone through extremely very hard economic doldrums as a society. Very interesting about CPDs that when you look at it keenly, we have almost the same speakers every other time, almost the same topics. It is only now that the CPD committee, which we picked at the beginning of our term as a council, was slightly fresh, but there's been almost a similitude of what has been presented for the last 3, 4, 5 years. What do I think we should do with CPDs? I think we need to take advantage of the Law Society of Kenya Act, which has created the Directorate of Continuous Professional Development. If I'm made a president, I would want to incentive and try to push forward development or restructuring of this directorate and to an institute. where we can train our members and issue them with certificates, so that even as you get your CPD points, you get certificates, so that we become a little bit more serious instead of just making money. And the society before COVID didn't make much money. We collect 3,500 shillings from a CPD session, spend 3,000 shillings paying hotels, facilitators, and all those other people. It is time we restructured this so that we become relevant and impute in our members what is modern nationally and internationally.
Thank you very much. Mr. Nyabera, any?
Thank you. Allow me to stand. On CBD, I have said in my manifesto, if you elect me, in the first 90 days, I'll declare a session where all chapters will come and discuss LSK. This is one point we'll discuss with you and decide. I have to give credit to branches and my brother Eric. In the AGM of July 2020, the branches raised a motion to devolve the CBD. Of course, it was technically ruled out, which was unfair. And what I believe is we need to give CBD back to members. Not only CBD, we need to give you the law society. There are unique challenges in Kisumu. If we say out of 5 CBD, you can get 2 in the branch, you'll be able to sit down, see what issues affect you, so that you're able to do them. Let me tell you what we did in Mombasa. We had a program called Steps of Practice. The most attended session was dealing with how to balance family and practice. It was done by a young lady called Eunice Njawe, and that is how I enable people. She came with an idea that young mothers get problems. How are we able to understand the issues? How do you do this? How do you do investment? How do you plan your life? Simple issues. I do not, like Bernard, who has served and has never reduced that CPD, propose to reduce. I must sit there and see. But people want value for money. What can you buy for 1,500? If we package it very well, and you think you are getting value for money, you'll be able to do it. The other thing I want to do is to create different bars. If you are doing employment, why are we forcing you to go and listen to oil and gas? It may take you 2 lifetimes before you get an oil and gas brief. So once we have people dealing with employment, even running down, coming and saying we want to do a CPD on this issue, so that when I go on Monday, I'll be able to do this in my practice. We have become too academic. You must have doctorate, you must have a professor, you must have masters. I have wonderful people in Mombasa. When a brother called Gikandi or Matete came and spoke, they spoke to members very well. So we must forget being academic. We must bring it in. I am the candidate. We say within a short time, because that motion was defeated. If you elect me president, the regions will be able to sit down and do the CPDs on topics that are attractive, that are member-centered. Ladies and gentlemen, I'm bringing back not only CPD to your hands, I'm bringing the law society back to your hands. Thank you.
Thank you very much, Matthews, and then give the opportunity to Mr. Teori, then Mr. Ombati will close on that issue.
Thank you for that question. I must admit that I agree that CPD for quite a while has become a revenue generation stream as opposed to a forum for exchange of knowledge. But I also can say, having sat in the CPD committee, that when certain reforms were undertaken in terms of how you extract questions and topics for discussion, including monitoring and evaluation matrix at the end of the day, there was noted to be a significant increase in the number of people who attended. And so therefore, the issue is not really the cost, the issue is the value addition. And for me, what I have proposed to do is to, just as my brother Bernard said, we need to first establish the sector bars so that those who practice conveyancing have an avenue where they can be able to interact and exchange knowledge on conveyancing. And through those sector bars, then we can be able to generate proposals that inform the calendar that goes out for CPD, And and the one thing which you have to give the Law Society credit for is that when it introduced CPDs, it's an idea that has been taken up by every other professional body. So it has its relevance, but there is a need to review it and to diversify also the revenue generation streams at the Law Society so that we can win the LSK of reliance on CPD fees, and also establish, in my view, a training institute for the Law Society that can be able to offer trainings on legal matters to other non-lawyers as a means of revenue generation, so that we can then supplant the gap that will be there when the teacher reduces the revenue gap that will be there when you reduce the fees that are paid for CPDs. So you must diversify in build capacity to generate more income so that then you are able to cushion and then employ strategic CPDs that would be able to take into consideration the different needs of the membership and also cushion the younger lawyers from the high fees on CPDs.
Very much, Mr. Omati.
Yes, yes. I would wish to respond as follows. Number one, the mandate under Section 4 of the Law Society Act is that the society should continuously update members about education and standards, and therefore you cannot divorce the practicing certificate from the CPD. I think that will be retrogressive. It will be going back from where we've come from. Number two is that, therefore, how do you then make CPD to be more relevant and more interesting to members and to generate new knowledge? Because with the current legislation, court cases, development in practice areas, CPD is part of an avenue for the society actually to not only educate our members but also to expand practice areas. So you cannot do away with CPD, because if you did, I think that would be retrogressive. And then you would need to amend some of the objects under Section 4. Number two is that I've had my friends here talk about CPD as if they're strangers in Jerusalem. My friend Eric here joined council in 2014. Carol joined council in 2018, and I think together with Governor Koech. I have not heard what they did in those years to improve CPD or address these issues. So I do not believe what they say. And because they've had the opportunity to make that difference for many years, more than 10 years combined. The way to sort out this issue is, I agree with Eric and Matthew, is to sector because our profession has grown, it's large and complex. And I took time to read about CPD and study the CPD model in the UK. They've sort of classified law firms to small firms and freelancers, medium firms, large firms, in-house, and lawyers who are involved in the regulatory authorities and parliament and such matters. So you first do that, and then you tailor CPDs in a way that is relevant to each practice area. And also make it easier and cheaper. Now technology allows us to do even podcasts, so that we can do cheaper CPDs for youngsters, for the young lawyers through podcast, and maybe they just pay 200 shillings for a podcast that would educate them. Use technology, do booklets on practice areas, and be more relevant, so that we have members not only who are, because you can't say you are learned if you don't continue, if it's not a continuous process. So I think that is how I'll do it, and as I said, I think I provide the clearest vision of sorting out the issues of the society. Thank you.
Thank you very much, Wakili. On a lighter note, before I hand over to my colleague, I did know that some of you are carrying loaded guns. Mr. Mbati has just discharged 3 bullets.
We have a rejoinder.
In advance, before the monitor said shoot, he's already shot. Thank you very much. I will then allow my co-moderator, Dorcas, to raise a few issues, which I think there's 2 or something. Try and move same pace.
Thank you, David. It is said that nations fail when institutions cannot hold. Now, the LSK has a core mandate of upholding the rule of law. And as such, we are a public watchdog. In recent times, it has been said of us that we have abandoned our role as a public watchdog, and we have relegated this to Kia Mtata, and we only come out loud, hard and fast, when it is matters of the society. We all 5 have a background in the society. You have been here before. What is new in your manifesto that has not been there in the previous times you have served in office that would help us reclaim our glory as regards this concern? I'll start with Mr. November.
In my understanding and where I come from, I've spoken to the rule of law. I've spoken about the appointment of judges. I'm one of the candidates. If you Google me out, you'll find me talking about the corruption, which I think to me is a cancer that is threatening not only this country, but the practice of advocacy. I sit in Mombasa with young lawyers. They are horrifying tales about judgments, and I like what was being discussed in JSC, judgments that are now saying the sun rises from the west to the east. What does JSC say? When you complain, they say go appeal. I believe, and I stand for this, there are prima facie corrupt judgments on the face of it. I'll continue to speak about it. And if elected today, I actually intend to create an ethics and corruption forum where we are able to document these judgments and bring them out to show what we're supposed to do. In terms of governance, when I was elected, I have spoken, and if you look out, on the issues of disobedience of court orders. I am bold. I stand for integrity. Ladies and gentlemen, you must have a spokesman of the Law Society who speaks not only for the Law Society, who speaks for the country. How do I intend to achieve this? You know, the Law Society can issue hundreds and hundreds of statements. As I've indicated in my manifesto, I want to include in my leadership the former lawyers of the Law Society, Lim Thoka, Paul Mwita, and the rest, so that I pick from institutional knowledge. You see, my father used to tell me many stories. I like elders. That is what the model I've used within the Mombasa Law Society, to listen to former chairs. Don't take them for the granted. They may look old, but they have wisdom. We must start realizing where the storm beat us. So if we must then speak on issues, and I have spoken, and I will speak. I will speak, though heavens fall. We have a duty. And you must then mark us by our history, all the candidates. What have we done? I have done it. I will speak for the rule of law. I will engage in PIL. And as I've indicated also in my manifesto, I'll not be having one person on whom I'll give 5 or 6 or 7 cases. To me, if a lawyer has done one case on PIL, it's called when you have eaten from the plate. Let's also pass it to your colleague. We should not be able to monopolize this PIL. I look forward to that day when a young advocate from Kisumu is also given an opportunity to do PIL and also have that opportunity of one day stepping in the Supreme Court, not courtesy of his clan, but courtesy of the Law Society of Kenya. Ladies and gentlemen, I request for your vote. My history speaks for itself, and I will continue speaking for the Law Society of Kenya. Thank you very much.
Thank you. Mr. Mwanza, the floor is yours.
Yes, I think my friend Mr. Jabena said the question and answered it. I don't think that's the question you asked. The question you asked is that what is our role in terms of involvement in the matters of rule of law and governance? And I think that the way to answer this, or the way to address it, is first, because you use the case study of Acacia taking over almost as the public defender of the rule of law. I think for you to understand what is happening is that you must also understand the structure of the Law Society. The PIL department or directorate at the Law Society only has one director and one person who assists them. I think another lawyer. And then, it has one director and one researcher. And these are the same people who are used to even print our certificates. So we do not have capacity at the Secretariat to be able to properly monitor legislation and also defend the rule of law and issues of public importance. So we must, as the Law Society, actually strengthen our directorates in terms of mandate and in terms of personnel so that we are able to address these issues. I think the larger issue is the issue of personnel and how the society addresses that. Secondly, on the issue of public interest litigation, I accept that you need to spread the briefs that come through public interest to younger lawyers and also most lawyers. But also, you must also realize that there are very technical cases that come and that need to be addressed by experienced lawyers who have the skill and the craft on these cases. So that when the chair of the Law Society calls you and tells you this is an important matter and you need to address it, they also have that discretion. However, in terms of addressing this issue so that we also protect public interest as part of our mandate, I think we need to strengthen our secretariat and probably hire more people to be able to work for us in terms of monitoring legislation and issues of great public importance.
Thank you very much. The podium is yours, Madam Kameni. Thank you. I think we asked what is new in our manifesto. I would start by answering that by saying that from 2018 to 2020, my mantra was on welfare first. I think I have discharged my duty on that front. Secondly, as the Vice President, I take pride in having served in a council where on the rule of law, our torch shone very bright. For the last 2 years, LSK has not applied to join in any matter as an interested party. That is on record. During the COVID-19 pandemic, there were policies, directives, and laws that flew on the face of the rule of law and also threatened our practice. That is also on record. What did the Law Society of Kenya do? We filed PIL matters to challenge some of these directives and laws that came that threatened the rule of law and administration of justice. What do I intend to do? I have said in my manifesto that I will ensure that we revamp the PIL department that we have in the Law Society of Kenya. It is true, as Mr. Omanza has observed, that it is understaffed. But above everything, the PIL committee that was established in that sat in 2018, established the PIL code under the leadership of Acacia. We came up with a PIL code that laid the structures on how the society should take up some of these PIL matters. my duty would be to ensure that that code is implemented. The other thing that I would do is to spread PIL matters to the branches. I think that idea was mooted in the 2020-2022 council that both myself and Mr. Kipkoech sat. I don't think the lawyers in Nairobi have the monopoly of handling the PIL matters. If we spread and engage the branches, the chapters and the centers on PIL matters that arise from different centers, different areas, then LSK will be had on all fronts and in all centers. This is an electioneering year. It is the responsibility of the Law Society of Kenya to monitor legislation. Like I said earlier, let us not chase after the wind. Let us prevent these policies by participating through memorandum to the various forums that they recall or they require us to give our input. Thank you. Thank you very much.
I'll just highlight two things that are different and new in my manifesto, or rather the vision that I have for the society. The first is that I intend to build capacity, legislative drafting capacity at the Law Society. We have no capacity to develop a bill or a legislative proposal since existence as a society, and I think that we do that seeking donor support so that we have internal legislative drafting capacity. Then we will be able to proactively deal with all legislation that are coming through Parliament and avoid changing legislation after it has come out of the line. Secondly, I propose to establish a legal aid resources from donors for purposes of unlocking funds to support strategic public interest litigation cases, which the Law Society does but does not engage in, because strategic litigation cases are aimed at changing policy and changing legislation, influencing policy, changing legislation, and require much technical understanding and resources to be able to undertake, but also to be able to avail resources for our younger lawyers to offer pro bono cases. We have FIDA, we have Kituo cha Sheria, which are all offering legal work, funds sourced from donors, but the Law Society does not have that capacity, neither has it developed that strategic mindset. So those are two different things that are in my manifesto that I intend to pursue. But let me just also just highlight something that I think most advocates do not understand. When it comes to public interest litigation, you must file a case within the shortest time possible. That is the reason why, for example, when we wanted to challenge the case by the Attorney General, we instructed Mr. Mwanza, because he has proven an ability to generate a petition within a very short time. And that actually explains the reason why you find that in most cases by LSK, you'd find that it is given to a select, perhaps what we would call a select number of advocates, because of that aspect of within 1 day of a government decision, you must be in court for you to remain relevant. But there is a need then to develop this other capacity to be able to do strategic public interest cases, pro bono cases, which can then be spread across the entire breadth of our membership. But that will require resources, and I have the technical mindset to be able to engage with donors to unlock these funds.
Thank you, Eric. The floor is yours, Samiti.
Thank you very much. I want to say that this council, the council that is retiring, in my view, did extremely very well in terms of public interest litigation. we instructed Omwanza at the very outset to file a case for us to be made essential service providers when we were not accepted. And when Omwanza, when I become president, I will be giving you 1 or 2 briefs. And make you the vice chair of PIL committee, so that in 2024, you can now ascend maybe to the presidency. I have so much firepower for public interest litigation. I did a case of Kimona Olekimeiwa versus Attorney General, where Professor Ngugi said that a public officer who travels outside the remit of his powers would be personally liable. It's a president-setting rendition, which I invite all of us to do. What would I do if I'm made a president? I will need to cascade PIL, not to branches, but to chapters. We want to see branches, chapters of the Law Society filing these cases in every county of this country. Number 2, bring in donors to finance public interest litigation. Thank you.
Thank you so much. On to my next question. As a society, we've had various challenges. In the months, the most notorious challenge is the issue of financial management of the society. We have had various challenges in the past as regards audits. We are unable to agree on our audits, who to audit, when to audit, who should appoint the auditors, which audit report is correct. We have gone to court to contest our very own audits. My question is it an architectural design failure of our society? If it is not, what are these cracks? How can we seal them? So that as a society, our finances are safe, secure, with good audit results. I'll start with Nejich.
The microphone, all right, can you use this? Thank you very much, Madam Moderator. The issue of the audit in the previous council was not much of the statutory audit. There was no problem with the statutory audit. The problem was that on the 22nd of July 2020, members passed a resolution for a forensic audit. And nobody opposed the forensic audit. The problem arose in council when one faction, the minority, was pushing for Pakarando audit firm, which had a relationship with the president and which also had some relationship with Mumias Sugar. The majority proposed KPMG. The president could not wait for the majority dissolution. He immediately moved to sign a contract with Pakarando. He believed that only one auditor would be able to unearth theft of the people he already mentioned even before the forensic audit was done. What would I do if I am president? I would want to lobby my council before council meetings. Once council has made a decision, as the president, that is my decision. Lead from behind when decision is being made. Once the decision has been made, I lead from the front. If we go to general meetings as a president, I would want members, those appearing virtually, 5,000, 6,000, the ones appearing physically, 100, all of them to participate. If voting is requested, as Eric Theuri was struggling sometimes back on the 18th of January for requesting for a vote, let the vote be done. Once a vote has been taken and the majority have had their way, the minority have been had, as a president, I will take the decision of the majority. LSK is about majority. LSK is about hearing the minority, but resolutions are made by majority if there is no consensus. I will be that president who would lead members to make decisions soberly and allow sobriety in the manner in which we make decisions. I will not mute anybody. And finally, as a president, I would want to share cash flows of the society every month You can trust me on this. You can take this against me. And any expenditure above 500,000 should have a name. If the president has traveled to Zambia or Paris, like my sister traveled sometimes back, let the name appear. Thank you very much.
Yeah, it would have been good to hear the people starting council, because I think one of the issues you raised was about an architectural design failure in our society. I think the issue of audit is, especially the forensic audit, is an issue that has been authorized by the AGM, and also it has been authorized by the SGM. It should be concluded quickly so that we know what has happened with our money and what, so that we hear both sides of the story, and then we have an opinion by the forensic auditor on whether we've lost our money or not. I don't think because this issue also arose, I think, during the Okoa time. It has been festering. It's an issue that has been almost been the elephant in the room, and it needs to be addressed quickly. Secondly, is our money safe? Is our money safe, members? I think that's a question that Governor ought to have answered, because he was the one who was the treasurer of the society. And Madam Vice President here was also one of the signatories. So they should tell us whether our money is safe or not. But in terms of going forward, I think we must have systems in our society so that leadership of the Law Society provides oversight, instructions, and they are not involved in the day-to-day management. Because when I hear Governor keep talk about cash flow every month, I think that is an issue of management. We should be very careful so that we do not go around circles. And one of the things that we need to do is to have structures that work. You'll be surprised to know that the strategic plan expired last year. We don't have a strategic plan. We do not have a procurement plan for the Law Society. So I think I agree with you that the architecture has a problem and we need to fix it. And that is one of the duties that we do as council.
Let's hear from Madam Gaman. Thank you. I think the question was direct and clear. Section 38 of the Law Society of Kenya Act mandates the council in mandatory words that the council shall cause proper books and records of accounts of all funds, property, assets, and liabilities of the society to be kept and to be audited as at 31st December of every year. And then the council shall, that is subsection 2, present to the general members these books of accounts. On 23rd of July 2020, members refused to adopt the audited accounts and threw the ball to council. Members have the power to select the auditor, but they threw that to council. 13 individuals sat down and called for quotations from 3 auditors: KPMG, PwC, and Pakarando. As at 14th of August of September 2020, only one auditor has presented quotations. So it is not true that an auditor had been handpicked. What happened was a faction of council, together with the secretariat, wrote to that auditor and said that you have not been authorized to audit the accounts of the Law Society. What am I saying? You asked about the cracks in this. There is no financial system. I am glad I go on record as the person who has raised this conversation in the Law Society of Kenya. We are discussing about audited accounts and accountability pursuant to my hand, what my colleague here called this golden signature. I discovered a lot of exaggerations in prices. And I moved a motion in council, and I said, before anything is brought to me to sign, because nothing was being brought to me to sign before, when we were 4 signatories with a mandate of 3, let the internal auditor verify from the departments and the need thereof. There is no standard operating procedure in the Law Society in the manner in which finances of members are handled. We cannot leave that one to the management because the board must make the policies and ensure that they're implemented. That is why we came up in 2018-2020 with the financial manual, because this issue of finances has been the elephant in the room. So for me, if elected as a president, I know where the gaps are. You are all here members, those here and listening to me. I have been hit left, east and center because I have refused to rubber stamp payments because members did not elect me to mismanage members' funds. What we need to do is to come up with the standard operating procedures of movement of payments. As the council, we make the policy, but we also oversee the implementation. We cannot leave matters money to the management only. So the cracks are there, and they are there by design. I will speak today because I have had a forum now to tell members there is a problem on matters finances in the Law Society of Kenya. You will not take that away, and I have raised those issues in the council and say that I will not sign for anything if it has not been verified. For example, I was brought a form that Kikoech and the other signatories had signed to take over an ABSA account from signatories who left in 2016. I refused to take over an account that I don't know, and that, when I followed up, that is an active account. This is the point. We cannot, as 13 members, sit down and agree on consensus that, okay, if you're a signatory, sign here, because that is what the management does. They'll bring you with a yellow sticker or pink, sign here. Caroline Kamende Daudi, I will not oversee mismanagement of members' funds because I want peace. 13 individuals sitting down to agree on some matters money will defraud this society and go away. So the point is we need to come up with firm structures in the Law Society to ensure that the policies are made, they are implemented. There ought to be movement from 0 to Z in matters money of the Law Society of Kenya. Yes, there are cracks that are there by design. We have signatories who left long time ago operating Law Society of Kenya accounts. The documents are there. I will not shy away from saying that in this podium. And those members who now want not to vote for me because I stood firm, I will continue standing firm on matters finances, because all lawyers reach out to me for financial assistance. They reach out to me as Caroline Kamende. I cannot oversee mismanagement of money. So I will seal those cracks if you elect me as the president on 10th of March 2022. Thank you. Mr. Nyabena?
Allow me a few minutes because there was a statement issued in favor of some of the candidates accusing me of refusing an audit. First and foremost, let me say an audit is necessary. We will do it the very first thing. And once I get it, I'll call you for an SGM. Nyabena is not accused of stealing any money. I was not in council. I will do it. I've had my sister Caroline say, it's the duty of council to keep accounts. She cannot escape, and my brother Bernard cannot escape from the fact that they were in Allen's council. So the fact that they are trying to say is the duty of council to keep accounts. So if those accounts were not kept, if I were them, I could come here and apologize to members that we failed. But we failed, allow us to be elected so that we rectify. Somebody has to take responsibility, and it's good that we take responsibility. Now, there's a fundamental question members must agree on. One of the colleagues who were in council says it's Pakarando. The other one says it's KPMG. If I were me, an auditor is an auditor. I'll say let Pakarando do it, let KPMG do it. They are not telling us why they never gave up. And all this points to a selfish this sign that I must have my way. Carol was saying, and the group under her was saying, it's my way or the highway. My brother Bernard was also saying, it's my way or the highway. Why were they doing this? Along the way, for us to succeed, somebody must give up the headline position. So today, if we elect either of them, will those divisions be healed? My answer is no. We need a fresh face to do this audit and to bring unity, because those disputes that they were engaging in will continue if we elect either of them as councilman, as the president. We should never refuse an audit. We must learn to talk to each other. I remember I called these two gentlemen. I called the president, told them, remove this hardline position. If you read the statement, I was accused of having said that Wazee or elders coming. I told them, if council is so divided on the issue of the audit, and you remember the motion that we brought in the SGM, we said, can we then elect independent members, members of honor, to carry this audit? For saying that, I'm being told that I oppose the audit. I cannot oppose the audit. For the record, and I've shared this, when I left Mombasa Law Society, out of 3 million disbursement per year, I left Kenya shillings 10 million in that account to buy property. Today, I'm going to ask my sister, Caroline, why didn't you disperse that money to Mombasa Law Society so that we are able to purchase property? She continues, and people continue saying that the branches stole money. If there is any money that was stolen, can we be told how this money was stolen? And point number 2, and lastly, the two gentlemen, the gentleman and lady before me, somebody needs to apologize to our employees. If we refused, and it pains me, if we refuse to pay our messengers who earn a mega salary, their funds, their children were chased out of school, their houses were locked, we need to take responsibility. If you elect me, because it pains me from deep inside my heart, I will apologize. For failure to pay for internet, I was talking to a colleague, and he said, I did not take a practicing certificate because there was no internet and the electricity. Somebody must take responsibility. It's good to look us in the face and ask for a vote. But I believe that when somebody says, I'm sorry, that person is stronger. But when we assume that bad things never happen because of this dispute, I'm sorry, we are not being honest, we are not being human. Thank you.
Mr. Heru?
Do we have a right of reply now that we've been asked to apologize?
We shall use the crossfire session to allow you to reply.
Thank you.
Thank you for that question. I agree that there is definitely a sense of concern and anxiety as to the corporate structure and whether it is adequate. And my proposal within the next 100 days of assuming office will be to hire a consultant to conduct a corporate governance audit to tell us whether the structure is sound enough in terms of corporate governance, and if it is not sound enough, what do we need to do, and ensure that those are implemented so that we have a structure that conforms to the highest standards of corporate governance. Secondly, I intend to also look at how we work and implement the strategic plan of the Law Society. The one that was there has expired. I will generate a new strategic plan, come up every year. This is what we do at the branch. Every year we have a meeting where we develop the work plans in terms of what are the items that we're supposed to implement in our strategic plan for that year, what are the costings, do the work plans, generate the work plans, and be able to come up with the budget estimates that then will be taken to the budget committee so that we can bring more light into the process in terms of how we use our money and in terms of how it is expended. Ensure that there is proper procurement planning, guided by the work plans which would be developed from the strategic plan of the society, so that we look at where we want to go as a society and what it will cost us, and ensure that we have a proper plan, well documented, well executed, and that there are adequate mechanisms for monitoring and evaluation. Of course, it is our responsibility to also ensure that we keep proper books of accounts, and I'm at least delighted that the process to unlock the audit and the forensic audit is now ongoing. So questions as to whether our finances are handled in the right manner or not will soon be answered once we have conducted both the forensic audit and the annual audit.
Thank you so much. This will be the last question to the candidates. You're aware that by dint of the position you seek, that you shall therefore be members of the NCAJ by reason of section 34(2)(g) in particular of the Judicial Services Act. Now, what are some of the key issues that you will focus on relaying to the Council that are beneficial to members and the consumers of justice at large? These are world sweeping statements, be very particular. Section 35 legislates the mobilization of resources for purposes of efficient administration of justice as one of the key functions of the Council. How will you leverage on your membership of NCAJ to support LSK activities? I'll start with Nyabena.
National Commission on Administration of Justice brings in the actors in the justice sector so that we are able to have conversations on issues that affect us. Part of my major problem I have is the issue of discipline of judges and handling of complaints. Because it needs a multi-sectoral approach from the police, the AG, the ODPP to handle these issues. I will advance and propose that this issue, and I've proposed before, that we try to have timelines within which to deal with complaints. I file a complaint. The only thing that was done after I wrote is an acknowledgement. We do not have a clear mechanism on how to deal with these complaints from the start to an end, and we have seen these entities at times fighting on who should handle what. I will ensure that we have the judiciary fund. I have been consistent in the argument that we need that fund so that the judiciary is independent financially. Whoever controls the purse will be able to control how you are being managed. There will be more interactions between the ODPP, between the Attorney General, and the Law Society. I have said that my leadership is conversational, and I've said that part of the way I run institutions is diplomacy. So within those institutions represented within NCAJ, I'll be able to do a lot of diplomacy so that we open up issues that affect advocates and also bring transparency in all processes to ensure that we as advocates, we as lawyers are properly represented and our views are properly heard in the administration of justice in this country. This will include some of the pending cases that have been there for too long. How are we able to resolve them? How quickly are we able to deal with corruption cases? But as we do corruption cases, I look, and it's a major concern to me, that if you look in the criminal justice process, you get somebody who called Mr. Nyabena a thief, and that case is pending in Kisumu. 2 years later, that claim is useless. We need to clean out the number of criminal cases that we have in court, so that now we start handling serious cases. There are very many unnecessary cases, very petty pending in court. I'll advance that we And I've seen the judiciary come for our civil cases and say justice at last. I also want justice at last. For those very many petty pending cases, I look forward to a day when somebody is charged in court and the process is smooth, then he knows that the cases will be handled expeditiously because they may be fewer, but with a higher conviction rate. So we will need to retrain, work together in harmony so that we clean the justice system. That is my promise to you. That is Matthew Nyabena. Will be diplomatic and have conversations to change the structure of the administration of justice in Kenya.
Thank you. The floor is yours, Tony.
Thank you. I think my understanding of your question is how I will use my position at NCAJ for the benefit of the Law Society. And I intend to do two things. The first thing is to use that position and the interaction that I have with the IG to ensure that I call for a meeting between the IG, all the branch chairmen, and the regional commanders, so that I can use that opportunity to introduce the regional commanders to the branch chairs. And thereafter, we establish a mechanism using from that meeting for interaction and cooperation, so that whenever there is an issue relating to advocate police issues, or when there are quacks and we need, as a chapters or the branches, you need the assistance of police, there is already an established mechanism for cooperation and collaboration between the regional police units, who will introduce them to the commanders, the OCPDs and the OCSs, so that you do not always have to look for the president whenever there is a challenge with regards to those two. Secondly, I also intend to use the partners that work with NCAJ. We have I think the US government funds a lot of activities with judiciary, IDLO, so that we are able then to create linkages for improving practice matters using the resources that are availed from those donors. It is something that we do in Nairobi. Next week, I think, we will be having a backbench stakeholders meeting where we bring together all the DRs and the various conveners of the backbenches to develop key performance indicators for the backbench for the next year, and that is supported by IDLO. We have climate change justice program, which is also supported by IDLO, but that has been an initiative of the Nairobi branch. What I want to do when I become president is to use those linkages to introduce those partners to the branches so that they can cascade their resources on matters relating to practice and welfare to the branches. That way we can bring more resources to the branches, build the capacity of the branches to intervene effectively on matters related to practice and welfare, and also assist them to generate income and develop the capacity to be able to source for funds from donors and manage those funds.
Thank you very much. Mr. Omonzi?
What would I do in my position as the President of the Law Society to mobilize resources for the administration of justice? That's how I understood the question. One of my agenda items is on legal aid, and I think legal aid is completely underfunded. We have the Legal Aid Act 2016, and Parliament has been giving about 50 million every year for purposes of legal aid, which is used just to pay for offices at CPD, at the Central Business District. I think I would use that position to lobby for more funding to the Legal Aid Act, so that indigent members of the public and those that are not able to pay for briefs and need legal interventions or legal advice be able to be resourced through the legal aid. That is how I use my position to try and have this fund increased, and that will also cover a lot of issues for young lawyers who can be able to at least get paying briefs, even if it's in small amounts, to be able to cushion them as they start life. Thank you.
Thank you very much. This is a National Council on Administration of Justice, which is chaired by the Chief Justice. It has the ODPP, AG, Inspector General, and several others. There are two things that have interested me in practice. Number one, I would want to use my position as a member of NCAJ to push for more synergy between the office of the ODPP and the office of the Inspector General, especially in criminal cases. It is very easy in this country for the police to arrest. Once you are arrested as an advocate for an accused person, a case can take 3 years, 4 years, 5 years, a frivolous case. There needs to be more synergy, or no witnesses are brought to court, or ODPP State Council prepare. So I would use this position to help the police as well as the ODPP to have a synergy on how they process criminal cases. Number two, judicial calendar. We live in a country where seminars, workshops, and colloquia are more of emergencies. They are like La Ninas, they are like cyclones, they are like Hyundai Katrina, you know? These are issues that need to be addressed. We need to have a predictable judicial calendar that is aligned to court diaries, so that we don't have judicial officers giving us dates 1 year ahead of time. When that time comes, you're told that judicial officer has rushed to Malindi for an official function, which is a training. I value trainings, but there needs to be a marriage on judicial calendar and court diaries. On resources, it's important to push for 5% through the NCAJ, engage NCAJ to push Parliament to increase resources so that we have courts in all the sub-counties that we have in this country that are also have an inbuilt advocates lounge with facilities so that practitioners are able to also function seamlessly within the court presence. Thank you.
Last but not least,
thank you. Allow me to answer this question in two limbs. First is on my scorecard, what I have done. I have had a privilege of sitting in the NCAJ as the Vice President of the Law Society. What did I do? In the COVID pandemic period, we pushed and I stood very firm together with the President on the partial opening of the courts. On the 15th of June 2020, there was total closure of March 2020, total closure of the courts. Why were we pushing for the opening of the courts? It's because our first call to our members is practice and welfare. So on that front, I pride myself having done that, not what I will do, but that I have done. On the issue of our relationship between the police, the multi-sectoral entities like the AG, the DPP, and the DCI, it is my initiative and it is in my manifesto that have already, and this I'm answering Eric Theory, I already established that mechanism. There's no single advocate in this country who has been arrested in my tenure because there is an understanding between these multi-sectoral agencies that any advocate who is in conflict with the law or has been arrested by any authority in the course of duty, the first call is the Law Society of Kenya. I think many members, including Mr. Mbena's members, have benefited from this established mechanism. Even when the newspapers and the members of press pick up this matter, LSK is contacted, and the person who has been contacted from the DCI, Matters Advocates, is me, Caroline Kamende, through the tools that I've established. So there's already a mechanism that I put in place when I convened the lawyer police relations committee, and also when I sat in this NCAJ. On mobilization of funds or resources to the Law Society, majority of these agencies, as Mr. Kikoet has highlighted, are government-funded institutions. The only thing is to invite them to our activities, and then also request them that we use their resources. Like we can use the courtrooms, we can use they can give us advocates launches to use on spaces. So we cannot get money, direct money, but we can ask them to help us use their resources. The last thing I would say on this is we have been able, and I would push as a statutory council member, that our practice areas are protected also. The e-filing system and any other matters of concern like internet in courts are enhanced so that our members do not suffer. So I will use that position using my scorecard and my experience there, and also furtherance of my agenda. Thank you.
Thank you very much. I'll hand over the microphone to my colleague, Odek, to carry it over from here.
Yeah, Mr. Odek will put across, I think, just 2 questions, because we have had a long day. I'm sure Mr. Deuli wants to find out what Kisumu has to offer.
Thank you.
I used to just say that is why I go to church.
To our candidates, one of the organs of the society under Section 15 of the LSK Act are the branches. You are all aware that this is the first time in the history of law society that the branches came to rescue the society. The caucus of the branch chairpersons are the ones who have, so to speak, ensured that we are now going to have an election. It therefore means that the importance of the branches cannot be ignored anymore. It is a concern for members that there are functions which are coordinated at the national office that should be devolved to the branches if devolution is to be fully realized as it has been done in other sectors. You would appreciate that due to the chaos that visited our law society, members of the law society were not able to be appointed to sit at the various committees within the county, the various boards within parastatal, because this function for selection of LSK members to sit in this board are done by council. So because of the chaos and the facts that were in the previous council, we missed out on an opportunity to serve. I would give an example at the county, and the county has been progressive in most of its matters. There was confusion. We have these committees, and I dare say some committees are to be chaired by advocates. But because of that chaos, that opportunity for members to serve was denied. The question to members is, to the person who would be elected as the president for Law Society of Kenya, can we know how you plan to empower the branches and how you will initiate devolution of some of the functions which are done at the national office but can ably be done at the branches level. Maybe just as you answer this question, I will give you this example. When the county government of Kakamega is looking for somebody to chair the land and physical planning committee, you see, that is a function, they need somebody to chair that committee at Kakamega. So as you answer that question, think of such functions. So I will begin by inviting Mr. Nitich to hear your comments.
Thank you very much. I want to agree very strongly with you, Madam Maureen Odek, that branches as organs of the society are very critical. They are very important for purposes of Section 4, taking the Law Society of Kenya deeper down to the membership. I also want to agree that the branch caucus has assisted us, and this was as a result of a case which I filed in Nakuru, later transferred to Nairobi, through members to ensure that the society moved on because of the stalemate which subsisted. On matters of appointment, I am aware the regulations provide that it is a function of council, but I want to agree very strongly with you as the chair of Kakamega chapter and a member of West Kenya branch, that notwithstanding, all of us are members of the Law Society of Kenya, and the branch and the chapters have better analysis and perspectives of some of the members who've applied. So as a president, I would want to consult with respective chapters, not even the branches. I would want to consult with respective chapters once people have applied, after the positions are advertised, so that there is concurrence. And once there is concurrence between the chapter and the council, we proceed to appoint. Luckily for Kakamega, I think we appointed somebody. We continued to sit in council for the whole of last year, when the vice president and the other members of council took off and went to the command center, where they would come occasionally with members of the caretaker council. On members of devolution of functions, it is not just sufficient to consult on matters of employment. I am also considering, as a president, engaging the entire branch caucus and chapters on matters of public interest litigation, as well as also ensuring that we continue to do pro bono work as a law society. Thank you.
Thank you. Mr. Nyabena.
Thank you very much for the question. Let me first tell you about the history of the branches caucus. The first chairman was my brother Charles Kanjama, who did very good work. Thereafter, I was elected by the chairman of that caucus, by Eric and the other chairs. So those votes are part of my leadership, that recognition. The branches caucus is not funded by anybody, zero money from LSK. I remember under Charles, we could give 5,000 to be able to get somebody to work for us. So it has taken tremendous sacrifice on our part to be able to do so, including the fact that when we were given leadership, members must appreciate that I sacrificed that position because my tenure was ending, and I gave Linda to do so. Now I come to you. If you think and you find that I'm suitable, you can elect me as your president. Number two, on the issue of devolution, I think differently. You know, there's been an animal called Council in the Law Society of Kenya, which has been running away with a baby called LSK. I want to bring the Law Society back to members. I see no explanation at all why appointment for somebody to work in Kakamega should go to Nairobi. There's Kakamega branch. We are going for reforms. Part of the reforms is to allow the branches in those areas. It's very interesting when I sit in Mombasa, and then some team sits in Nairobi, actually without consultation, and then they say we've nominated somebody. I think this is the right time to bring the Law Society back to members so that we are able to do so. Just realize one thing. When we had the new constitution, there was devolution, including the civil service. The LSK secretariat has never been touched. So we do not have full devolution in this process. The last one, and this is crucial. President Uhuru Kenyatta has been holding functions of national office in Kakamega. They came to Mombasa. We have the annual Legal Awareness Week. As chairman, I've always spoken to national office. Why is it that it's always held in Nairobi? So the Nairobi branch should also be given space to do it. Elect me. Some of those functions, you'll find them in Kisumu. So the national office is felt. I want the secretary and the CEO of the Law Society of Kenya to also come here and deal with your issues. So that one of the promises I've made is to ensure that then out of LSK, if you are from Kakamega, you know who to call. So that we do not have telephone calls that are not being answered. My brothers and sisters, I will change that. It has not been changed, but if you give me the opportunity, you will see it. Thank you.
Thank you. Madam Kamenda.
Thank you. It is true that Section 15 establishes the branches as one of the organs for effective governance of the Law Society of Kenya. And on also the issue of appointments to boards, Section 25 is clear that they ought to be transparency and also it ought to reach out to all the members of the society. There ought to be invitations made. I think on this issue, the last council, of course, before the clause that you talk about came up, we had a policy, and Mr. Netich will confirm that if there is an invitation by Kakamega County for a chairman of a lands committee or any other committee, that the priority was given to a qualified member of that set of that area. I remember we had appointed somebody in Nyeri, and Nyeri chapter brought back and said that this person no longer practices in Nyeri. So there is already a policy in place that was put in 2020, if I'm not wrong, in the meeting of 10th of August 2020, if my lion's memory serves me right, that the first priority will be given to a member who practices in that area. Kipkoech will also confirm that where we got no member from that area applying, we recalled again applications. An example was one in Kilifi. How do I plan to empower the branches? I had already said earlier in my submissions that I think we should devolve PIM. And in the Allen Council that I served, we had rotational branch visits. So I think I would want to revive this so that we pick out the areas that aim our branches are of concern. Section 24 that establishes the branches also gives the power to the National Council to address some of the issues other than practice and welfare. I would want to visit the branches, get those issues, and address with the necessary stakeholders. That would be my advice.
Thank you. Mr. Eric Theory.
I support and will ensure that the branches have given the necessary support and allowed to undertake some of these functions. Of course, the statute recognizes that the Law Society has to appoint. What I intend to do is, whenever I'm requested to do that, I will request the chapter to do that nomination. I give them the evaluation criteria. I oversight in terms of how they have done the evaluation and the nomination. And if I am satisfied that they have conducted the process as per the evaluation criteria, we will nominate. So it will not be the national office calling for those persons to express interest. It will be the local chapter that will do that, and that I will do. Secondly, I will also implement and establish a quarterly leadership forum between the national office and the branch leadership and the chapter leadership, so that we have an opportunity to sit and discuss matters that affect practice and welfare within the branches, and to also determine the needs, sometimes the special needs of certain chapters that can be undertaken by and all supported by the Equalization Fund. So that when we are talking about a court, for example, like we're in Kakamega, and it has a lodge that does not have furniture, we are then able to use, because that is the reason why we set up the Equalization Fund. We are able to use proceeds from the Equalization Fund to support the provision of necessary supporters to those branches, and that should be done through the Leadership Forum. Finally, I will devolve projects or rather activities that are undertaken by the Law Society. We need to take, for example, sports, the sports day around the country. As a branch, tomorrow we are having a football tournament where we are raising awareness on issues related to cancer. So I'm not talking about things that we intend to do when we get into office. I'm talking about things that we are already implementing. And the one thing I have to agree with Chair Nabena is that some of these things, like the Legal Awareness Week, because of the challenges we had in council, for the first time, Nairobi branch conducted the Legal Awareness Week. And for the first time, we were able to conduct Acacia's pro bono legal awareness week that was attended by all the cadis. We advertised in mosques for Muslims to come, and we have advocates who are Muslims giving legal advice to those that are in need. So we've been looking at minorities, we've been looking at where there is a need and providing those services. For the record, the Nairobi branch is the first branch to ever come up with a bar bench for the Cadis Court. We already have plans to have interactions between the Children's Court, the Family Court, and the Cadis Court, because there is a conflict on the matters of law in relation to custody of children. So we are offering to you a proven track record of performance, of innovative thinking, and of offering solutions that touch on us. And when we do this kind of things, we improve the respect that we deserve from the members of the public.
Thank you. Mr. Ombati.
Yes, I agree that branches are a core function, are part of the governance of the Law Society. And what do I intend to do as president? We will release money that is due to branches without a day's delay. When that money needs to be sent, it will be sent immediately. Secondly, immediately we get elected, I know previously council has had an induction, council induction that takes a week. I would call it an induction and leadership conference. And we will not only have induction for council, we would want to start with the branches from the beginning. We call the chair of all the branches and the chairs of all the chapters, so that we all agree on a work plan and reduce and get to know each other and map up the issues that affect each branch or each chapter from the very beginning. Secondly, I think there is a need for law reform in terms of devolution and what branches ought to do. The first one is to amend, and this my proposal is to amend the Law Society Act. There are many amendments that need to be done to that act. And since you raised the issue of the branches, I think one of the issues that need to be amended is on representation, so that now every branch elects to council. Out of the 8 branches, each one elects a member to council. We remove this issue of Nairobi, general member, and all that. Then we have the president and the vice. Secondly, on law reform, I think that will allow us to devolve some of the functions so that they are written in the law and it does not depend on the goodwill of the president of the council at the national level. Thirdly, is to also give some of the chapters that have grown very big and because of devolution and in terms of capacity, we should have branches. I think like Thika and Kiambu combined need a branch. They don't need to be attached to Nairobi. And probably, I saw that maybe in Eldoret and maybe in Kisumu then is split, so that we have to. That is one of the ways of empowering branches by writing it into the law, so that their functions and some of the functions, some of the objects are devolved and they are written, so that you don't need it on a policy level from council, but it is clear. Thank you.
Thank you. My last question. You're aware we have a lot of young advocates who are being admitted, and one of the employment opportunity areas are as researchers. Under Section 7 of the Judicial Service Act, researchers are to be advocates of at least 1 year post-admission experience, and they're employed to serve only in one specific court for the duration of their services. Do you believe that this is good for their development as young lawyers? And what would you recommend to improve their quality of judgments in the courts in which they serve, considering the experience of 1 year post-admission. Mr. Nyabena.
First and foremost, let me say that that provision is unfair. I know young lawyers who've been employed on contract. I know JSC along the way reduced the value of consecration. I look at a system where there is career progression for those researchers. I know they are overworked. I've spoken to some who have said that they even received calls from judges at midnight to do that research. So it's an issue that I think we need a totally new experience in terms of dealing with the researchers in court. They need to be secure and they need to be dealt with appropriately, being our young colleagues. I have no problem with 1 year. Any 1 year experienced young lawyer is able to do proper research with proper guidance. So in all this, then we must engage the Judicial Service Commission to create a proper system. I look at a researcher progressing to a magistrate, progressing to a deputy registrar, but that should not be an end in itself. I know some of them who resigned in protest because their salaries were reduced. So this is an issue I think we should deal with very carefully, and I will be able to address it. When a young lawyer is employed as a researcher and his remuneration is not being properly given, that is, I think, something that the Law Society should get involved so that we deal with it. Thank you.
Thank you. Mr. Ombati.
Yes, I agree that one, we need to engage the Judicial Service Commission in terms of what services that a researcher ought to offer. I disagree with you that researchers should write judgments. Because a judgment is a serious thing. You know, when you are judging people or the affairs of men, it's a serious issue. Sometimes on life and death, about their properties, about their family, and you know, about things that are consequential to people's lives. So the role of a researcher should just end at the researcher, because they do not have the tools and the experience that is needed in life to judge the affairs of people. You need that, and that's why there is a certain level of experience that is required for you to be a judge. In terms of movement and the progression, I agree with Mr. Nyabena. I think researchers should be able to rotate so that they also are able to enrich their experiences. You do not only have a researcher that is based in Kisumu, because what has happened is this, is that when you have very sensitive and high-stakes matters, there are lawyers, actually there are lawyers or parties who reach out to the researchers and ask them, what is it that the judge is saying? You know, they put a lot of pressure on these young people who do not also have the capacity to handle it. Can you tell us where is the judgment going? So I think for us to be able to insulate them from that, it's good that we rotate them amongst other judicial officers and the station, so that not only are they enriched in terms of experience, but they are not exposed in terms of pressure. And this will mean engagement by the Law Society with the Judicial Service Commission and our representatives. Thank you.
Thank you. Mr. Nejit.
Thank you very much. I want to observe that the reason why judicial researchers were engaged was because they thought they were going to get the silver bullet that was going to assist judges in this country to cut down on backlog, especially for judgments. They have, however, been misused. In some cases, they do judgments themselves. In some cases, they are even pushed to engage in other things that are not professional. What do we need to do? I agree with Mr. Oman Saombati, my classmate, that we need to make it to be diverse. They should even research for chief magistrates. research in specialized courts and all those other things. And they should also be given non-practicing allowance, unlike what it is today where they pay for their PC, they are not practicing, they don't get a non-practicing allowance. And more importantly, we probably need to reconsider this issue of contract, because if you give them a 3-year contract, which may not be renewed, then I think it puts them in jeopardy. We probably need to engage the Judicial Service Commission on contracts that are at least renewable for 2 terms. Thank you.
Thank you. Mr. Teuri.
I think the issue with legal researchers is the lack of a clear career progression plan in terms of the work that they undertake, and the fact that it is almost impossible to establish for them a proper performance evaluation matrix within which they can be able to score their performance with a view to personal career development. So one of the things that we need to do, and which is something that we've been pursuing, is to look at the question of mentorship. We have approached the judiciary in this aspect, and what we were asking them is, what happens when judges retire? Where do they go to? Because we hardly use them, and they have a wealth of experience, and we were just informed that they have formed an association. So I intend to engage them, not just to mentor the advocates, because there is an aspect to which they can mentor the advocates, but there is an old culture in the judiciary where older judges used to mentor the younger judges and show them the tricks and help them to progress career-wise. That we need now to extend that type of mentorship from the retired judges to these legal researchers so that they can be able to grow. The challenge has always been that when a researcher is allocated to a judge, sometimes those judges have also certain personal attributes that they may like a researcher so much that they do not want to release them, because there is a certain way in which they like their brief being prepared. And so they feel like if the researcher leaves and moves to another station, then they will have to start training the other researcher in the ways in which the judge likes things to be done. So those are concerns within the institution that ought to be addressed, with a view of coming up with a very clear policy in terms of how then you allow these researchers to gain the necessary experience and exposure to be able to progress career-wise.
Thank you. Finally, Madam Caroline.
Thank you. Of course, the judiciary provides an environment, an opportunity to our members who join as researchers. And I know one of the reasons why our goal should be to engage JSC so that the Act is amended to start, that Section 7 of the JSC Act is amended to start them on perhaps even a 2-year or a 3-year. It is quite impossible to reshuffle a researcher to 3 or so divisions of perhaps the High Court within 1 year. That would mean that by the time a matter is heard and the research on the on the judgment or on the ruling, then they will have done nothing if they are to be rotated within the departments. Because how long does a case take? Perhaps maybe in this 1 year, they only handle one matter because of the nature of the judiciary, the way they handle the matters. So we may need to start a conversation with the JSC on this provision of 1 year. As the Law Society, these are our members out here. One of the reasons why I established this sexual harassment and anti-bullying policies because a judicial researcher reached out to me and told me that she'd been sexually harassed by a judge. And the judiciary does not have a sexual harassment and anti-bullying policy. I engaged them, members of the bench, on this issue, and it was taken up that they're not trying to come up with one. So we need to create a secure and safe working environment as the Law Society. These are our members, and I'm on record having done that because a researcher had reached out to me. So because they are also our members, we need to reach out to them, we need to find out the challenges and address them as the Law Society. Thank you.
Thank you so much.
Thank you very much, colleagues. We are nearing the end of our debate tonight. It was afternoon, now it is night. We have picked a lot of things from what we've discussed. I think it would not be proper for us to end the debate without giving one or two of our members a chance to ask a question. I think the chair of West Kenya branch is saying one. I am seeing one hand up. I'm seeing a second hand up. It's a nice balance. Male, female. I don't think we need to interfere with that setup. It's just fallen so nicely the way I wanted. I will, yes. You will introduce yourself and you will put your question across. Generally, or you want to target?
I'll make it general.
Good. Proceed.
And of course, I'll introduce myself with great pleasure because I am a candidate.
You are a candidate.
My name is Harriet Joaquin Boshe. Thank you very much, moderator. I am a candidate. I'm vying for the position of LSK Nairobi representative. Thank you very much to the presidential candidates for the conversation. There is, we all know that of the issues perhaps that we've been going through as a society. And my question would be, what plans do you have to make sure, and of course all of us, God willing, when we're elected, we should work with you to do it, but what is your plan with respect to facilitating cohesion within the law society? Thank you very much. I hope as you're taking down the notes, you're also writing down my name to vote for me for Nairobi representative.
I think for the sake of time, Parents Council, all the best. We'll allow Mr. Nyamoya to ask his question so that when you answer both questions together. Thank you.
Thank you. Now, I have just
introduced yourself.
My name is Nyamoya, and that remains my name. I have three concerns. One concern goes to Leuri, Kamende, Metich, and Ben. Ladies and gentlemen, you have served LSK in different capacities, either at branch levels, as council members, or leaders generally. Now, my question is, during your time of service, that's when LSK had a problem, a very big major problem. Don't you think, on a moral ground, you needed to take a break so that at least you sit back and reflect before you can come back in the future days? I know your intentions could be well-meaning, but from where we sit as members, sometimes your insistence on your quests breeds suspicion. Because the membership is also growing. Young people like Mpule and the rest would want to become council members. but your continued quest for leadership makes you careerly LSK leaders. That's not good for our growth. Don't you think on moral grounding? You need to give leeway, space for these young people here. That's my first concern to the four of you. The second concern is everybody's talking about mentorship of young lawyers. Mentorship of young lawyers. But there is a crisis that we have today on senior lawyers. We have a problem that they are not, some of the senior lawyers cannot mentor young lawyers, even by their own standing in society. What do you do to them? Don't you think you need to come up with a program of mentoring senior lawyers? The reason, that's a very serious issue. The reason why I'm raising that concern, I have made observations that after a 10-year of practice, if you have firmly gotten your ground, you can do very well. But if you miss a step, you can be miserable. And you see senior lawyers are the mirror of the LSK. If a young lawyer makes a mistake, we don't look at it. But if a senior lawyer makes a mistake of misery, depression, then that is the mirror the society looks at. That's why we cannot talk about students in school of law failing when our senior lawyers are failing. The mirror is bad. Don't you think on the welfare account you need to have a committee on mentorship, continued mentorship of senior lawyers? Some senior lawyers cannot even buy you tea. They can't even give you a good lift. That is a concern. And that comes when a senior lawyer gets a problem. That's when now you see there is no mentorship here. You need a young lawyer to mentor that person. Finally, but I don't look at me like, I'm not talking about you. You're a good man. I don't know how to hide, so I just shoot straight. The last issue. Yes, there was an amendment of the Act to allow young lawyers to open their firms, even day 2 of their admission. But the practice, you can attest to it, is not easy. The kind of practice we are witnessing is one which not only requires some structures by LSK itself to certify how those young lawyers can open their firms. Mistakes which are made because of lack of experience are getting into clients and the general public. So that a young lawyer who's paying rent in his house is also paying rent in town, and when he's not capable, he's taking briefs under tree. And that's a lawyer, you know. Somebody in the street is looking at him. So don't you think, Mr. Mas, like during our time, there need to come a structure where at least, yes, they are allowed, but they can be, there's a structure through which they can do it. Opening a law firm is not just like opening a matoke kiosk. It is different. And finally, members of now, the ones who want to buy. I've heard you talk about judiciary, law society. Judiciary, law society. You are not telling us what you're going to do with parliament, with the executive. Remember all these problems David are talking about. We are able to work with parastatals. Come from the executive and parliament. All these problems, the lawyers are not being paid. They are paying bills from county governments. Are coming from the executive. Tell us, which structure and theory do you have to ensure that when we elect you today or once, and the rest, you are able to want and log that thing? Who do you know? You are not going to vote people who cannot even have a platform where you can stand and do things. Move. Lawyers are dying because they are owed by government. Get it? People are owed. They are not being paid. And you are smiling here. Can you tell us who you know? In the exam. Okay. Finally, this last audit. You need to tell us how worthy you are, so that we can follow you and know whether you have stolen from us.
Those are 5. Were there 5 or 6 questions?
Brief consent.
Okay. I'm sure you these learned friends know how to deal with numerous questions. You can find a way of answering Ms. Nyamoya's concerns in the way we teach in the interest of time and of by my colleague, who is running for Nairobi Rep. I will start with Mr. Teuri. You wamesema ung'atuke. Kutoroka cheo. So you can, and the rest of you, thank you.
The question of cohesion is, of course, topmost concern, especially given the history of where we are coming from. But the way to address it is in the manner in which, as the president and as the vision bearer, you lobby your team to achieve what I would call the unity of purpose by listening to them, being a consensus builder. And I have done this. In my council, we have never voted. We have arrived at most of our decisions by consensus, and I intend to pursue that path because it has proven and it has worked and it has enabled us to achieve the results that we have achieved, even though we have been operating in extremely difficult circumstances. In terms of what the questions which my friend Mr. Nyamoya posed, I think having the experience to run and manage the affairs of a society can never be seen as a bad thing for anyone seeking a leadership position. That to say you have an impressive record of leadership, but because you have been there for quite some time, we probably would want to try someone with no such record, and then would be to turn logic on its head. So I think the consideration should be, in terms of the challenges that we are facing right now, who then possesses the relevant experience and has demonstrated the know-how in terms of handling the challenges that we face in a manner that will bring honor and respect to our society. And I think that is the question that the membership would be answering on the 10th of March. As for structures for collaboration, I have said and I want to say it again, we will develop the internal legislative drafting capacity so that for every bill that Parliament does, there is intervention from the law society. Whenever you want to achieve anything, there must be a value addition to a process. The law society will give value addition. We have, as a branch, managed to get different stakeholders. We are able to intervene when, for the Kenya Bankers Circle, Kenya Bankers Association, because we have a memorandum of understanding with them. We are able to intervene on matters relating to taxation with KEPSA because we have a working relationship with them. And the more we build value and integrity in the relationships that we have with the different stakeholders, the more as a law society we are respected, and it increases our lobbying and bargaining power to be able to intervene whenever the matters of concern are raised on touching on the mandate of the law society. Finally, I think I agree with you that there is a growing divide between the senior members of the profession and the profession itself, and there is a need to bring them back to the fold and to start that engagement whereby we can harness the experiences that they have had, and where they go wrong, then you have mechanisms for peer review, because it is easier for Mr. Atieno here to talk to another senior whom perhaps they went to school together with than it is for Mr. Deuri to speak to somebody who is about 25 years, because there are certain experience gaps that I possess that I cannot bridge to be able to talk to that person. So there is a need to have a formalized structure where the senior members of the society are able to interact with each other by way of peer review and just deal with any challenges that come up. For the other lawyers, I think, who are opening up law firms, there should be more support from the chapters and from the national practical trainings. And these are one of the things which we intend to use CPD for purposes of teaching you how to manage a law firm, business development, how to source for clients, because those are the skills, the human resource management aspect of it. And we can easily do this by partnering with the Institute of Human Resource. Just do a collaboration agreement. Partner with the ISPAC, do a collaboration agreement. When we need training, they give us training. When they need training, they come to us, we look for members, we give them training. Through those kind of initiatives, building support, building stronger partnership with other professional organizations, we can be able to impart to the younger lawyers the skills they need to manage, not just their firms professionally, but also to be able to have a proper work-life balance.
Thank you very much, Mr. Theory. Mr. Ombati, let's try to manage time here.
Yes. On the issue of the question that was asked by Mr. Mboshe, how do we plan to facilitate cohesion? I think most of these issues can be dealt by common sense. Common sense in the sense that you reach out to the members of council, you talk to them before an issue is put to the vote, you build consensus, and immediately we are elected, we have an induction training and also a leadership conference between council and the entire leadership of the Law Society, from the branches to the chapters. And in this way, we get to know each other as people and also find a formula to work. On the issues that were asked by Mr. Nimwea, I'll summarize them. It's a good idea actually about mentorship of senior lawyers. I've never thought about it. I've always thought that it is the young lawyers who need mentorship. And I'm glad that, and part of this debate is to get new ideas, and I'm open to that. I listen, and I'll do a bit more research and talk to a few seniors and see what they would propose in terms of mentorship for senior lawyers. On amendment to allow young lawyers to practice so that it's returned to the previous 2 years, I don't think that will resolve the problem. The issue is to train them properly, and as they already said, you have a way of training them, of mentoring them, and of doing CPDs on practice areas, on how to run a law firm, and on such issues. Just about our net worth, I think I have a couple of cows and I sell milk.
Thank you.
Oh, sorry about that, sorry. I think Mr. Bati used what they call common sense. Thank you, you can proceed, Carol.
Thank you. To the question by Harriet on the plans, we have to make sure that there's cohesion within the law society. One of the reasons why Regulation 20 was couched in mandatory terms, that the decisions of council first must be built on consensus. I think it was to heal or to deal with that issue. So as president, I would first ensure that I build consensus within the board in decision making. If there is no consensus, then I will embrace diversity, allow the majority take the day. But as I've said before, as the president, it will be my duty to advise the council members on the legalities or otherwise of the decisions. Whether more members stick to one side, they ought to make legal and valid decisions on behalf of the law society. Another thing that I have said is to revisit and renew the branch visits. I think that way when we go around in the branches and the chapters. We also try to build cohesion. I think this time around it is important to do that because the audit issue, I must say, broke the society in the middle. So I would ensure that as the council, our first duty is to go around and assure members that all is well. But again, amongst all the other issues that I would want to do is to guard washing dirty linen in public. What lowered our standards or also exposed this was people went to social media just to wash the dirty linen. And the first thing I would also want to do is to ensure that council members sign the charter, the council charter that ensures that members do not go out and communicate decisions outside the ones that the president should communicate. We had not done this, and everybody was a communicator of any decision. Depending on what side they were in, they took it as their duty to just communicate what they wanted. I think the channels of communication should be streamlined so that we don't have communication even to our own members coming from east, west, and center. On the question, I don't know whether it was a question or a concern by Senior Nyamoya on why there is suspicion why we are vying. First, I think experience, as Mr. Deuri has put it, is a key issue. And then again, I think this call for papers is to all the members. Those papers are calling for members to express interest to serve the society. We're not narrowed down to 4 of us. I think every member it was a discretionary decision, and I, as Caroline Kamende, felt that I have served the society in 2 different levels, and that it was my time now to serve at the helm. I think it would be unfair to say that this breeds suspicion because we look like perennial candidates. I think the floor was open to everyone, and having gigged myself, I feel that I have the experience and I have the scorecard and manifesto to serve the society. On the issue of mentoring senior lawyers, I think the colloquial meaning of the word mentoring is from high to low, but I think as seniors, we can ensure that the SOPEC and our disciplinary measures and structures are well implemented so that we can also mentor by commission or omission. But what I would propose on that front is that we have activities, engagement activities between the members so that senior can also mentor another senior. But I think that is something you've thrown to us. As Omanza said, I have never thought about it. It's very hard for me to tap senior and say, I want to mentor you or on this issue. I will look like the lost sheep. But I think having engagement forums where all and sundry, because I think upon admission, we all start from the same footage and we are all advocates. We can mentor each other rather than creating cadres of mentorship. I think that could also split the society. But if you have any idea that how I can do it on my 16 years or 17 years of experience, then I can be able to do that. On the law firms opening on the first day of admission or thereabout, I think we need to be practical. This is because majority of us do not retain our associates. There's unemployment. I will tell you, my phone is full of requests for employment opportunities. Where do we want these lawyers to go if we start now putting this barrier of 2 years of experience? We ourselves do not lead by example. We're not telling them, come, I employ you. We throw them out there. I will tell you on 6th and 5th of March 2020, we admitted 834 advocates. 1 week after that, COVID struck. That is why I came up with the care packages. Because because those advocates are there with me in their forums. And every day I had a request for 100 shillings, 200 shillings. My boss released me. We also need to think about unforeseen activities or unforeseen emergencies or unforeseen other issues. Because even those who were in employment in 2020, when COVID struck, most of them were released and relieved of their duties. Where do we want them to go unless we create employment for them? So I think it would be unfair to revisit this provision to bar members from practicing. Allow me to say on structures, I think it is good that we keep the parliament and the executive on checks. That is part of my manifesto. On lifestyle audit, I think I'm a fairly senior advocate and I run a good practice.
Thank you.
Thank you.
Thank you. Arab Letich, we allowed Caroline to take a bit more time. She's a lady, so we have to be, she must be treated differently. So you will not enjoy the same privilege. So please, you have a minute to respond to what has been asked.
Thank you very much, Oma. I must say very quickly that the issue of cohesion of the society is very fundamental. As we talk today, the Okoa LSK has already endorsed Mr. Nyabena and Mr. Theuri, whereas the Brave New Bar has endorsed Mr. Mwanza and Messrs. The only person who has not been endorsed is myself, and I will be requesting you to kindly endorse me. Once I am elected as a president, I would want to bring on board the Okoa LSK. I want to have truth, justice, and reconciliation for 2 days. We talk about the age limit must fall, the Brave New Bar, address the accountability issues, bring Dr. Haminwa, whose microphone was snatched in 2016. We ask him for forgiveness, and also bring all the young lawyers and tell them that in the fullness of time, they shall also be prosperous. Let us be one society. Let us be very democratic. Let us allow the majority to have their way whenever we can't have a consensus. We also need to take this down to the branches. We have branches where chapters are saying, branch chairpersons are not giving us money. We need to discuss these things at the branch level so that chapters are also happy, and we have one society that is moving forward. And then finally on cohesion, ensure courts are functioning, lands offices are opened, registrar of companies is functioning so that young lawyers can work and be able to get monies in their pockets and be liquid and solvent so that they are not forced to take lectures from anybody within the profession. Nyamwea, my schoolmate, I am the most experienced. 4 years in council, 5 years at the branch. I served at the branch level as chair as an associate. I have the firepower more than any of my colleagues here to bring in the necessary longest experience, youthfulness. It is a double blessing. The youngest, the most experienced. I will be able now to unite Okoa, unite the Brave New Bar, and move all of us, the young and the junior, into a prosperous law society. Mentorship, I agree with Mr. Nyamwea that there is something that needs to be done here. I knew of a senior advocate who could not give anybody a lift in Naivasha because he was rushing somewhere when he was requested to take somebody to Nakuru. But you get another lift from somebody and you find him somewhere at Kikopei chewing 1 kilogram of toasters alone in a corner. On amendment of the Act, we probably need to take advantage of the CPD Directorate, convert it into an institute so that we reach out to young practitioners. We should not go back to the provision which was amended. Let practitioners continue, but let us reach them more often. Parliament and Executive, whom do I know? I am a very bold person, Mr. Nyamwea. I can reach out to any office. I am diplomatic at the first instance, but I'm very bold when necessary and combative when pushed to the extreme. I would deploy all those skills. What is my worth? I am a small-scale tea farmer here in Kericho. Additionally, I am a fairly successful practitioner. My partner is Gordon Fred Odhiambo Bola, who comes from Migori, who is also a fairly successful practitioner. But I am not a rich man, but I am able to buy tea anytime I meet young practitioners like Ativa here. He's benefited from my generosity. Several people have gotten a packet of tea leaves for myself. You can raise your hand. Yes, and you do not need to vote for me because you got a packet of tea leaves.
Thank you. Finally, the questions, Mr. Elder Nyabena.
Thank you very much on the question by Harriet on cohesion. One, I come from Mombasa Law Society, 111 years. You've never had Mombasa Law Society any issues or differences. In my 20 years, I've lived in Mombasa. I know how we do it. That is what I want to bring here. What do? We ensure once a leader leaves office, you must respect them. At least if for nothing, just respect us for sitting here. For I think this must be the third or fourth hour to listen to this. And after any one of us wins, just respect us for offering our 2 years to serve you. If we do that, and this is what I propose, I will, upon election, write a letter to former leaders of the Law Society, trying to bring them together. You see, if you give me leadership for 2 years, it's like giving me an opportunity to take care of a baby. I should have a right to know how the baby is doing. In terms of unity, I led the caucus. Let me tell you now that there were interest in that caucus. There are many times I had to step back for this caucus to remain what it is. If I had engaged further, possibly Judge Mrima could have nobody else to give that caucus. As a mark of my sacrifice, I let go the presidency. Some people say, Nyabena, you should have been president for 1 year. Possibly this could not be there. But as a Christian, I know at times it's good to sacrifice and see your friend, even your foe, as better than yourself. That is what I bring to the Law Society of Kenya, and that is the opportunity. I know I'm the symbol of unity. I've been told about the issue of giving away to leadership. I look at my brother Eric, who has served in council, National Council before. Look at his record at National Council. If he served very well, take him back. If there are issues, don't take him back. I look at my brother Manza. He's a new person without experience. Let me tell you this. When I was appointed Chairman Law Society of Kenya, Mombasa, it took me about 1 year to be able even to talk to Chief Justice. People needed to trust you. I've dealt with the Chief Justice, I've dealt with the Attorney General, I've dealt with the Solicitor General. If you want a president who will work on day one, I think that answers the issue of who do I know. I know all these people because I've worked for 4 years. They respect me, we respect each other. We worked well with Chief Justice Baraga. And we were the only branch, just imagine. We were the only branch. LSK didn't appreciate Maraga for what he did. We felt we should appreciate him. Let me tell you, when I spoke to Alan, even when Alan finished, he says we are the only branch that gave him a gift. It was actually a soapstone bowl, which was embroidered with MLS. When I gave that gift, people asked me, Nyabena, why have you given Alan, who doesn't speak against government, this gift on behalf of Mombasa Law Society? I told them, Alan has served us. I respect leaders and will continue to respect leaders. I've been asked a question about mentorship of senior lawyers. You can't mentor senior lawyers, let me tell you. You can't. But there's something we did, Jacqueline will witness. In March 2020, we did this. We created what we call a senior lawyers appreciation month. You know, you have to turn around and change it. I think this time has not been given sufficiently. Allow me to finish. We turned it around and appreciated those senior lawyers. Once I assumed national office, my 4 friends have no idea what to do. I'll start a senior lawyers appreciation month within the Law Society of Kenya. Open their farms on day 2. If you have no employment, what do? You allow them to open farms. So senior lawyers, it's our duty to support young lawyers. Call them to our offices, give them the briefs, give them the support that they deserve. Parliament and the executive have talked about diplomacy. I'm a diplomat. I will engage and be able to solve these things. On the issue of welfare, I've had my sister Caroline Kamende say how she has supported young lawyers. I've done something sustainable in Mombasa Law Society. We have the Mombasa Advocate Welfare Association, whose chairman is a former chairman of Mombasa Law Society. In Mombasa Law Society, we do not do the contributions that she does. What we do in terms of funeral, we have insurance cover. For 80,400 shillings, somebody is able to get, if they are bereaved, to about 300 and 500,000 shillings. So in Mombasa Law Society, you will not come to our wall and see contributions. Because to me, I look at it as tokenism and something that is unsustainable. So Carol will be able to sit down if you are elected, so that I share this idea that we can have a sustainable system without tokenism, which translates then to treating these young lawyers as voting machines and as a system of controlling them. Finally, my net worth. God is good all the time. I have a loving mother, Priscilla Mumina. I have a dear wife, Telly Wari. I'm blessed with 3 girls. I love women, and I always do anything to protect them when I can. And I have 1 son. That is all that I own. The rest is vanity, but that family is what I count. Whatever God has blessed me with will come and go, but I keep my family in my heart. I keep you colleagues in my heart, and I'll carry you in my heart once I'm elected as president. Thank you.
Thank you very much. I think we are coming to the end of this debate, and we have decided to eliminate the crossfire session because of time. And I think that initially my plan had been to give everybody a chance to have a parting shot with the members present tonight. But I think some of us have already given what looks like a parting shot. So if I was to do that, I would not allow you any more than 15 seconds, and the timekeeper will be very, very strict on that. Before I do that, and as you give your parting shot, just 15 seconds, as the persons managing the debate, you know, in 2020, when the outgoing council had a debate like this, one of the questions that we put to them, and we put it to you tonight, so you say together with your parting remarks, you just need to make one statement on it, is whether you belong to or you have any political affiliation that might affect the discharge of the responsibilities as president if you're elected. I know it's a question that you can simply say, no, I will not be affiliated to any political class, or I am not using this position as a stepping stone to political office. But we have seen that some of the people we elected may have been doing or may have taken office because their eyes set on other things. Okay, so I don't want to point fingers, but I know that can sometimes be an issue with an office such as that of president of the society, because there's going to be a lot of influence from other people, from government, from politicians, from senior lawyers who are being used by other people. So we need that guarantee. And remember, I had a chance to go through something called the Advocates Code of Conduct. I think it was promulgated by Isaac Okero's team. I had to go through it because I wanted to refer somebody to the disciplinary committee. And it is so expansive and so extensive that if you sit here, Mr. Nyabena, and you lie to us that you will not do this, then you go in tomorrow and do the opposite, it is a professional misconduct offense, I can tell you. If you mislead your colleague, you turn into another animal. I can ask Dr. Acacia
to file a complaint against you because you stood in front of your peers and told them a lie. So you have only 15 seconds to, we already know what you stand for, we have read your manifesto, so you don't need much time, but we want that guarantee that you will not walk into this high office and then start, and allow yourself to be patronized by politicians or use the position for purposes other than the ones for which we elected you. Mr. Nyabena, you will go first. And timekeeper, please.
Is there a closing remark or that is it?
Closing, I think you gave your closing remarks. What sounded like your closing remarks, so you don't need to say it.
Let me use my 15 minutes to say that I'll declare a free CPD on election to discuss LSK. I'll ensure you have a customer relationship officer within LSK. You should not call and your calls are not answered. Delivered to your doorstep. Nyabena is apolitical. I believe in God. God is good all.
Thank you very much. Ngetich Kipkoech Bernard contested to be a member of parliament for Bureti 2013-2017. They didn't make me a member of parliament. I will not be contesting in 2022. At the moment, I'm politically non-aligned, but I understand the political terrain in this country more than any of these candidates, and nothing speaks clearly to this than what I've already told you. I've been contested twice in Bureti. As a branch chairperson, as an up-country rep for 4 years, it has been extremely clear that I am non-aligned politically, save that I come out strongly on the rule of law and constitutionalism. Elect Kipkoech for sobriety of the Law Society of Kenya, join me to rebuild the Law Society of Kenya, rally behind the youngest, the most experienced, the most robust, and bold candidate, Ngetich Kipkoech Bernard. Thank you.
Thank you, Mr. Kipkoech. Yes, Caroline?
Thank you. I am not aligned to any political party. I have not made and I will not make any decision pursuant to any alignment to a political party. I undertake to serve equally all our members, our profession, representative of the legal profession. I stand for accountability and responsiveness. I have been tried, tested, and proven. Please put me into office as the president. Thank you.
Thank you. Mr. Martin?
Thank you. The total experience of these colleagues of mine, my competitors, is 25 years. If you put cumulatively, they have served the Law Society for 25 years. And in the 2 years that they propose to serve you, they do not offer any new solution. They've had their time, and I request that you retire all of them and give me a mandate, because I present fresh ideas and I have a better vision and clear plan for a strong, united bar. Thank you very much.
Thank you, Mr. Martin. Finally, Mr. Deuri.
Thank you, ladies and gentlemen. Thank you for staying with us for the entire duration of this debate. We appreciate you. I ask for your support come the 10th of March. And for me, I am politically non-aligned. My legacy as a president is extremely important to me, and it will be tainted if I engage in political considerations.
Thank you very much, Mr. Deuri. I think we have had, it's been a long, long day. It's a statement of the type of issues that we wanted to discuss with our candidates here. I was very, very impressed or amused when my brothers and sister here were asked to disclose their net worth. And Mr. Mbati says he just owns a few cows and sells milk. You know, even Brookside just sells milk. So it's not to say that he's a pauper. Thank you very much. I think let us clap for ourselves and to the Asanteni sana for creating time to attend this debate. I will now return the microphone to the office. I am not in this office. We mentored and now we're waiting to be mentored. so much.
Thank you very much, our moderators and our candidates and everyone else. I'm not going to say any other thing. I think we've learned a lot from our candidates. Allow me to welcome the Debate-Kisumu chapter chair, Ms. Neto, to give a vote of thanks and the final prayer. Remember to pray for those of us that are leaving Kisumu like right away, traveling to far away places like Mombasa and Nairobi, Bungoma, Kisumu, Busia. Thank you. Karibu. I'm not saying you go away.
Wow, it's been a minute, huh? We want to say thank you very much to everyone. For the contestants, we are grateful and thankful to God that you have strength, because I know that you have traversed this country. We continue to pray for strength even as you do your last lap. Thank you very much for honoring this call. We are indeed grateful. You are all smart in your own ways. And someone said, yeah, because again, no soldier goes into, what do you call it? No soldier goes into battle, yeah, with a condition that he or she will not be killed, you know? Yeah, you are all here, you got into this hoping and trusting God that you are going to win, but the challenge is that LSK presidential, the position for LSK president is only one. So that means only one person will get it. But we encourage everyone, in the event that you don't get it, remember that you're a winner, because you had the courage to do this when all of us did not have. So be encouraged. Yeah, it is very important. So I want to thank the moderators. You've done well. It's been a long day. Thank you, Senior. Thank you, the beautiful lady, as the branch here calls her. Thank you, Maureen. You have done well. Thank you for your support. Thank you, members, for being here until late. We are grateful for your support. Thank you, because it is encouraging to the candidates, not contestants, the candidates, that you are here, you have stayed up until late. So I don't want to talk too much. I just want us to all rise up and pray. Father, we are grateful to you. Thank you for your faithfulness. Thank you for your love and grace. Above all, we thank you for the gift of life. Thank you for the opportunity to gather and to be here, King of Kings, and to deliberate on issues concerning the welfare and issues affecting us as lawyers. First and foremost, Father, I want to lift the candidates before you. You have given them strength. They have hope, each and every one of them. But I thank you because the Bible says that you have plans for each and every one of us. We want to pray for all of them, God. As we go into the elections, you have the person you have endorsed. But them that will not make it, we also want to pray that you will encourage their hearts, because we know there's a reason and a purpose to which you have called them. And we know that there's a reason why, Father, they got into this race. May that purpose be fulfilled. It may not be for the purposes of being the president of LSK, but it may be for the purpose, your own purpose, to give them a higher office. We want to commit them before you. Thank you for their families and the support that they have received. We want to pray for journey mercies as we go back home, for all, each and every one of us. Those who have traveled from outside Kisumu, we commit them into your able hands, that you will be with them, go back well with them, Jehovah. We thank you for each and every one of us. As we go back home, dismiss us with your peace, give us journey mercies, and all will be to the glory and honor of your name. It is through Jesus Christ our Lord how we pray and believe. Amen.
Thank you.
Thank you very much.
A photo session. All the best. Thank you.